SIR matter, now my list has gone up to the September. Every Friday I'm taking a 30-40 matters. Even I am fixing it has now gone up to the September.
But if it so commences to your lordship.
What is the urgency?
Well, the urgency is, my lord, the municipal, the name has been deleted. So what is the urgency is, my lord? It is regard to, my lord, Islampur. In the municipal elections will be on in any moment, my lord. There is no board now. Since we have also lost our right of voting in the General Assembly. Now we will lose my right in the municipal elections also. This is the urgency, my lord. Nothing more.
You listen.
My lord.
Friday.
Great.
Friday SIR matter.
Great.
Appear for extension of entry model. Entry model is expiring on Friday. Now, could it appear tomorrow or
Friday?
Entry model is still Friday. Not tomorrow or day after tomorrow.
Day after tomorrow to be mentioned extension of appellate side.
Appellate.
Here I am one child member, and no confidence motion was issued. Video is prevented me to cast the vote, my lord. I am a Panchayat member, no confidence motion is issued, my lord. I have to cast vote, my lord. But video is prevented as because my name is deleted. I have filed an appeal.
Your name is deleted?
My name is deleted. I preferred an appeal. So I will only, my lord, SIR matter, my lord, kindly, my lord, urgency is that no vote is very soon, my lord.
Give.
Lordship, upon compelling circumstances, I was here before your Lordship to take leave, my Lord. Lordship has asked me to file it and then come back. My Lord, this is relating to the chain of restaurant whose main business account has been frozen. My Lord, now they are facing a financial difficulty for transaction and all, my Lord. My Lord, on 20th of this month, my Lord, last month, my Lord, they found difficulty in transaction, and then when they inquired the bank, they said technical glitch. After that, after a few days, when it was not
because see, this freezing matter, there are so many matters are there. How it can be?
Lord, it's
Give the list to them.
My lord, may I be
much obliged, my Lord.
My lord, I'm praying for inclusion of this matter, my lord.
Come tomorrow. Tomorrow, Thursday. Only today I am taking any urgency. What come tomorrow, all mentioning I will take.
We cannot
My
wait
lord.
for a day, Lord.
Why?
You would kindly see, Lord, this letter. The matter is pending before your lordship, Lord. The item number, Lord. Remember? It is item number for upgradation, Lord. Your lordship, what has happened, Lord? I have initiated challenge order passed under section 123 of the RBI. So this is basically an order of Lord. I approached this honorable court. The honorable court, Lord, rightly held, Lord, that it is not maintainable. You go to the RBI.
Correct.
RBI tribunal is not found. So by this time, this has been, and there is a liberty granted.
Tribunal is not there.
No, it's not functioning. There are RTIs which I have annexed, Lord, to the writ petition as well. But your lordship would kindly take it up, Lord, tomorrow. I have intimated them that, Lord, I have served them a notice of mentioning. And I have also communicated that I'll be mentioning this matter today before your lordship. So your lordship would kindly.
Where is the number?
This is it.
Eta kaaj karun kal ke within 10 minutes kar do. But you issue the notice.
I shall.
Who is appearing for the Union of India?
I shall. Tomorrow.
Not urgency.
Lordship, one matter with to PMLA Act, your Lordship was pleased to fix it on 26th. Lordship, thereafter it was declared as a holiday. Your Lordship will recall Section 8(7) application. Your Lordship was of the view probably a criminal revision should lie rather than from the special court's order rather than a writ petition. It was fixed on 26th. Because it was declared a holiday, your Lordship, it not came up. Any day convenient, your Lordship.
My lord, with your lordship.
Huh? You find from there is a date already. It's 26th. The matter which has not been listed. Contact me, court officer. He will give.
Very well, Lordship. The only urgency is the liquidator may dissipate with the assets.
Not today mentioning.
Lordship, let's millet for withdrawal, millet. For withdrawal.
It listed.
It's not listed, millet.
Tomorrow to be mentioned for withdrawal.
Lordship, I am seeking lordship kind leave to mention one matter for granting leave, your lordship.
What is the urgency?
My lord, the petitioner's salary account has been frozen, your lordship. Lordship.
Nothing.
My lord, item number, my lord, all his accounts have been frozen.
File it. First you file it.
My lord, item number 17 of the 117 of the monthly list, my lord. The particular card was sold and, my lord, the registered and it's a defective card, my lord. There is a question of.
Go to the Consumers Forum.
My lord, there is a question.
Why the read?
my lord, consumer forum, that is unit 2, that is within the jurisdiction, my lord, that is not running, my lord. That is the reason, my lord, the writ has been filed.
Consumer forum is not running writ petition.
Yes, my lord.
Good.
Yes, my lord. Unit number 2 is not running, my lord. Where I have the jurisdiction.
Which district?
It is still there, unit 2.
Which district?
That is in the North Chabish, the Karwa.
I will inquire then.
Yes, your lordship. Unit number 2 is not currently not functioning, my lord.
So what is the urgency?
Urgency is, my lord, the particular petitioner cannot run the car, my lord, and it's an accidental, my lord. And
so what the interim order can be passed by this
my lord,
court?
interim order is to, my lord, that at least, my lord, RI is required to look after the car whether there is a manufacturing defect or not, my lord. That is the only direction to be made upon the RI and let them check the car.
How it can be unless the other party will come and with the consent, how the court can
Yes, my lord, I have already served the notice and everything has been complied with, my lord.
ठीक है उसको रख दो 2 दिन बाद रख take and fix on next Monday Tuesday रख दो 7 तारीख को हाँ 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 no urgency yes call the list item number हाँ क्या वो है 1 2 3 अरे कॉल तो करो पिटिशनर्स नहीं है
Petition is there in person.
which one okay जब लिस्ट किया तो करो court will decide you cannot decide list the matter list the matter the court is sitting you call the matter what impression will go to the bar out of 10 basis the court is calling the matter yes which department हाँ ED हाँ
আমি স্যার বলতে পারবো না আমি একজন লয়ার একটু আপনাকে আমরা লিভ চাইছি কি বলতে পারবো স্যার বোঝাতে পারবো
you are telling that you are appearing in person
আমাদের লয়ারের হাত দিয়ে ভেঙে গেছে সেই জন্য ইন পার্সন করে
হ্যাঁ
জমাও করে দিচ্ছি
হ্যাঁ
জমাও করে দিচ্ছি আসতে পারবেন একটু আপনাকে বুঝিয়ে দেবো এই লিভটা আপনার কাছে আমরা চাইছি
what leave
ওই
yes
may be permitted, my lord. My lord, kindly allow me 2 minutes to ventilate the grievance of the petitioners.
Who is that? Where is the respondent?
I don't know, my lord.
Don't know then?
But served the notice. I seen the already served the notice.
Notice to serve করেছি নোটিশটা স্যারকে দিয়ে দেবো নোটিশটা স্যার
Yes.
Notice to them. My lord, the petitioners, the matter is relating to the disputed sale deed of 23/4/2018. Kindly have a look, my lord, page 51, through unaccounted money. My lord, on 21/1954, the petitioner's father entered into an agreement with Debesh Bijoy Sahana, managing director of SK Sahana and Sons Limited, for sale of premises number 50 Padmapukur Road and 2 rice mills after paying 2.75 lakhs, and the due was 25,000. kindly see the agreement.
What is your relief in this writ application? What you have prayed for in the writ application? What is the prayer?
Prayer for the unaccounted money, with the sale deed made to the unaccounted money, and therefore the ED is required to investigate the matter. And uh, present position, they are trying to dispossess this senior citizen from his own property.
Who?
Respondent number 8 and 9.
So go and file a civil suit.
Already suit is clear. So I want to submit before your lordship. The suit already clear. On 14/5/1954, an indenture was made between the Satyakinkar Sahana and some private business.
Nobody is there. Though the petitioner has filed the affidavit of service, but none appears on behalf of the respondents. Affidavit of service is kept with the record. The petition is directed to inform the next date of hearing to the respondents and to file the affidavit of service. List the matter on 16th July under the same heading. Yes, next.
I'm for the respondent number 5, my
Who
lord.
is for the petitioner?
May it please your lordship, I am for the petition.
I am dismissing this petition. You have misled this court for mentioning the matter. Have you gone through the order dated 10 June 2026?
Yes, my lord.
Yes, what is the order?
My lord,
You have not appeared. Where is the mentioning list, sir? Where is the mentioning list? It has come as a mention. If it has come as a mention, I am dismissing it.
no, my lord,
Sorry, this court will not allow this practice. You are not appeared. The court has fixed an order, has an order for fixing in the monthly list. Then you mention the matter, suppressing that order.
my lord, there have been certain subsequent developments, my lord.
Preliminary objection, my lord, in regard.
I am not hearing. I am dismissing it.
No, there will-
Give the mentioning list.
My
I
lord-
see what is the urgency of mention. Whether you mentioned that the matter was fixed on 8 June.
Yes, my lord.
8th of 2026 by this order.
Yes, my lord, that has been.
So,
Can application. Can application. My lord, para 31 of the application which has been filed, a can application had been filed, my lord.
what can application?
My lord, actually,
Can is not here. What is a can?
my lord, it has been filed. My lord, the difficulty is that.
What is a can?
My lord, the issue is that a competition had been
I am
announced.
asking what is the can? What is a prayer in the can?
Yes, ma'am. My lord, so in the issue is that there has been a competition
I am
which has been
asking what
announced.
is the
Yes.
prayer in the can? You are asking the competition.
My lord, recalling of the order.
Okay, you file affidavit in opposition to the can within 2 weeks.
My lord, meanwhile,
The petitioner has filed the present application being can 1 of 2026, praying for recalling of the order dated 10th of June 2026. Full stop. Counsel for the respondent press for time to file affidavit in opposition. Let affidavit in opposition filed within 2 weeks. Reply within 1 week thereafter. Lease the matter on 2nd August. 3rd August. The petitioner, the learned counsel for the private respondent. Learned counsel for the private respondent raised the point of mentality. The same is kept open. Yes, next. Keep it there.
I'm for the respondent.
Milords, I am for the petitioner, Milords. Milords, this petition is challenging the
Prior to my largest friend comments argument, kindly pay it to last order on 6th of March. For my understanding, the lordship was kind enough to release the matter from the list. Thereafter, without any notice, all on a sudden, yesterday.
Go out of the list. Where is the mentioning list? Same again. Where is the mentioning list of this matter?
Milords, because
Sorry. This court will not allow this type of the practice when the matter is already gone out of the list.
My lords, I explain it to you, my lords. Listen to me. Give me 2 minutes, my lord. Let me explain. My lords, I mentioned the matter on in March because there was an urgency. Thereafter, matter was taken out of the list because the board was really heavy. Thereafter, I mentioned several times. There has been several mentioning lists that this matter will be taken up, my lord. Now, I'm not from here. I'm from Delhi. My local council had mentioned the matter, my lord. Then the
local council should know which time the matter is to be mentioned. At the mid of hearing of the original such matter, your advocate on record or your advocate appearing before came before this court at the mid of the hearing are asking for the mentioning.
my lord, that was in the month of March.
Yes.
My lord, I apologize on that for that, my lord. I apologize that day itself. My lord, I was not aware that the appellate side matter will be taken up.
And at the time mentioning, you mention, yes, my lord, this is the situation of the matter. That's why you're mentioning the matter. See, what is the reason mentioning list? Well, you suppress that.
My lord, there have been several mentioning. It has been mentioned several times after March, my lord.
See the mentioning list. You not mentioned that down by the order dated 6 March 2026. This court has delisted send the matter out of the list.
My lord, I apologize for this, my lord. My lord, I was not aware about it. My lord, I sincerely apologize if it was not mentioned, my lord. This matter has merits. This deals with respect to the constitutional validity of the selection process and tender process, my lord. My lord, I filed my writ petition in the month of February. March, it was listed.
Regard an order.
One thing, I believe earlier the copy was served upon the government leader. It was tried sometime in March 2023. I believe the also learned advocate will not appear. So again, he has to serve upon the.
My lord, this is the affidavit of service. We already served the copy, my lord.
When it was served?
When was it served? 16 to 2026.
After April, I have served to the public government leader's office. After April, then you don't know. You're not practicing in the Calcutta High Court. Then after the April, after the May, new set of the PP and all the things has come. Now you have, either you have to serve the copy or intimate the date. Though by an order dated 6 March 2026, the matter was
taken up, my lord.
placed out of the list.
As per
the mentioning made by the Land Council for the petitioner, the matter is listed today. Land Council appearing for the state press.
No, for the respondent number 3, successful bidder.
Land advocate appearing for the respondent number 3. You are having the copy?
Yes, I have the petition because my client has got.
None appears. Who is for the state? None appears on behalf of the state. Full list of the petitions directed to serve the fresh copy to inform the next date of hearing to the office of the Learned Government Pleader and to file a fresh affidavit of service. List the matter on 9th of July 2026 under the same heading.
So kindly indicate that what order has been issued on 9th.
Come on, I am not passing any order. I am not passing any order on merit. Yes.
My lord, can it be 10th of July?
Huh?
Can it be on 10th of July or 8th of July?
Okay, 10 July.
10 July. Great for me.
Under the same heading. Next.
Your Lordship, I am appearing for respondent number 1 and 2 in this matter, Your Lordship.
Yes.
I am appearing for the petition. Today I am filing my written affidavit in opposition as well as one supplementary affidavit, Your Lordship.
My lord,
Who is for the petitioner?
in 7 and 8, my lord, there are various insurance companies. This was with regard to the insurance claim when the father of the petitioner died in a railway accident.
Carriage of motion with me, I think. They are all respondents. Carriage of motion with me, I believe.
Yes, you are the petitioner. That's why I'm asking.
My lord, since my lord, we have not completed, my lord, some of us have not completed our affidavit in opposition. My lord, that is why before he starts.
Let. Who is appearing for the 7?
7. I am placing 7, my learned.
You are for the petitioner. How many respondents are there?
Your Lordship.
He was appearing in person, I think. So
Yes, Your Lordship. He mentioned in person. No, he appeared on last occasion. He appeared in person. All right.
Okay, who is appearing for the New India?
Yes, sir, I am appearing for New India.
And you filed the affidavit?
I am filing. They have filed
Have you received?
Yes, we have used our reply. We have also prepared a supplementary affidavit. Yesterday we have served over the email to the petitioner, Your Lordship. I'm sir.
today I'm filing the same.
My lord, for respondent number.
Just, I am coming one by one.
I am for
Take this.
1 and 2.
And 2.
Well, 2, I am for appealing item number 8.
No.
I am
Who is, 8 is different matter.
7. Item number 7. Who is appearing for the respondent number 2?
1 and 2, I am appealing.
You're-
Both are New India.
Okay. 3.
My lord, 3, my lord, I am appearing, my lord. I would be seeking, my lord, some time for filing my opposition, my lord. The reason.
3 just a minute.
4.
4 is also, my lord, the same. 3.
3 and 4. So you both are appearing.
My lord, I am for the.
Yes, Mr. He is asking for time for
But I think today we don't have anything to say before your lawsuits.
Why?
I am questioning the repudiation of my personal accident claim by the insurance company 1 and 2. I am questioning that order. They are at best right now a pro forma respondent, my lord. Not most than that.
3 and 4.
3 and 4.
Okay.
Because I supplementary. May I take your
What is
lawsuits
the
to the
reputation?
reputation? Just your lawsuits. Well, your lawsuits will get it back.
Your Lordship, before my learned senior friends start with the submission, they have not used any affidavit to my supplementary, Your Lordship.
Well, let them take it. Your Lordship, take it up. I'm on that. Now your losses will get it that repudiation claim at page number 116.
Yes.
May I place it your losses that? I have to place it in its entirety because your losses will get the entire facts on it. We refer to the claim lodged by you in your capacity as a nominee of let's say Ratan Kumar Kundu, the deceased insured, seeking accidental death benefit under 4 personal accident insurance policies issued by the New India Assurance Company Limited, each carrying a sum insured of 25 lakhs, aggregating 1 crore. The said policies were issued pursuant to digital proposal forms. Well, kindly take note of this. Submitted by the insured and were subject to terms and conditions and warranties and declarations forming part of the contract of insurance. Upon receipt of the claim intimation reporting the death of the insured in a railway accident, the company undertook a detailed examination of the claim and in accordance with the standard insurance practice appointed an independent investigator to verify the factual matrix and disclosure made at the proposal stage and compliance with the principles of utmost good faith governing the insurance contracts. The investigation was completed after extensive verification, including scrutiny of records, policy of disclosures, and information obtained from multiple sources. During the course of investigation and subsequent correspondence, it came to light that the deceased had prior to and contemporaneously with the issuance of the above-mentioned policies by this company, procured multiple personal accident and life insurance policies from various other insurers, resulting in an aggregate insurance covering running into approximately 25 crores. This fact has also been admitted by you in your communications addressed to the company, as well as the Insurance Regulatory or Development Authority of India. It is a matter of record that at the insured deliberately obtained 4 separate insurance policies online without disclosing the material information regarding of multiple policies that were obtained from other insurance companies. The omission is not minor or technical in nature, but relates to a fact that is fundamental to the assessment of risk by any prudent insurer. The existence of multiple high-level personal accident and life insurance policies is a fact of unquestionable materiality. Such information directly influences an insurer's underwriting decision, including whether to accept the risks at all, whether to restrict the sum insured, impose special conditions, and decline the proposal outright. Suppression of such information deprives the insurer of the opportunity to make an informed decision and strikes at the root of the contractual relationship. Insurance contracts are contracts of media fees, requiring complete transparency and honesty from the proposer. The duty to disclose material facts is absolute, does not depend upon whether a specific question has been asked. The insured was under a continuing obligation to disclose all material facts known to him, including the existence of other insurance policies. The failure to do so constitutes a clear breach of the duty of utmost good faith. Having regard to the magnitude of the undisclosed insurance, the proximity in time between the procurement of multiple policies and the date of the insured, and the absence of any plausible explanation for the accumulation of such extraordinary coverage, the company is constrained to conclude that non-disclosure was deliberate and fraudulent. The policies were thus obtained by misrepresentation and suppression of material facts with the intent to induce the insurer into issuing policies it would not otherwise have issued. While personal accident insurance is a benefit policy, the law does not permit the creation of artificial or excessive risk through the undisclosed over-insurance. The procurement of insurance over grossly disproportionate to the insured financial profile and reasonable needs constitutes a classic case of moral hazard. Such moral hazard fundamentally alters the risk assumed by the insurer and renders the contract commercially and legally untenable. Your repeated reliance on the fact that certain other insurers have settled their respective claims are wholly misconceived and legally untenable. Each insurance construct is independent, and each insurer is entitled to access and decide claims based on disclosures made to it and the terms governing its policy. Exactly, your lordship. Kindly take note of this. Settlement by the other insurers does not bind this company, nor does it validate a contract obtained by suppression or fraud. Whether the company does not dispute, kindly, this is very vital according to me. The company does not dispute that the death of the insured occurred due to accident. It is well settled in law that the occurrence of the insured event does not cure defect in the formation of the contract. A policy obtained by fraud, misrepresentation, or material non-disclosure does not confer any enforceable right irrespective of the cause of death. In view of the foregoing facts and circumstances, and in strict accordance with the policy conditions, statutory provisions, and established principles of insurance law, the company hereby exercises its right to treat the policies as voidable and repudiates the claim in full on account of material non-disclosure and fraudulent misrepresentation and breach of utmost good faith and creation of moral hazard. In view of what has been expounded in the foregoing paragraphs, I have to inform you that your claim lodged under the aforesaid insurance policy does not qualify for indemnification, and the same hereby stands repudiated, and in entirety no liability of the nature arises under this said policy. I think this is as much as. Therefore, your lordship, the company repudiate my claim on the basis of non-disclosure of material facts which amounting to misrepresentation and fraudulent act. I have done it, as I tell your lordships. So far, I have seen, and that there is no bar in taking multiple accident policies. The petitioner before your lordship, the father of the petitioner, was a senior technician in the cell. So there was hazardous service he was doing. So he thought fit that he has to do for his family certain amount of claim by way of taking appropriate accident policies. Now your lordships will be finding from page 120. This was done through online procedure. I am not taking to your lordships. If your lordship wants that, I can take your lordships. Each of the pages, your lordships will not find any column indicating or asking the insured person to disclose that whether he has any existing or previous insurance policies whatsoever nature. But I have not found it, and that's our averment. This is your lordships, the form by which this was disclosed. Your lordships will not find anything. Amount was taken on the same day, your lordships, by 130. Your lordships will get it. The premium was taken online. That is at page 130.
Yes.
I will stand corrected because that's my basic case. I take your lordships to some of the paragraphs and how they have dealt with in affidavit. Your lordships will kindly consider paragraphs There are four, your losses will find. I have stated in paragraph 5 that the four insurance policies under the National Insurance, New India Insurance Company Limited. Then your losses will get it at pages. ওই paragraph ওই যে যেখানে বলেছি আমরা যে কোনো কিছুই Malad, kindly see your lordships, page 13, paragraph 30. Because the whole poem, Malad, case boils down to this simple issue, this issue. Malad, paragraph 30, it is most humbly submitted that the impugned repudiation of the insurance claims by the respondent number 1 is ex facie illegal and arbitrary and without authority of law. And the sole ground cited for repudiation is alleged non-disclosure of previously obtained insurance policies by the deceased insured. Such a ground is wholly misconceived inasmuch as the proposal forms generated and hosted by the respondent insurer through its official online portal did not contain any column or query seeking disclosure of existing or prior personal accident insurance policies. In absence of such query, no duty of disclosure arose in law, and the allegation of suppression is contrary to settled principles governing the insurance contracts.
Yes. So their only contention is that
I have not disclosed.
You are not disclosed.
The second point I'm taking, lordships, this is online proposal form. Any online submission, unless there is a column,
yes, you are
that will not accept it. Similarly, your losses, if there is a column, if I do not answer to that or put a tick mark or whatever your loss is required, then this is cannot be submitted either. This cannot be submitted even either. So your losses, admittedly, according to us, Malad, there was no column. Now, Malad, your losses kindly take up their affidavit in opposition. I will just show you the losses to some of the paragraphs.
Yes.
Malad, kindly see your lordship page 4 of the affidavit in opposition, paragraph 5C. I will just, Malad, place the relevant paragraphs of their affidavit in opposition.
Yes.
I further state that the said policies were issued on the basis of the digital proposal forms. That's their case. Submitted by the insured and were governed by the terms and conditions, declaration and warranties forming part of the contract of insurance duly agreed and signed by the insured therein. Then your losses will find paragraph F at page 5. Paragraph 5, page 5, paragraph F, small f, my lord. Has you got it, your loss? I state that during investigation, it was revealed that the insured had procured multiple personal accident and life insurance policies from various insurers, aggregating to an extraordinary coverage of approximately 25 crores, which as a matter of fact was never disclosed to us and insurance company at the time of obtaining the policies, which is a major fault committed on the part of the insured while obtaining the insurance policies.
Yes.
But I make one submission if your losses will not find in the affidavit what are those conditions or terms contained in the policies, the proposal forms. Then your losses, paragraph H in the next paragraph, it is again stated that insured deliberately suppressed material facts regarding existing of insurance coverage at the proposal stage of these policies.
Yes.
Then your losses will find paragraph page 7, paragraph 10. Just last 2 lines. It is further stated the petitioner herein has annexed all those other policies issued in favor of his late father. Prima facie, this para itself confirms the presence of other insurance policies. Well, who denies it? I have never denied it. Though issued to different insurance companies. One fact you losses kindly take note of. Right now we are concerned with the 4 policies of the New India Insurance. this was done on the same day at different time. Now, my lord, I disclosed my PAN card, I disclosed my Aadhaar card, I disclosed my voter card. Now, according to me, my lord, if someone was done, first one was done at 10:30 and second one is done at 12:30, the company itself in its procedure system, portal system can know it.
Yes.
Apart from that, because I put my lord, disclose my Aadhaar card. As soon as the second policy is I disclose my Aadhaar card, it will be in the system.
Yes.
And that was your losses. I cited judgment. That was the view of the court also.
Yes.
Then your losses will get it. Malad, paragraph 15. Malad, all malad proposition of law, all that, that's good. But it based upon the application on the facts. Malad, kindly see, this is their vital paragraph. Without prejudice to the aforesaid statement, it is stated that all insurance contract or construct you be made fiddy. I accept it. Subject to there is a clause or terms or column to disclose it or query, founded upon the doctrine of utmost good faith, which imposes a strict, positive, and continuous duty upon the proposer or insured to make a full, true, and complete disclosure of all material facts within his knowledge at the time of entering into the contract. It is further stated that the doctrine is not a mere moral precept, but a substantive rule of insurance law recognized under common law, codified by principles of contract, and consistently affirmed by Indian courts. The rationale is that the insurers assess risk, decides whether to accept the proposal on what terms and what premium, solely on the basis of disclosures made by the proposer, who is in exclusive possession of facts material to the risk. It is a settled proposition of law. The duty of disclosure does not depend upon the insurer. Malad, kindly take note of eliciting information through the specific question in the proposal form. Malad, therefore, their case is that even there is no query or column, I have to disclose it. But how could I disclose it?
Yes.
In the online form, proposal form, unless you keep a query? The obligation of disclosure is active and not passive. The insured cannot take shelter behind omissions in the proposal forms. Kindly see your losses.
Yes.
They're accepting that there was no column.
Yes.
Contained and since a particular fact was specifically, there was no obligation to disclose it. The law mandates that all material facts, whether or not specifically inquired into, must be voluntarily disclosed. But I'm putting a question to myself. In an online proposal form, unless you keep a column or ask me something specifically, how could I deal with it?
Okay.
So this is the case your lawsuits will find. Now your lawsuits, reply your lawsuits, I have said it. The same thing of you, obviously, that I don't think your lawsuit, I should go into the reply. Now, I cite two judgments, then I will deal with their supplementary affidavit. No. This is online, and you take note of this. Monmohan Nanda versus United Insurance Company Limited. Monmohan Nanda. Here the similar question arose. Your losses will find that at paragraph 7, 7, 9, 27, 34, 35. I will just what the proposition of law laid down by this Honorable Supreme Court in paragraph 52 to 60, that I will. Similar, all the facts cannot be the same, but similar. Kindly come to paragraph 52 at page 43.
Yes.
On a consideration of the aforesaid judgments, the following principles would emerge. There is a duty or obligation of disclosure by the insured regarding any material fact at the time of making the proposal. What constitutes a material fact would depend upon the nature of the insurance policy to be taken, the risks to be covered, as well the queries that are raised in the proposal form. Kindly take note of this, madam. As well as the queries that are raised in the proposal form. What may be a material fact in a case would also depend upon the health and medical condition of the proposer. So here there is a person who was suffering from certain disease. He disclosed it. But they say, Malad, there are certain other diseases. If specific queries are made in a proposal form, Roman 3. If specific queries are made in a proposal form, then it is expected the specific answer are given by the insured, who is bound by the duty to disclose all material facts.
Correct.
That's it. If any query or column in a proposal form is left blank, kindly see your lordship what the Supreme Court, Honorable Supreme Court says, then the insurance company must ask the insured to fill it up. If in spite of any column being left blank, the insurance company accepts the premium, issues a policy, it cannot at later stage when a claim is made under the policy say that there was a suppression or non-disclosure of material fact and seek to repudiate the claim. This is the relevant paragraph. You didn't put me any query. On the online proposal, I cannot disclose something on my own.
Yes.
Then paragraph Roman 5. The insurance company has the right to seek details regarding the medical condition, if any, of the proposer, by getting the proposer examined by one of its empaneled doctors. If on the consideration of the medical report, the insurance company is satisfied about the medical, this is not a say. Then your losses, this is material fact that how to be relevant. Then your losses paragraph 7. In other words, a prudent insurer has to gauge the possible risks that the policy would have to cover, accordingly decide to either accept the proposal form and issue a policy or decline to do so. Such an exercise is dependent on the queries made in the proposal form. Kindly, my lord. Such an exercise is dependent on the queries made in the proposal form and the answer to the queries governed by the proposal.
Correct.
Similarly, according to my humble submission before lordship, this, my lord, the question now arises with your lordships on the pleadings of the parties and the documents disclosed.
Yes.
Well, this is the answer. If you do not put a question, how could I disclose it?
Okay.
Then your lordships, and I cite another judgment to your lordships. Just. Well, this is, my lord, the honorable single judge judgment of the division bench judgment of the honorable Allahabad High Court. Your lordships, and that's I give my learned friend the reference Santosh Kumar. A copy? Oh, I'm giving copy. That's very good. আমার কই সন্তোষ এটা আমি তো নোটস লিখেছিলাম না এটাই मतलब paragraph 8, 9, 16 and 2022. मतलब I just take your lordships. Paragraph 8 and 9, your lordships will get the facts. मतलब paragraph page 2, paragraph 2b. While applying for the policy, the insured allegedly furnished all requisite details in the application form. Then your lordships will get these facts. Now I take your losses straight away to paragraph 16, how this was repudiated. Then your losses, I think, my lord, dealing with all the cases. Conclusion at page 22. Kindly consider this.
Yes.
Upon examining the facts of the present case, it is to be noted that the petitioner had taken 4 policies from the LIC. Of 3 of the said policies, the LIC has made payment with regard to the claims made by the petitioner. But pause here for a moment. I have already got, my lord, on the death of my father, the specified amount of 8 lakhs from the railway itself. And the other insurance he has got, I have disclosed to your losses. I will give the page number, your losses to that. However, for the last policy that was taken on August 16, 2018, for the insured of from the sum assured of rupees 15 lakh, the same was rejected by the LIC on the ground that the column 9 of the proposal form was left blank by the petitioner. In fact, clause 9 specifically sought for details of policies that have been taken by the petitioner within the past 3 years, and the petitioner did not mention that the petitioner had previously taken a policy bearing number 558. Your losses can take note of, because the other number, only the last 3 digits, from the LIC itself, for a sum of assured of rupees 3,70,000 on May 28, 2018, less than 3 months before taking the present policy. In our view, this is not a suppression of material fact, and accordingly, the LIC cannot shrug away from the responsibility by merely taking the ground the previous policy was not disclosed. The petitioner has pleaded that he has disclosed the information to the agent of the LIC. And as per the agent, the said previous policy is not required to be filled up in the form as it was already within the records of LIC. The insured had also given copy of his PAN card, Aadhaar card to the respondents while filling up the proposal form. Moreover, insurance of policy bond imputes verification of proposal form along with the financial documents like Aadhaar and PAN with all the previous policies are linked. The earlier policies all being purchased from LIC, one would expect the minimum due diligence would be carried out by the LIC also.
Yes.
Applying to the aforesaid judgment to the facts of the case, it is to be noted that if in spite of any column being left blank, the insurance company accepts the premium and issues policy bond, it is presumed to have waived its right to repudiate the policy on the ground of suppression or non-disclosure of material fact at a later stage. Thus, it is the burden of the respondents to verify the details provided by the insured available with the office of the LIC before the insurance policy bond. Mere shifting of their burden upon the petitioner from his rightful claim would not help the respondents in any manner. As I taken your losses, they follow policy. All the policies, your losses, kindly take out note of paragraph 5. All the policies were done in one day, 25th September 2023. One after another specified. So if I one disclose my lord one, they could have my lord before issuing the policy bond. Kindly take all the policies were taken on 25th September 2023. They could have said, no, you will not get the policy bond because you have done the others we have not disclosed. So I had disclosed my Aadhaar card, I disclosed my PAN card, then I got it. My point is clear to your lordships. Why I am saying it to your lordships. These are my humble submissions with your lordships. Only one thing I tell you, Lord, take your lordships to their supplementary affidavit they have given us today. And I don't require my lord to any. No, just a minute, my lord. No, no, please. Just a minute, my lord. Notes storage. Now, my lord, the date of death of the father, that means insured person, 30th April, 30 April 2024. 2024. 30.
30th April.
30th. Now, I have my lord, placed before your lordships the particular paragraph of the repudiation, my lord, that the company does not dispute the date of the incident. I placed it. Now, what they have trying to say, dear lordships, there is another company with whom I have the claim, Care Health. My lord, they have lodged an FIR after 2 years with the place where my father died by falling from the railway. That's a Daltonganj, your lordships, in 2024. Now, that FIR date, kindly take note of your lordships, 5th May 2026. Your lordships will not find the FIR date here. I do not get it from their supplementary affidavit.
Who has lodged the FIR?
My lord, FIR lodged by another insurance company, Care Health, not the present insurance company. The FIR date 19th May 2026. What they say that we have not disclosed in the present petition that particular FIR. This is their supplementary affidavit, and therefore
19th May.
19th May 2026.
Where it is that?
Well, that they have not disclosed. I am getting a losses. Suppression of material fact.
What is the date of the FIR?
FIR 19th May 2026.
Where it is at?
That's your lordship will not get it. I can give your lordships the date. Your lordship, paragraph 5, they have only said the FIR, they have not.
Yes. Paragraph 4, it is there. Supplement.
Date your lordship. And yes, I'm sorry, yes. Date is there. Now, your lordships, writ petition was filed. I have received it on yesterday,
Para 4, they have given the details.
Exactly.
Your Lordship,
Yes.
once my learned senior will start the submission, I will join within 2 minutes, Your Lordship. Just 2 minutes.
But you have minded
will-
you are repudiated. I will not hear their contention. You are repudiated. It is your duty to
I will
satisfy
counter.
this.
I will counter. I will counter everything. Just 2 minutes.
Yes.
Now, your lordships, what they say by way of this supplementary affidavit, I have suppressed the filing of FIR against me by the another insurance company. Now, my lord, the writ petition your lordships affirmed on, my lord, and
No, I
filed on
will deal this.
15th January.
I will deal this. Let
So this
they
is
come.
what they have post, my lord.
This I will deal this.
Let-
That's why this court, once the matter is taken up for hearing, this court is not adjourning the matter. By adjourning the matter, this is the fate. On that day, I put them, the insurance company, in crush. Now they have taken this. I will see to that.
Much obliged.
My lord has seen, this annexure to this.
You satisfy me.
Lordship.
I'll not required to go to the facts. You satisfied this court 3 points. Show me the insurance law that one person only can get the insurance of one accident policy, not more than one. Show me the law under the
There
policy.
is no, my lord, there is no bar with regard to taking a number of policies. My lord, there is no bar.
There is no bar. Any
There is no
any number of the policy
Any
can be
number of
taken.
policies, my lord, can be taken, my lord. But
You are
the
referring for the respondent number
my lord, in this case, not for 3 and 4.
3 and 4.
My lord, though I am not answering respondent in this case. my
No,
lord,
but I am asking the legal question
yes,
because you have taken
yes.
it is suppressed. It is suppressed or not, that I will come to later. So first you have addressed the law point whether there is any prohibition for taking the multiple insurance action, that too I am specific on the accidental insurance.
Lordship.
There is any no, there is no
No,
bar.
no, my lord,
There is no bar.
There is no bar.
Then you satisfied this court. Second, where is the law? Where in the form? Is there in column? He has to give the details of the policy.
My lord, in law, my lord, there is no bar with regard to taking of multiple number of policies. But, my lord, this disclosure with regard to, my lord, the previous policies is to be given so that, my lord, insurance.
Show me your form. Show me your form. It's online. The person cannot come to you first year to so, or you this is not your case. You ask the petitioner at the time of filing of the case how many policy that is. Show me the form. Is there any column with regard to the details?
My lord, if your lordship kindly comes, my lord, to page number, my lord, in this item number 7, my lord, the petitioner's writ petition, page number 26, my lord.
Page number
26. Page number 20.
26.
20, my lord, it should be 20, 26.
26 the affidavit. Writ petition.
My lord, then 27, my lord. My lord, the numbers, my lord, have been, my lord, deleted from my copy.
27 is the ombudsman rule.
My lord, your lordship, my lord, come to page number 27, the insurance policy proposal form. P1. Annexure P1 is. My lord,
P1 is the insurance ombudsman rule 2017.
My lord, this is the copy which has been served up to me, my lord. The first proposal form.
Which, from where you are referring?
Annexure P1, my lord, this is
26.
WPA, my lord, 1304.
No, that is another. I am on W.
It is
ये कौन सा
page 26 WPA 1304.
आइटम नंबर कौन सा है कहाँ 120 कर दिया
page 26 my lord.
সে পুরোটা অন্যটাই নোট করে
তুমি কোনটাতে
कितना बार बोलता हम यार तुम लोग सही में पेज 1 P1
my lord, P1, my lord, page 26 in my copy.
yes got it.
My lord, your lordship will kindly see, my lord, this is the proposal form.
Yes.
On the left, my lord, insured's name. This is the first box. Second box is policy details. My lord, in policy details on the left, first column, my lord, is proposal number, period of insurance, date of proposal, and then previous policy number is 0. He has disclosed, my lord, 0 policy.
Correct.
No, my lord, it is not leaving blank, my lord, he has put in 0. Next page, my lord, the page after next, page 28,
Page 28.
lordship.
Yes.
But this is the same policy,
Yes.
the same place, my lord, previous policy number 0. Your lordship will kindly see, my lord, the timing. As has been rightly, my lord, pointed out, my lord, if my lord, the timing was there.
Yes.
Page 28, my lord, in the same, my lord, the second column, second box, policy details, your lordship will kindly see the timing. Second box, my lord.
Yes.
First column was previous policy number 0. My lord, second column from 25/9 to so and so, timing is 11:59.
11:59.
Look,
Yes.
this was with regard to the first policy. He had taken.
No, that is page 26 and 27.
26 and 28 are to be read together.
So these are similar policies.
These are similar, one policy.
Okay.
And then, my lord, your lordship, for the next policy, my lord, first policy 11:59, my lord.
Correct.
Second policy starts at page number 3030, my lord.
30, yes.
Same place, your lordship will kindly see, my lord.
Yes. Name, policy number.
Previous policy 0.
Yes.
It was 11:59. Actually, না সময়টা কোথায় আছে 217 from 217 to 2020 নম্বরটা ডেটটা কোথায় টাইমিংটা মিলট second policy
Page 30.
page 30 মিলট 30
Yes.
and 32
Yes.
read together.
Yes. Page 30.
Previous policy 0.
Yes.
First
But
policy
kindly see the time.
Milord, timing is Milord is
Similar time. Same time.
Milord, timing is specifically not here, Milord.
Kindly see.
Yes.
24/9/2024 11:59:59. The same as page 26.
But Milord, it is taken subsequently, Milord, and then Milord.
It is your document. It is not your case. The petition has fraudulently obtained this document. Then 34. 67, 69, 601. Then 34. 34 is the third policy. How many policy you have taken?
Milord, 4 policies are there. Page 26, 30, 34,
26, 30,
and
34.
38.
All are time same. 38. Time is same.
No, Milord, timing, Milord, is your lordship will kindly see the issuance of policy, Milord. Timings are different, Milord, in all the 4 policies.
Where
Milord,
where is that?
Milord, page 26, Milord, the first one what I had shown to your lordship, it's 11:59. At the top, Milord, 153:59. Policy starts, Milord, 153:59.
Correct.
The second page 30, Milord, it starts at 217. From 153, Milord, it goes to 217.
Correct.
Previous policy 0.
Correct.
And then, Milord, the third, at page 34, it is 9:58
Correct.
PM.
Correct.
Milord, 7 hours later.
Okay.
Previous policy 0.
Okay.
And then, Milord, the fourth one, page 38.
Yes.
At 10:01.
Yes.
Previous policy 0.
Yes.
But in all these subsequent 3 policies, the previous policies, Milord, the existence of previous policies has not been referred to. It has been reflected that no previous policies were there.
Correct.
Milord, difficulty is, Milord, when the insurance company issues the policy.
Yes.
Milord, it sees, Milord, the financial condition of the individual also. Milord, in this case, Milord, the documents were shown to your lordship, Milord, in the repudiation letter, that the policy of approximately rupees 25 crore were taken in the name of one individual. The individual, Milord, was around 60 years old man.
Yes.
On the verge of retirement. All these 25 crore or whatever the amount may be, Milord, a little less or more, Milord, were accidental insurance policy. A substantial part of these policies, Milord, were with regard to one particular travel from Calcutta to Ajmer and Ajmer to Calcutta.
Correct.
A couple of crores, Milord, policy. Milord, we all are prudent men here, Milord, what I understand. Milord, there is no previous record of taking these previous policies, Milord, or earlier this accident claims coverage. In 6, 7 or 8 months, an individual takes a policy in the name of his father, who is in the verge of retirement, for approximately 25 crores. Quite a few of those are with regard to one particular travel. He himself travels with his father on that Ajmer trip. For himself, there is no record of any accidental claim coverage, Milord. Milord, what does this lead and where we are leading to?
Are you the investigating agency or you're an insurance company?
Milord, I am an insurance company. I have got investigating officers also.
Once
Milord,
you receive the claim,
Lordship.
when you receive the claim from the petitioner after the death of the father.
Milord, after the death of the father, yes.
After the death of the father, when you have received the claim of the
Milord,
petitioner.
specific date, not within 2-3 months, but within
2-3 months.
reasonable time.
Just
Yes.
a minute.
Yes.
Within 3 months.
Lordship.
And you repudiated the claim. Have you made an application complaint to the police authority? Please, there is a doubt with regard to the purchase of this policy, and he has traveled with the father, and he is the beneficiary for investigation before repudiation.
Milord, there was.
I am asking one question.
Milord, police had given.
I am asking one question. What you have opened your mouth with regard to the.
Yes,
regard to the genuinity of the claim. So that's why the court has, I am putting a question to you. After the death of the insurance for 2-3 months, the petitioner who the beneficiary of the claim or nominee of the insurer has applied for, and you find that 25 crore rupees is there, and similar policy has been repeatedly purchased on the same day. So there is a doubt. So first the police has to investigate into the matter, and then we will proceed with that. This is not your case in the repudiation. What you are submitting here now, that is not the case of the repudiation. What you have taken the decision in the repudiation, you have to stick only on that. You cannot go beyond that. If you could have been taken your authority or taken the stand at the time of repudiation, yes, there is a doubt. So we are not going to decide until a proper investigation. That is not the case in the repudiation. So this court cannot take the cognizance on your submission. Yes, next.
Milord, investigation, Milord, was an ongoing process.
That is subsequent. Sir,
Milord.
Don't tell all these things. If the fire incident is occurred, whether you are giving the immediately you are giving the insurance. If the fire has been initiated under 436.
No, Milord, our Milord,
the GRPO has closed the case long before.
Yes, Milord. Milord, the investigator of insurance company goes to the site, Milord. The surveyor goes, it makes the assessment, Milord. If it's found in order, then the claim is paid.
Correct.
Lordship.
So here also the death was occurred and in the railway station. The authorities have initiated the case, filed the report, and that the court is not going into that. You are asking what you are making the submission. That is not the ground of repudiation. If it had been the ground of reputation, the court could have been think on that. But that is not the ground of reputation with regard to there is a suspicious on all these things.
Milord, ground of repudiation, Milord, what I find in this record, Milord, is the ground of non-disclosure of and Milord, non-disclosure of previous policy references.
That is the point of law, whether it is required or not.
Milord, it is not only with regard to the non-disclosure of previous policies of this company, Milord. Milord, there was, as I stated, Milord, there were at least 10 other companies, Milord, approximately. None of the other insurance companies' policies were disclosed. Not even one.
So that's why the first question I put to you, is there any bar for purchase of the policy or disclosure of the policy earlier? If I am purchasing for all 100 of the companies, I have purchased the policy. It is required that all the 100 policy detail is to be given to you.
Yes, Milord,
show me the law.
Milord, the references.
Show me the law. And you are telling that page 21 to 38, 26 to 38, it is the same day you have accepted the premium.
Yes.
Then you are not bothered to see.
Milord, how can I, Milord, on the online, Milord, if he says 0, he has declared it.
Okay.
He has declared it.
Okay,
he is not, Milord, he is not even keeping it blank.
Okay,
he has declared previous policies 0.
Okay,
and not only with regard to this insurance company, Milord, with regard to all other previous policies, if there be any.
Okay.
Milord, I cannot go and, Milord, ask for 100 crore or 200 crore rupees insurance policies in my name. If I ask for, my lord, I have to disclose all my other, my lord, financial position and all my other, my lord, the whether I'm in a position to pay premium or not, and whether I'm worth 200 crores or not. Otherwise, my lord, it will, my lord, lead to an anarchy.
So you mean to say, as per your submission, if I have purchased insurance policy and if something has happened to me, so
Yes.
and the policy covers 100 crores, so
Lordship.
you will not give the 100 crores
will
if the
give, but-
policy covered.
Yes, it will
Eh?
give, but my lord, at the time of disclosure and at the time of taking
That
the
is
policy.
different. That I'm saying, that is different thing. That is the point of law. Then that court will
Lordship,
decide.
lordship,
Yes.
lordship. My lord, because if it is not disclosed, my lord, once it is disclosed, insurance company will decide on the
law. Show me law. You are going here and there.
My lord, I am on the disclosure part.
Yes.
My lord, it is Reliance Life Insurance versus Rekha Bain.
Yes.
Understand, my lord, 219, 6 Supreme Court cases,
Yes.
175.
Which paragraph, sir?
Your lordship will kindly come, my lord, to the paragraph 16, 16.
Para 16.
Lordship.
রেফারেন্সটা বলে দাও একটু বলেছি বাবু
2019 6 SCC
2019 6
575 Paragraph 16, if minute, if I can invite my lord.
Yes, yes, yes.
Minute, the fundamental principle is that insurance is governed by the doctrine of uber rima fide. This postulates that there must be complete good faith on the part of the insured. This principle has been formulated in McGilvray on insurance law succinctly thus: subject to certain qualifications considered below, the assured, that is the insured, must disclose to the insurer all facts material to the insurer's appraisal of the risk which are known or deemed to be known by the assured, but neither known or deemed to be known by the insurer. Breach of this duty by the assured entitles the insurer to avoid the contract of insurance so long as he can show that the non-disclosure induced the making of the contract on the relevant terms.
Yes.
The relationship between an insurer and the insured is recognized as one where mutual obligation of trust and good faith are paramount.
Yes.
Therefore, thereafter, I would invite your lordship to come to paragraph 26.
Yes.
It's at page 192.
Yes.
My lord had been asking, what was the material fact, whether it was important or not. The expression material in the context of an insurance policy can be defined as any contingency or event that may have an impact upon the risk appetite or willingness of the insurer to provide insurance cover. My lord, I would request my lord to go to next paragraph 27. Materiality from the insured's perspective is a relevant factor in determining whether the insurance company should be able to cancel the policy arising out of the fault of the insured. Whether a question concealed is or is it not material is a question of fact. Paragraph 28, my lord will kindly come to. Materiality of a fact also depends on the surrounding circumstances and the nature of information sought by the insurer. It covers a failure to disclose vital information which the insurer requires in order to determine, firstly, whether or not to assume the risk of insurance, and secondly, if it does accept the risk, upon what terms it should do so. The insurer is better equipped to determine the limits of risk-taking as it deals with the exercise of assessments on a day-to-day basis. In a contract of insurance, any fact which would influence the mind of a prudent insurer in deciding whether to accept or not accept the risk is a material fact. If the proposer has knowledge of such fact, she or he is obliged to disclose it, particularly when answering question in the proposal form. An inaccurate answer will entitle the insurer to repudiate because there is a presumption that information sought in the proposal form is material for the purpose of entering into a contract of insurance.
Yes.
29 minutes. Contract of insurance are governed by the principles of utmost good faith. The duty of mutual fair dealing requires all parties to a contract to be fair and open with each other to create and maintain trust between them. In a contract of insurance, the insured can be expected to have information of which she or he has the knowledge. This justifies a duty of good faith leading to a positive duty of disclosure.
Yeah.
The duty of disclosure in insurance contract was established in so and so. Milord, Lordship will then, Milord, kindly come to Milord. Paragraph 32, Milord, 30 and 31 also deals with the same, Milord.
Okay.
It, Milord, further, Milord, elaborates that principle. Milord, I was inviting Milord to paragraph 32. In the present case, the insurer had sought information with respect to previous insurance policies obtained by the assured. The duty of full disclosure required that no information of substance or of interest to the insurer be omitted or concealed. Whether or not the insurer would have issued a life insurance cover despite the earlier cover of insurance is a decision which was required to be taken by the insurer after duly considering all relevant facts and circumstances. The disclosure of the earlier cover was material to an assessment of risk which was being undertaken by the insurer. Prior to undertaking the risk, this information could potentially allow the insurer to question as to why the insured had in such a short span of time obtained two different life insurance policies. Such a fact is sufficient to put the insurer to inquiry. This was only in case of two insurance policies. Ours is not such a large number of multiple policies.
Yes, yes.
33 million. The learned counsel appearing on behalf of the insurer submitted that where a warranty has been furnished by the proposer in terms of a declaration in the proposal form, the requirement of the information being material should not be insisted upon, and the insurer would be at liberty to avoid its liability, irrespective of whether the information which is sought is material or otherwise. For the purposes of the present case, it is sufficient for this court to hold in the present facts that the information which was sought by the insurer was indeed material to its decision as to whether or not to undertake a risk. The proposer was aware of the fact while making a declaration that if any statements were untrue or inaccurate, or if any matter material to the proposal was not disclosed, the insurer may cancel the contract and forfeit the premium. Milord 34, Your Lordship will kindly come to. We are not impressed with the submissions that the proposer was unaware of the contents of the form that he was required to fill up, or that in assigning such a response to a third party, he was absolved of the consequence of appending his signatures to the proposal. The proposer duly appended his signature to the proposal form, and the grant of the insurance cover was on the basis of the statements contained in the proposal form. Barely 2 months before the contract of insurance was entered into with the appellants, the insured had obtained another insurance cover for his life in the sum of rupees 11 lakhs. Your Lordship will kindly see me at the time, 2 months. My Lord, amount is 11 lakhs. Here, yes. Lord, we are dealing with approximately 25 crores. We are of the view that the failure of the insured to disclose the policy of insurance obtained earlier in the proposal form entitled the insurer to repudiate the claim under the policy.
Yes. Next.
My Lord, on that basis, my Lord, the insurance policy's repudiation was held. And my Lord, as far as the judgment relied by my learned friend, my Lord, Mr. Shanyal, this Manmohan Nanda,
yes,
is concerned. If my Lord is kind enough to come to my Lord, paragraph 68 of this.
Paragraph 68.
68, page number 55.
Yes.
Therefore, the respondent, is my Lord there, my Lord?
Yes, yes.
Therefore, the respondents were not right in stating that as per the terms and conditions of the policy, all the complications arising out of the pre-existing condition is not payable. As already noted, acute myocardial infarction can occur in a person who has no history of diabetes mellitus 2. One of the risk factors for the aforesaid cardiac episode is diabetes mellitus 2. The fact that the appellant had diabetes mellitus 2 was made known to the insurance company. So this is absolutely different fact. It was made known to the insurance company.
So that's why since beginning I'm asking
I'm grateful
you.
I'm extremely
what is the law to? Yes, next.
Milord, Allahabad is based on this, Milord. So this is there. And Milord, this supplementary affidavit, Milord, because in the next matter, Milord also is relating to the same matter. There are. So, Milord, next matter he would not be doing, Milord.
Why?
Because the affidavit.
Frankly speaking, Milord, I could not prepare myself. This
same.
Is no, this is a little different.
Same, Milord.
No, can't be the same. This was not repudiated by the insurance company as Malaysia. What the ombudsman says that they have a limitation to entertain a claim. Above that, they won't.
Okay.
That's a different point.
Okay.
That may have a judgment, but
No,
have to
Milord,
place it.
Milord, why I was submitting, Milord, since in the other matter affidavits were not complete, as I paid for time before your lordship. Milord, in today's supplementary affidavit, Milord, that was the reason, Milord, I was paying for time, because these documents, Milord, we have got very recently. Your lordship will kindly see the annexure part, Milord. My lord has been kind enough to see that, Milord. Milord, this is, Milord, from the railway police, Talkalganj, where the accident had taken place. Milord, accident took place.
When?
Milord, this is recent, Milord, because this is,
Then?
Milord, this is 1st June 2020.
Then?
But Milord, the section is section 302. Investigation is under section 302. It is a murder.
2024 incident, 2026, when this court has scolded you, you have pursued the, I will record that. If you want to press that supplementary, I will record that. That's I'm telling Mr. Sanyal not to argue the matter on merit. I will record that submission. I will record the date. I will take this CD also. No problem. That's why this court in the habit, if the matter is taken up for hearing, I am not adjourning, because 2-3 matters I have suffered that. And you have done this also.
Did I?
Yes. Why? You persons have advised, go to the FIR, because this court has first you have given the answer and the same question was put, and now the second day you are coming with an FIR up to after 2 years. I will record that. If you really you argue the matter, I will take note of it and I will record that. That's no problem. What is not the result? That is different thing. But advocates should be fair before the court. What is before the court? You have to rely on that, not to go and get supplementary afterthought.
Milord, it was, Milord, the investigation was, Milord, your lordship will kindly hear me, kindly be with me, Milord. Milord, the investigating agencies were, Milord, going through the process. Milord, the facts, Milord,
I had practice in the criminal side 25 years.
I'm aware of that.
And I know once the final report is filed, what is the time limit for reopen the claim, reopen the case. The railway authority has closed within 2 months. And now after when the court had scolded you when the insurance policy is going on, even though that's why I put the question, when the claim has come to you, why you have not given the matter to the insurance and the police authority for inquiry?
Milord,
pending your claim.
Milord, initially, Milord, because of this lack.
And after the 2 years, you filed the writ petition, you have dealt with all the things. Now you are going to the FIR.
Milord, lack of Milord, FIR is first of all is not by this company, it's by another insurance company.
Maybe.
Milord, who is not a party here in this particular case. But Milord, we have been asked, your lordship, see, Milord.
Okay, I will deal with that.
Milord, to submit all these documents, Milord.
Very good. I will deal with the FIR. No problem. Whatever the submission you made on that FIR, I will deal that.
Milord, the investigation of the insurance company, Milord, or
tell me one thing. You are telling is referring to 302.
Lordship.
And when the FIR was chalked out?
Milord, since we are not the FIR maker.
No, when the FIR was chalked out, and from the page, paragraph 4, who has upon this affidavit? Then
New India is upon.
Who has upon the affidavit?
New India Assurance.
New India Assurance. When the FIR was chalked out?
Your lordship, from the.
Milord, your lordship kindly sees, Milord, the case number.
Correct. Kindly come to the page number 4, paragraph 4, page 3, paragraph 4. Page 3, paragraph 4. Come.
Yes.
Correct.
Yes.
Page 3, paragraph 4.
Lordship.
On May 2026, there is a section of 302. IPC is there.
Milord, it is, Milord, the notice, Milord.
Notice says so.
Milord, the police has sent this notice. Milord, in this connection, your lordship will kindly see, Milord, page number 6. Milord, your lordship, Milord, would it be my lord pleasure to come to this notice of the police once, Milord, for my satisfaction? Notice সঙ্গে ম্যাচ খাচ্ছে না
The general counsel কে পাঠিয়েছে
this has been sent to the general counsel, Milord, of insurance. And Milord, there was another notice, Milord, with regard to, Milord, the respondent number 4 in in item number 8. If your lordship, my lord, these are all my lord same. That is why my lord, I'm just your lordship kindly
That's why I'm
pardon.
asking,
My
sir,
lord, my lord.
the 302 matter
Lordship.
after 2 years, and this is after 2 years.
My lord, since this is connected matters, my lord, I'll just, I mean, there's the chat, extra copy ache. I mean, the 8 here. Notice is same of the Daltonganj police station, the supplementary affidavit. সেটাই বলছি তাই জন্য জজ সাহেবকে দেখাচ্ছি your lordship will kindly say my lord the no hand given notice what I have given to your lordship
91 years.
My lord, 94 BNSS,
Correct.
in bracket 91 CRPC,
Correct.
taking information. In the above referred case, the suspicious death of Ratan Kumar Kundu, my lord, written by the railway police.
Correct.
To us. To
Correct.
us means my lord, to the General Council of Insurance Company.
Correct.
In the above referred case, the suspicious death of Ratan Kumar Kundu and a possible insurance fraud, criminal conspiracy are being investigated. During the investigation, it has come to light that insurance policies are issued in the name of the deceased with your company, and a post-death claim was proposed to be filed. Therefore, you are requested to ensure that original copies and available digital records of following documents, there are a large number of documents referred to, made available to this office under section 94 of the BNSS. So, my lord, the new act, my lord, BNSS, and it is not just, my lord, that.
Sir, I am asking only one question.
My lord.
Unless and until it is proved that that is not a natural death, that is not the death, accidental death.
Lordship.
First, the police has to investigate. Yes, this is not an accidental death. This is not the unnatural. It is the unnatural.
My lord, I'm grateful.
Then only the police will come. That's why I didn't want to go into this.
Lordship.
Without that, the death first, the cause of death has to be proved.
I'm grateful to your lordship.
Once the death is proved, then only the question automatically it will come who was involved. If the proposers, the beneficiary is involved, automatically it will be repudiated. So kindly see what is the investigation with regard to the cause of death. Cause of death is already there in the final report by the railway authority. Maybe ask the survey documents from you, from your document, whether the cause of death will ascertain. That is only a mens rea will come.
My lord, this is with regard to, my lord, the insurance fraud. Police is taking note
Sir,
of, my lord,
insurance fraud by whom?
by the petitioner.
Petitioner. Why? What is the petitioner? It is the that's what.
Yes.
Go out. Go out. Out. Is he your junior?
I'm sorry.
He don't know the decorum of the court when the court is putting a question to the senior in his.
I'm sorry.
See, that's what I'm telling. Where the intention started, purchased the insurance policy, made him a nomination. After 1 month, 2 months, 3 months, 1 year, death occurred. So whether the death occurred, that death, cause of death is connected with is involved by the
insured,
not insurer,
the claimant,
the nominee,
beneficiary.
First, you have to ascertain that.
My lord, this is what, my lord, the investigation.
You are showing 91. 91 is that. 91 is the production of document. Production of document, nobody is denying that he is having the insurance policy covered 25 crore, whatever it is.
We are not denying that. But, my lord, this production of document is in reference to what? It is in reference to the, my lord, the suspicious death.
Yeah, that is what I am telling. Suspicious death means suspicious death.
Yes.
So the cause of death has to be ascertained. It has to be ascertained. The cause of death involved, the petitioner is involved, the beneficiary is involved for causing death to the.
That would be the resultant effect of this investigation.
Correct. You are telling that. Show me the CD otherwise. Yes, there is a suspicious upon this petitioner.
Your lordship will call for the CD. Because
why?
My lord, we have received, my lord, we have only received this notice. Nothing more. And this is why, my lord, I thought it, my lord, prudent on my part to show it to your lordship, my lord, that what is the state, my lord, what is happening. My the amount of policy for the person and non-disclosure of material facts. The judgment would have placed before your lordship. Had I
Mr. Sanyal, your client has got a notice from the investigating agency. Take instruction.
Investigating from the
This FIR from the police authority.
no, I
Has
tell you, losses, not
has-
from the police authority.
Ah.
My client received the, my lord, came to know on 17th June 2026. My lord, he came from the Axis Bank. There was a email survey that then he has to put to the link. Then he came to know that he has no account in the Axis Bank in the Daltonganj. Probably police informed the Daltonganj branch of the Axis Bank. He has a bank account in the Durgapur branch. So from that, he came to know that there was an FIR. And this was a complaint by the Care Health.
No, but the problem is that now once the involve the insurance policy, then the court has to be caution on that. So if it's so, then you have to make a party to them. Then the
Party to
court,
Malad-
this investigating agency, because the insurance policy is involved in that.
Malad, I can take your lordships. But kindly come to my. This is after Malad 2.5 years.
Maybe.
Just your lordships. Read petition. Just a minute. I take your lordships to that. Page 43 and 44. I have not taken your lordships to this. Malad, English translation of police final report. Malad, kindly come to the next page.
Yes.
Last but one paragraph. Moreover, as per the post-mortem report, the statement given by MO at Sadar Hospital and due investigation, it has been revealed that the deceased had expired due to an accident itself. So after thorough investigation from all the aspects, it has been cleared that the deceased Ratan Kumar Kundu such and such has expired due to accidental fall from running train. And this has been closed by the GRP. And the railways authorities settled the claim of rupees 8 lakhs. That is I have also annexed.
Okay.
Now what I'm claiming, after that they will probably wake up and lost a false claim. Complaint.
Standard of proof, Lord, in a civil proceeding and a criminal proceeding.
Okay, next. Anything further?
No, Lord, these are the two grounds, Lord. We have repudiated on the ground of non-disclosure of material facts. And Lord, investigating agencies were always in doubt, So we had pursued that at the time of issuance of policy, Lord, from so many insurance company and so many policies have been taken, Lord. We were never aware of that. Lord, had we known, Lord, as a prudent insurer, Lord, we would have thought otherwise whether to give a policy of.
And now we go to the second issue. Okay, this is if you find that he has not, but the first insurance policy which he purchased at 21. Correct. At that time there was no policy.
With regard to other insurance company, then maybe
I am asking you.
From this insurance company, perhaps not. I have not.
Not.
First policy
No. Then.
So, not first policy, not perhaps with this insurance company, there was no previous policy.
Then,
but with regard to other insurance companies, he needs to disclose that. LIC policies, your lordship has seen, it was only for 11 lakhs. And 3 months earlier, he had taken that.
I am asking, lordship, why you are going to the other fact?
We were not aware of.
Not aware. Yes.
Your lordship, kindly come to page 23 of my opposition, your lordship. Your lordship.
Page 23.
Page 23. Annexure C, your lordship. Your lordship, why the insurance company is repudiated? Insurance company cannot repudiate on its own, your lordship. There's an independent authority. A surveyor has been appointed, who is then having a licensed surveyor has been appointed. Your lordship, kindly come to the 23, how it has been dealt. Your lordship, kindly come about the incident first. Page 25.
Yes.
Shri Ratan Kumar Kundu went to Ajmer Dargah, Rajasthan, with only son Sri Shayan Kundu on 26/4/26 for pilgrimage. They reached Ajmer on so-and-so date. After darshan at Ajmer, he and his son boarded train Satragachi Express on 28/4/24 at Ajmer railway station at about 23:40 hours. They were supposed to reach Satragachi Howrah on 30/4/24 at about 14:30 hours. They boarded the train in B7 coach
and their birth number were B722 and B724. Ticket copy enclosed here. The incident, as stated by the insured Sri Shayan Kundu, is reproduced below. I'm not reading it because His Lordship is well aware of it. Your Lordship, kindly come to 8.8, page 26, our investigation. Our inquiry at Daulatganj GRP and Daulatganj Hospital. We visited the Daulatganj GRP on 21-25 for investigation into the insurer's death case. We met Sri Munidhar Naik, Sub-Inspector of Daulatganj GRP, and has discussions with him about the case. Sri Naik confirmed us the incident of recovery of the dead body of Sri Ratan Kundu beside railway track was true. He told us that the body was lying near pole number 312/2628. One railway personnel of Toldra railway station informed Daulatganj GRP at about 9 a.m. On 30/4/24, the one dead body was lying beside the railway track near the pole number so and so. Police personnel from Daulatganj GRP rushed to the spot and picked up the body and brought to Daulatganj GRP station. The body was inspected by officials of Daulatganj GRP on 30/4/24. The FIR was made by...
Where is the main? That is the fact.
Your Lordship, kindly then come
Where is the conclusion on this?
Yes, Your Lordship. Kindly come to repudiation of claim.
Where is that?
Page 30. Yes.
Repudiation
of Future General Indo Insurance Limited repudiated the claim lodged by Sri Shayan Kundu. It's a different insurance company, not from the same. Copy of the repudiation letter is enclosed and so and so. Reason repudiated by the same said insured for the repudiation code based on submitted claim documents and policy terms and conditions. Multiple misrepresentations based in claim. Also, insured was not cooperating for verification process. We have reproduced below the exclusion clause for the policy basis which were unable to pay this claim. Disclosure to information norm. Definition. Disclosure to information norm. The policy shall be void and all premium paid thereon shall be forfeited by the company in the event of misrepresentation, misdescription of non-disclosure of any material fact. Now 8.6. Abnormal PA policies purchased by the insured. The insured has purchased 22 numbers of PA policies from 11 insurers from more than rupees 12 crore. Some policies, like 2 policies with Care Health Insurance Co Limited for rupees 6.5 crores, had provision of double benefits in case of accidental death. This total policy amount around rupees 19 crore were purchased. Notarized affidavit of Sri Shayan Kundu, this is on declaring the policy details and in incidents is attached. This is a whole lot of policies which has been purchased, Your Lordship, which was given by on affidavit. Now coming to the conclusion, Your Lordship, page 32. 9. Our verification, we could not find any clue contrary to the death of the insured's late Ratan Kundu due to reported fall from the train. Mr. Ratan Kundu was not even in officer rank in employment at Durgapur Steel Plant. He was senior technician. He belonged to lower middle class, but it is astonishing and mysterious that he purchased abnormal value of policies from 11 insurers for total death benefit of rupees 19 crores. This obviously gives a question whether the beneficiary of the policies had any ill motive behind the death. It appeared that the death was a certainty at the time of purchase of the astonishing amount of policies. We, under the circumstances, cannot recommend payment of benefits under the subject 4 policies. The insurer should get in touch with other insurers to verify whether the insured declared all the policies to all the insurers. The investigation report is issued without any prejudice. Now, why I am submitting this, Lordship? This is the third-party organization, or the license organized created by IRDA. They have come to a conclusion. We have to follow this, and we have to for settling of any claim. We cannot go beyond this. So now,
how you can tell that?
Because there is the IRDA regulation says the IRDA as well as the Supreme Court has stated in many judgments that the survey report should be given.
But also stated that it can be under challenge in the court.
Yes, that's why I'm coming. I'm coming, Lordship. I'm coming. So now,
can you tell me?
So now this is
9.2. 9.2, can he come to that conclusion?
I'm coming to that, Your Lordship. So now this has
Give
become.
the answer 9.2.
I'm coming to that. I bow down before Lordship. Now that, so now from this a dispute.
Give the answer, sir.
I know,
That's why
I have heard.
a very bad habit of this court putting the question. 9.2, give the answer whether this what you say, this what you say, the surveyor can give this. What is the duty of the surveyor?
This is an opinion, Your Lordship. As per my understanding.
What is the duty?
To assess the loss and
Then-
to give. Your Lordship, now what my submission is today, Your Lordship, now it has become a disputable facts. For disputable facts, the petitioner has to challenge this survey report. They have not challenged this, and and they have to prove before the honorable court or before any other court of that this survey report.
Have you served this survey report?
Yes.
When?
With my affidavit in opposition, we have served.
In the affidavit, when the survey was conducted?
That instruction.
Reputation, where is this report report you are dealt with? In the reputation, where is the report you are dealt with? Show me any line.
But we have served, Your Lordship. I have to
Tell me, in the reputation, if you are not dealt with, how you can deal with the reputation now? If you are dealing with you rely upon this reputation, then the petitioner would have been get an opportunity to this reputation, this survey report.
Your Lordship, paragraph 2, Your Lordship. Upon receipts of Your Lordship, the last line, the paragraph 2, the investigation was completed after extensive verification, including scrutiny of records, policy disclosures, and information.
There's a survey report.
Yeah, upon receipt, I will start reading from paragraph 2, Your Lordship.
Yes,
upon receipt of the claim, intimation reporting the death of the insured in a railway accident, the company undertook a detailed examination of the claim and in accordance with standard insurance practice, appointed an independent investigator to verify the factual metrics disclosures made at the proposal stage and compliance with the principle of utmost good faith governing insurance contracts.
Correct.
And the investigation was completed after extensive verification, including scrutiny of records, policy disclosures, and information obtained from multiple sources.
Okay. Yes.
So
anything further?
Nothing further, sir.
Yes,
Now, Lord, I take the last point first of my learned friend. Your Lordship has considered the report of the so-called investigating agency.
Yes.
My humble submissions, if Your Lordships, their conclusion, my Lord, at 9.2, in not regard to my claim either. In regard to the astonishing mysterious fact, this is beyond their purview. Even if Your Lordships kindly consider impugned repudiation letter, Your Lordships will find that the my learned friend place paragraph 2 appointed an independent investigator to verify the factual metrics, disclosure made at the proposal stage, and compliance with the principles of utmost good faith governing insurance contracts. That's now what they have said, Your Lordships. They have said that Your Lordships kindly come to page 117, paragraph 9. While the company, even the investigating agency doesn't dispute the police report also, company does not dispute the death of the insured occurred due to an accident. It is well settled that the occurrence of insured event does not cure defects in the formation of contract. A policy obtained by fraud.
That's why I'm asking, because they have not relied on that.
That's why there's totally different perspective they had. Now, I have to deal with Mr. Jadav's point. If you look at page 26.
Yes, you have to give the answer. Zero. Why you mentioned the zero?
Oh, sorry, sir. I'm sorry, Mr. Singh. I'm sorry. Now, Your Lordships, this is not the e-proposal form. I give Your Lordships the current e-proposal form, the company, because I submitted, I can't have a copy. This is the e-proposal form. Your Lordships will not find any clause like this. What happens, Your Lordships? After filling up the e-proposal form and after making payment, this pre-filled form comes to the insured persons. Where this your lordships will find I have annexed it. I have got it with the insured policy. Kindly have a look at the entire, they don't have any clause. That's why in their affidavit, they do not say the column number, query, nothing. Your losses will not find in the affidavit in opposition. Your losses will not find any clause. This is the current one even. That's why paragraph 15, they have couched the language. Even if it is not there, this was my obligation. Why I'm saying is lordship, I will show to your lordship from that. Now this is after the insurance was done. When they are issuing the policy, this was the written proposal from personal accident. Your losses will find this was never in the e-form on the online e-form. Yes. Now your losses, this is your losses. Why I'm saying this is not the proposal form. Your losses, copy. Just a minute. Copy. Oh, I'm got it. I've got it. Now your losses, kindly take these rules, regulations. What is e-proposal form? Then your losses, kindly I request your losses tally with page 26. Then I will go to the date. Well, this was issued by IRDI, my Mr. Singh's client. Kindly see 2 Roman 6, e-proposal, electronic proposal, means a proposal form for an insurance policy filled in electric form by the prospect with his electronic signature. This has to be generated first. Then I can submit the e-proposal form. Your losses, where is that electronic signature? In this page 26. This is they have pre-filled in. And after that, before issuance the policy, they have given to me. This is your losses will find with the password. Now I take your losses a little further of this regulation. Kindly see your losses. Regulation 3, sub-regulation 5. When the prospect furnishes the details in e-proposal form, it shall carry his electronic signature. This is not the e-proposal form. My learned friend is pointing out previous policy. And then your losses kindly consider regulation 4, Roman 6. Electronic insurance policy shall be deemed compliant only when issued with digital signature in accordance with the applicable provisions prescribed by law. Is it that one, your losses? So I have done according to these regulations. And that's why my humble submission before lordships, in their affidavit, your lordships will not find any reference to page 26 because they knew it that this is not the e-proposal form. No reference to your lordships. I have disclosed in my petition because I got it from them.
Yes.
There is no column in this form. Now your lordships, my learned friend probably will cite your lordships. Kindly see that your lordships. Signature not verified, digitally signed. Jagat Joy Panigrahi.
This is issued by the company.
Exactly.
After we
I give that, that's your losses.
After we give the proposal, then once the premium is made, then they are giving the certificate of the.
Then your losses will find, kindly take your losses page 26. Period of insurance of the writ petition.
Yes.
From 25th September 2023 to 25th September 2024. When this was done, your lordships? At 1 p.m. 53.59. That's, this is one policy showing, that's the policy issues at page 28. It tallies with the time. This is one. Kindly, dear lordships, kindly come to page 30.
No, in that the e-form which you have submitted,
Yes.
what time you have submitted and when you have made the payment?
Huh? No, that's your losses. I'm showing the sample. Your losses will find at page 28. Kindly come to your losses.
Correct, correct.
But that's a sample. I can't have the e-proposal form because that's with their online process. Page 28, the first one, your losses kindly take your losses premium at the bottom, at the middle portion. Premium amount 2389, GST 429, total 2814. You also got it? And then stamp duty, rupees, and then receipt number. So, e-proposal form will not be accepted. Is not payment is simultaneously not made. This is the insured policy they issued.
Yes.
Then your losses kindly see the next one, page 30. I just point out your lordship, period of insurance, and then your lordship's timing. It's a different timing.
Why different timing?
Your lordships kindly see your lordships, 2:17.30 p.m.
Correct.
So first I then Malad, after some time I did it. Everyone was like that. I told your lordship, submitted your lordships. On the same day I did it, but on different time. All that I'm submitting, my lord, that this is in their my lord, system. They got my information. They could do it, did it. Now the policy, my lord, even before issuance of the policy, they could have checked it up. The point is, my lord, there was no column for the query.
Okay.
They have not said in the affidavit either. That's my answer.
Yes.
Look, how can I check up with regard to the policies taken by the other insurance companies?
What?
Not with regard to the other insurance company, not whether the petitioner has taken any policy or not. Not, how would it reflect then and there on
That's
online?
okay.
That's why I have to keep a clause.
See, page 26 to 34, which are relied upon.
Lordship.
Correct. 38. 38, 39, 30, 40. Relied upon. This is the certificate issued by you. This is not the form filled up by the petitioner. Online. It is not the online form. After filling up the online form, you are issuing the.
This is generated.
Generated. Correct. So if it is generated, because this zero, previous policy 0, cannot be in the hand of the.
Given to him, no objections raised. He has got a 15 days free look period. Nothing objected to.
What
no, with regard to the previous policies, it's absolutely on the basis of uberima fide. Milord, your salary is.
This is not uberima fide, my lord.
This is yes, Milord, because only on that basis, Milord, I shall be issuing the policy. Considering Milord, whether you are Milord, this 25 crores policy or 5 crores or 10 crores can be issued or not. And in normal circumstances, Milord, that is why Milord, what is material, Milord, that has been reflected in the Honorable Supreme Court judgment, which I will have shown to your
I will go through.
And Milord, this is digitally signed, Milord, by the insurance company. And once, Milord, this is also written, Milord, in case of any grievance, please come back to the insurer within a fortnight. Free look period is always there. Milord, nothing there, nothing. And Milord, when this, Milord, when the insurance policy, Milord, on the face of it, insurer doesn't refuse. It's only, Milord, when the settlement comes into the picture, Milord, then insurance company, Milord, looks into the details. Whether those who have, Milord, given with, Milord, in absolute good faith or not. Milord, your lordship, Milord, in the supplementary affidavit, Milord, your lordship has seen, Milord, that list of insurance policies, Milord, that perhaps, Milord, it was not reflected, not shown to your lordship. Supplementary affidavit.
Yeah, that is not denial. It is not denial. It is not that they have denied that other policy is not there. Not
always. I've never denied.
It is not denial that it is whether he has not disclosed, then the court has to see what is to be done in that. Yes. Here in concluded CAV. That's a 1304. And with regard to other matter?
Other matter, Milord, I was, Milord, because of this, Milord, though affidavits were ready, Milord, I did not affirm them in 2 of the matters. Milord, in one matter, the affidavit, Milord, got, Milord, affirmed. But my lord, with regard to for the two insurance companies, my lord,
No,
my lord, you will kindly give me, my lord, 2 weeks or 3 weeks time, my lord. In the meantime, I will affirm those.
record item number 8.
I'm for the respondent number 2, my lord. I'm filing affidavit opposition.
My lord, I am appearing for respondent number 3, my lord. My lord, the difficulty is I could not prepare the affidavit in opposition in.
Till the time, Joseph.
And the liberty was not there.
Nobody has filed the affidavit. No?
Oh, I don't think so.
Nobody has filed the affidavit.
Respondent number 4 has filed the affidavit.
Only respondent number 4 has filed.
My lord,
Who is he?
Wait, two.
Respondent number 2. Healthcare. The care health insurance.
I'm appearing for
You're appearing for 2. Respondent number 2.
I'm appearing for 3.
Malad, whatever opposition we have received, Malad, we are filing our reply to that.
Respondent number 2 and respondent number 4, 2 has filed affidavit in opposition.
my lord, 7 as well. My lord, 7 as well.
দুটো এফিডেভিট দিচ্ছে কেন?
Number 2, respondent number 7, 2 filed their respondent number 2, respondent number 7 have filed their affidavit in opposition after serving the copy to the counsel for the petitioner. The respondent number 4 has filed the affidavit in opposition along with the supplementary affidavit after serving the copy to the land counsel for the petitioner. The counsel for the petitioner has filed affidavit in reply, but you have not filed the supplementary to the respondent number 4. Supplementary you got it, the respondent number 4 has
No,
filed the
just
supplementary.
now I am getting it probably. I have not yet got it.
Petitioner has filed
Give me
affidavit in reply
supplementary.
to the affidavit in opposition of the respondent number 4.
Malad, that I have not yet received.
The
Not
petitioner
right, probably, Your Lordship.
give the supplementary affidavit. Where is the supplementary affidavit?
In this matter, they have not.
In item 8, my lord,
No, you respondent number 4. Who is appearing for us?
I have filed my affidavit opposition and the supplement.
Where is the copy? He has not received.
Yes, I have served the copy on mail.
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 Give a copy, sir.
क्या बोलते हैं?
To reply on
No
mail.
mail. दीजिए.
Huh?
All on mail.
In opposition filed by the respondent number 4. Counsel for the petitioners press for time to file affidavit in reply to the supplementary affidavit filed by the respondent. As other respondents are not filed the affidavit in opposition, the other respondents are given liberty to file affidavit in opposition within 2 weeks after serving the copy to the land counsel for the petitioner. The petition is liberty to file affidavit in reply within 2 weeks thereafter. List the matter on 6th August
Under the same heading, my lord.
under the same heading.
Much.
my lord, 2 weeks, 2 weeks. Still new test.
Wait, my lord.
So this is not connected with this, no?
No. Accident same, but the points are different.
No, the point is, what is the point in that?
My lord, I tell you, Lordship, point.
Then I will keep this also, then otherwise one judgment is delivered.
No,
then
no,
it
that will not.
conflict will be
That
there.
will not. That will not.
My lord, same accident, same death. In some cases, it has already been repudiated. In some cases,
No, the second matter which you are asking to what is the point in that with regard to the claim only?
yes, my lord, the same claim, my lord. The repudiation in some cases
Same
has.
claim, not the similar claim with different companies,
But
but the same
yes,
accident. But I tell
it
you,
has to,
Lord,
then it has to be CAB वाला है ना, उससे मत करो.
no, my lord, that should not be tagged with that.
No, I am keeping with that. The judgment will deliver some, otherwise it will be conflict.
No, I tell you, Lord, in that matter, my lord, the ombudsman tribunal has, or the ombudsman have declined to accept my complaint case on the plea that my claim amount is more than 50,000. So
No.
that's the point to be decided.
Reputation.
No, repudiation in one, but repudiation, I went to the ombudsman to that matter.
Correct. Then
Is it the
So that's a
submission of
different
my-
matter.
But is it the submission of my-
1304
in
na?
that case,
Though the counsel for the respective parties concluded the argument, full stop, the matter along with WPA 27584 on under the same head. Okay? Yes, next.
my lord, both matters will appear.
Yes, next. 12
My
o'clock.
lord, first one is CAB.
With.
Today's case is CAB.
No. I will keep that. I already recorded the argument completed. Let that be completed. I will pass some. Otherwise, it will be a conflict of the decision.
Bless you.
Yes.
Yes, wait, please, your lordship.
Yes.
Yes.
Your lordship has
indulge on numerous occasions based on which we've traveled abroad. We've traveled abroad. Now, my lord, finally, this matter has come up for hearing. That the LOC should not be sustained any further.
Before Mr. Banerjee starts, my lord, may I just indicate one?
Yes.
Lord, this is the my lord, latest instruction, my lord, I have received.
Evening.
If you lordship, my lord, can you see, my lord?
My goodness. So basically, when a matter comes up for hearing before the Honorable Court on final hearing basis, a document is brought on record to show that we are at flight risk when we on numerous occasions we come and go. And we keep coming and going because of your lordship. Seize paragraph number and the order was
Allow
passed.
me, my lord, to file a report.
How can this be permitted at this stage, my lord? If they want a fresh LOC, they should go before that.
No fresh LOC, that LOC was subsisting.
That the LOC cannot, my lord, we'll argue, my lord. You have the observation so and so. Further, due to complexity of group companies, so and so, so and so. Issue of the details of company, the officer of the hospital, the inspection not reach completion before recommendation by this would. So it is submitted pursuant to the report by the Central Ministry. These are all proposed actions. If your lordship sees DE, these are all actions which are contemplated and directed right now just to frustrate my claim. Whereas for the last 5 years, ED is investigating and they've not reached a conclusion till now. This is a large-scale misappropriation of public funds, from which of trust officer of lifting of NSC. But how are they showing the prejudice?
Yes.
So, my lord, what I am proposing to your lordship, my lord, subject to your lordship approval. But today, as on date, I don't have any report. But can you give us 3 weeks time, my lord? Let me, my lord, call for report, seal cover report. Let it be placed before your lordship, my lord. Your lordship peruse it. Then thereafter, my lord, it can be considered.
What remains after this?
No, my lord, it is.
What can be done?
May I just tell your lordship why this has come? Well, let's seize this, my lord. This is Delhi High Court. So far as my relative is concerned, comes down heavily on my lord, Union of India and others. And say, my lord, if your lordship sees the cause title, it is Anand Raj Kanodia, one of the family members. They approached Delhi High Court. Sees how Delhi High Court has dealt with it, my lord. Same LOC, my lord. Same LOC. What is pending before your lordships?
Same LOCs are different.
Sir, this is of January 9, 2026.
Yes.
And the central government will have passed an order on 23rd of April 2026.
I will not interject, my learned friend. When he submits, my lord, let me just show your lordship how Delhi High Court has handled the situation. My lord, first, my lord, I'll tell your lordship in a synopsis. First, the press. Then, my lord, paragraph number 2 is what he was suffering, and my lord, the fact that your lordship would see, he came to know, paragraph number 2, fourth line. He came to know that one FIR being number so and so was registered with Kotwali, Jaunpur, Uttar Pradesh. This is the FIR, right? On the basis of materials in the said FIR on 19/9/2021 ECIR. This is the same ECIR which is pending before your lordship, where the LOC in question is considered. The petitioner claims that to be residing in Delhi, operating startup so and so. Now, my lord, he gives his own details. Now, paragraph number 4 is with regards to him wanting to travel. Now, paragraph number 5, my lord, contains, my lord, this becomes of seminal importance, that petitioner contends that he is neither an accused in the FIR nor named in the ECIR. My lord, I'll just indicate to your lordship over here. Over here, the distinction is that I'm named in the FIR. Some of the people who before your lordship, some are there, some are not. The persons who've been named in the FIR, there's been a closure report. The closure report has been accepted by a court of law. It is not to trammel before a superior court. So today, Vijay Madanlal Chaudhary is triggering in. And that is the reason why the power of ED is also being triggered in. We'll come to that issue later. My lord, your lordship sees the rest. according to the petitioner, on the basis of the ECI registered, had
No,
already
what is
been
the
closed.
what is the FIR of this case?
Same FIR, my lord.
221.
Yes, my lord.
441.
Yes, my lord. This is the same FIR.
There are two.
220 of 2021.
220 of 2020.
Yes, my lord. Now kindly comes to paragraph number 5. It is contended that no FIR ECI is pending against the petitioner. Rather, ECI is registered against his family members remains under investigation according to the petitioner FIR number so and so, on the basis of which ECI was registered has already been closed. And since the ECIR is founded solely on the materials collected therein, its continuation view of the settled position law cannot be sustained. This has been argued before the Delhi High Court. Same facts. Now, so and so contains well settled principle predicate offense. Kindly comes to page paragraph number 6, right in middle. It is contended that the law is well settled that once predicate offense stands quashed, the accused persons are deemed to be discharged from all consequential proceedings. He further submits that the petitioner shall undertake to fully cooperate with the investigating agency as and when required. On the basis of on notice being issued, besides various
what
objections.
The court has passed an order. What the court has said?
My lord,
now they are disputed. They allow this. Go to tribal to.
He is quashed. The LSCs are quashed.
Where is that?
My lord, before your lordship comes there, may I just tell your lordship, invite your lordship's attention to paragraph number 21. Kindly, my lord. Just paragraph number 20 and 21 sees how your lordships have dealt with me. It's there already. Not exactly your lordship, but exactly this is what has happened to me. Before your lordships, by your lordships. 20 LSC appears to have been issued in so and so. Thereafter, a petitioner was summoned to join investigation on occasions. Kindly sees 21. It is pertinent to note that during the pendency of the writ petition, the petitioner has permitted by this court as many as 7 occasions to travel abroad, and there is no allegation whatsoever in misuse of the liberty or non-cooperation with the investigation. The date on the date of the order and the duration for which he is allowed is extracted. Now kindly sees this extracted portion. Now Malat sees 22. Thus, as of now, it remains undisputed that the petitioner has been allowed to travel abroad as many as blank occasions orders passed by this court. In such circumstances, the continued restraint imposed upon the petitioner by way of LOC operates as unwanted restriction on his personal liberty and right to travel under Article 21 of the Constitution of India without any contemporaneous justification. Mechanical continuation of LOC, despite the absence of necessity of the petitioner for investigation at this stage, renders the restraint prima facie arbitrary, particularly when the petitioner has neither evaded the process of law nor shown any inclination to obstruct the investigation. At this stage, it is noteworthy that the court is unnecessarily burdened in passing interim orders in such matters. The time spent in adjudicating such lists could be better utilized in dealing with cases involving substantive rights and pressing issues of law, and resolving such cases at first instance may lead to more efficient use of judicial time. Under these circumstances, keeping the principles laid down by this court in the aforementioned cases, the court quashes the impugned LOC. The directions are given by the petitioner to submit undertaking on the affidavit before the ED, and then from E to V, IV. So this is considering the fact that the LOC was that of the enforcement directorate in the same case, the predicate offence is closed. And the total number of cases which the Delhi High Court has relied upon, if your lordship wishes to see, from paragraph number 7 onwards.
With this judgment, same judgment.
Same judgment. No, it becomes important because it's fact-based.
Yes,
paragraph number 7 is fact-based. Because they speak about another offshoot of another case. They speak about offshoot of another case. Despite that, it is quashed. And the incident of fraud amounting to 991 crores as occasioned in UCO Bank flagship corporate branch Kolkata is brought to the notice. It's not that the court was not aware. And then everything of what the ED could have said is stated in paragraph number 8.
Yes, you have challenged this order.
No, so far as
What of the Delhi High Court challenge?
so far as this order was passed, my lord, that order was passed on 9th of
January 2026.
Yes.
19,000. So
Then
far as
April you have taken steps.
SFIO, my lord, the order, central government passed an order, my lord, under section 212(1)(c).
Correct.
Kindly see, my lord, it was on 23rd of April 2026.
Correct. April you have taken steps.
After that. Now, my lord, so far as this part is concerned, my lord, so far as SFIO investigation is concerned, the court did not have the occasion to deal with that. And so far as well, this SFI investigation and report and the central government order is concerned, well, today I am also handicapped. Today, well, I just have this document, well, I need, well, also instructions, well, to
2021 FIR. Now,
so far as FIR is concerned, well, closure report is there, repetition was filed. Now the matter is pending also before the Supreme Court. Other cases are also there. And so far as these parties concerned, this is, you also knows, this is an independent action by the central government on the basis of the investigation report submitted by the investigating officer. This has nothing to do with ED and other things. This is an independent action on the part of the central government.
How soon will file the report?
Give me 3 weeks time, I will file it.
Can I just say something, subject to what you're
It will come from Delhi.
The issue is, the broader issue is that certain regulations of RBI have not been adhered to, for which there has been particular banks suffering a loss. That is the larger issue.
From there only the cases are
right. So you have multiple cases, out of which cases have resulted in closures. The biggest agency, my lord, with greatest respect, was Enforcement Directorate. 6 years they've investigated. I have continued to go. I am trying to understand, how is it so that by incorporating a fresh investigative mechanism to see that there's been a corporate fraud of the same nature would put an extra restraint or an embargo on my Article 21 as discussed by Delhi High Court? What is his explanation to that? The proposed action of the SFIO to see whether I'm involved or not with ED, who's actually the main person who looks into transfer of funds from one place to the other. If they could not come to a justifiable conclusion till today, and with ED being on board, I have traveled multiple times with your lordship's order. How is the Delhi High Court order being in variance?
That's correct. That's correct. Now something has come before.
I have not paid for quashing of the SFIO. My lord, so far as there's a quashing period also. My lord, I'll keep it at abeyance. I'll not argue so far as quashing of ED case is concerned. It's only LOC which is the issue, my lord. Then again, my lord, Delhi High Court's last line, that multiple times I would love to come back to your lordship. This time I will travel to some other part of Southeast Asia.
2,300 crores.
Indicating
2,300 crores.
Whichever the amount of crores would be, I would be coming.
Yes. Completes only, because in the manner adopted by referring to the order passed by the Honorable President in Anant Raj Kanodia matter, to cut short the entire matter and to show that while your lordship or this honorable court in these 5 particular petitions belonging to the relatives, friends or whatever of the same group was allowed to travel outside India on multiple occasions by this honorable court on interim stage. And that is the sole reason not to continue the LOC. Your lordship has already seen that.
Yes.
Honorable Delhi High Court has never held that issuance of LOC was wrong. LOC was illegal. Honorable Delhi High Court has only held paragraph 23 and 24. Your lordship can read again. That
by taking into consideration of this instruction, now Mr. Tiwari and Mr. Chatterjee will come with the notification of 23.
Your lordship got it.
Clause 5, II.
Well, your lordship is giving them the idea now.
Senior friend completes his argument on merits, if any factor. I show you, lordship, that this is not a case on 2021 FI. I'll show you. Let him finish first, then we will answer.
No. First, let the because
let the report come.
Let me file the report. Let me file the report.
Yes, let the report come.
I will deal also.
Yes,
no problem.
Your lordship will deal with it. We don't have we have no doubts about it. Knowing your lordships, we have no doubt about it. Just one thing I want a clarification. I
already indicated why this.
I understand. But my learned friend tried to indicate something. Possibly his counterpart in Delhi had some other thing to say before the Honorable Delhi High Court. Whatever is there is on record. Yes. So let my learned friend not say that this was, my lord, three facts. Named in the FIR, not named in the FIR. If the issue is absolutely inconsequential because it has resulted in a closure report. A. B is that
That's why I wanted to see what the SIFL will do.
Yes.
After
If
that,
your lordship so says that, gives this 10 days.
Closure report, the fact of this closure report is half fact of this entire case.
don't know. I don't know.
But kindly come to that judgment once again. Kindly come to paragraph 7.
Then you challenge it before the Supreme Court.
I'm not supposed to challenge it.
Huh?
My learned senior has made his submissions. Can they allow me to show
Yes,
from
yes,
that judgment, paragraph 7?
Yes, yes, sure.
1991.
Kindly come to paragraph 7.
Yes.
Paragraph 41 of 2025. That is not a closure report.
New effort.
Closure report is in 2021, which is pending.
Despite this also, this is exactly what I told your lordship.
Okay, let's. So you
No, my lord, I beseech your lordship. My lord, may I just tell your lordship that they have, don't worry. But may I just tell your lordship, they had a lot of time. This was kept for final hearing. Gives them 10 days time. We'll come back.
Again, I have to come and ask for extension. Give me 3 weeks time, in the meantime, I'll
Within
submit.
10 days, they can't
when the
It will
next
come from
let me consult my diary. What is what is the shortest date? Then I
At your lordship's, my lord.
will see to that.
my lord.
What is the
Your
shortest date?
lordship. Your lordship. If only Mr. Chakraborty would have gone to Delhi, it would have been better, I think. Better representations would have been made.
I have placed that my learned senior at least thought my name.
Of course, I do.
At least.
Very worthy, very, very worthy.
कितना बजे? 17 July.
Grateful.
2 weeks is there.
Yes. And my lord, let them serve a copy of.
Yes. No, let they come. Because it
I
will
need
come
to
with a
seal
report.
cover,
Let they come.
Now imagine the situation. He gives something in a sealed cover.
Next.
And my touchstone of argument is Article 21.
Right.
Where
No, that's why if it is that, then the court will
Yes,
provide.
yes, yes,
No
yes, yes,
problem.
yes. Because my lord,
Now, here also I find LOC is also not been given to the.
yes, my lord.
It is coming under. So then I have made the provision. Now it has to be.
Yes, yes.
Can I be on
With
25?
your lordships there, my Article 21 will not stand infringed. Grateful, my lord.
Can it be on 21st because 16th is not so everything.
He's going to Delhi.
No,
No, he's going go to Jai Jagannath. He's going to Puri most of.
देखो 21 तारीख को देखो.
On personal grounds, I have nothing to say.
22nd.
No, personal ground बोला मैं किच्छु बोला.
22nd.
I'll never say.
Thursday, Wednesday. Okay, 22nd.
I'm a passenger. 22nd.
Yes.
22nd.
Well, your lordship would kindly keep it at 12. Grateful, man.
Though the matter is specifically fixed today for matters are specifically fixed today for hearing, but the learned counsel for the we are appearing for the Union of
India and the Ministry of
Union of
Corporate
India.
Time to record the Union of India.
Union of India prays for time to file report. Accordingly, for the interest of the sick case is adjourned. Let the report be filed on or before report be filed on or before 22nd July 2026. This is the matter.
Let the report be filed by SFI. Kindly specify it. Otherwise, it will be
Bring
difficult.
the report. I will not. Let the matter appear on 22nd July at 12 noon as specifically fixed.
Grateful. Well, all five.
All matters.
Grateful.
There's
Your Worship, the SFIO may be added as a party by the petitioner.
yes.
So far as the SFI is concerned, let them. Already SFI has not been added. Let them add SFI as a party.
Let the file the
infringement.
why you are making so all the let the report.
Grateful.
All interim orders were timed.
Yes, next.
Big handicapped in this matter.
You are Jagannath.
I don't need hands.
How you can be handicapped?
That's it, I don't have.
This similar matter has been moved yesterday. Is the IOCL matter, my lord? Your lordship has heard Mr. Abhitosh Majumdar was moving, my lord. I was only beseeching your lordship has issued an interim order, my lord. But my point was very simple that
the date of the RCs were showing
That's the same.
a different date when the date couldn't have happened because the invoices do not tally. But I've made two charts, my lord, which I can hand over now, or I can put it in a supplementary affidavit if your lordship wants. Your lordship will kindly direct. Well, the same direction, on the same day.
No
Then I think that will endure. And well, only one thing, my lord, that the entire thing that it will abide by the result of the restriction, my lord, this time.
Well, it is always there.
Always there.
It is always there.
See, yesterday I not done. It is the then.
And you did not ask for it.
No,
He
they
asked
are
for an interim order.
interim order.
He asked for, I'm not asking for an interim order.
So that's why you kept today, not not along with that
I
matter.
wanted the first, your lordship, sorry, I wanted that Friday. Your lordship get it on today, my lord. But why I'm saying this, I'll just point out why, my lord. Then why I'm saying this, my lord. It just gives you 1 minute's time. Your lordship is aware of the facts. My lord, they had taken the point that under clause 10, my lord, it is premature. But that submission, man, I've heard the entire thing. But yes, that's why I'm saying.
No, not premium. Whatever the argument, this court is of the view with regard to what are the conditions the IOC is only to see with regard to the registration of the vehicle in question. Vehicle, as per the terms and conditions, is the registered owner or not on the date of inspection, on the date of before issuance of the LOI, and on the date of the opening of the tender. Correct. Now you are taking the plea that yes, RC is there, the smart card also be generated, RC was there, but you find the document, RC is on 9th April and the invoice is on 11th April. So how if the invoice is in 11th April, how the registering authority have registered the vehicle? This is the question.
Just explain on this one. I'm absolutely well, there is a clause which says we'll not look into the RTO at the time when the bid would be considered.
Correct.
But
issuance
there is
of
also a clause that LOA, before LOA, that will be.
Yes, they will consider the LOA. They will consider with regard to the document registering document.
Registering document.
Correct.
Not only registering document, any document.
Whatever it is. So any document with regard to the vehicle. With regard to the vehicle, what you required? You have to see the insurance is there, or whether you are having the permit, or whether you are having the registration in your name.
And only one thing, what means when they are going to verify the RTO verification. Now, on the date when the bid is submitted, after that they cannot. So the only thing which they would have to verify is whether on the date of submission of the bid, the smart card was given or not. That they have not verified. Without verifying that, it's the state office. It's the tendering authority themselves. They can't show the state office and say it is not the tendering authority. State office and their tendering authority, the same person.
Yes, officer.
So that has not been looked into. Let them file a report with that only. If it is found on the date of the bid, they did not have this on the date of the bid, then they are disqualified.
No, because if I will say, okay, you produce the affidavit in opposition, disclose all the bid document, then it will be, I think, how many bidders are there?
Now they selected, 9 bidders have been selected.
9.
I am only submitting, let them put it on affidavit that on the date of submission of the bid.
That's why then in that case the total bid document has to be produced before this.
And not only that, each one bidder has offered 8 number of tank trucks, and there will be supporting documents in respect of 8 number of tanks. So
I have already put that in my petition, so he will have to reply to that if your lordship directs affidavit. So that he has to do. The only thing why I am now submitting, in the event it is so found that these are not there, and it was wrong.
Then automatically.
So that is why I said that the petition. Why I am saying, I have only shown your lordship, NG projects and others I had shown in your lordship, damages is there, I know the law. But here, in the event, this clause is there. If it is found that there is no one, or rather that there was no document on that day, they will have to cancel. Then they cannot say, I'm cancelling the entire tender process. That is, I said, subject to the writ petition. Only that much I wanted from your lordship.
That clause is already there. Like we can always take steps.
Let the file affidavit.
Yes, I'm not asking for any interim order at this point. I cannot. Your lordship has rejected yesterday. So how can
one thing, my lord, in the earlier application, your lordship has seen that there is a representation.
Well, there is a representation. I'll put a.
Okay, that
I have done it, but it's
the
I'll have to give a supplementary for that one. It is there.
this court find that in the similar matter, the similar matter was taken up by this court on on 30th of June 2026, and this court has refused to grant any interim order and direction was issued for filing affidavit. Accordingly, in the present case also, the respondents are directed to file affidavit in opposition by remember that date?
Yes, 3 weeks.
3 weeks. Reply if any,
The 7th of August. That
reply if any that will be filed within 2 weeks thereafter. Release the matter on 7th of August.
Well, may I just hand over yesterday's number so that it can be tagged together, man?
Well, number give the along with WPA number.
Well, I will just give man to your lordship. And man, leave to file supplementary affidavit, man.
Yeah, the petitioner is given liberty to file supplement as per the prayer made by the counsel for the petitioner. Leave is granted to file supplementary affidavit, subject to after serving the copy to the land counsel for the respondents, and the respondents are liberty to file the affidavit, file a comprehensive affidavit of the writ petition along with the supplement.
Very good. Very good.
Good.
15.
15 हाँ कब हो गया न्यू फाइल से चले गया
Brief to the Baba.
yes 15 yes
My lord, the petitioners have, my lord, challenged, my lord, a debarment under the adoption regulations, my lord, which is formulated under the Juvenile Justice Act of 2015. Now, my lord, on the adoption, in terms of the adoption guidelines, my lord, a prospective adoptive parents, my lord, the petitioners before your lordship are eligible to adopt children, my lord, between 3 categories, my lord. There is
under CARA.
Under the CARA guidelines, my lord. My lord, there are 3 referrals, my lord, a prospective adoptive parents can receive from the date of registration, my lord. Accordingly, my lord, 3 referrals received. My lord, first referral received in, my lord, although it was registered, my lord, we registered in 2020, my lord, first referral received in 2025. Second referral received in the latter part of the year of 2025. My lord, lastly, my lord, we missed the first 2 referrals. The last referral, my lord, was given to us in the year December 2025. My lord, if we would have missed that referral, my lord, our seniority list, according to the CARA guidelines, my lord, would have reached the bottom. My lord, we were appearing as serial number 1. Our seniority was reflected in the guideline, in the registration portal as serial number 1. However, my lord, we missed our chances.
Serial number will be registered as per the application.
Yes, my lord. Our serial number was 1, although, my lord, the first referral came after 5 years. My lord, we missed the first 2 referrals, my lord. The third referral came in the year 2025. My lord, thereafter, my lord, what has happened, my lord, is very interesting. My lord, after the referral is received, my lord, the credentials of the child is given to us. My lord, after inspecting the credentials of the child, my lord, some discrepancies are found. My lord, the lordship kindly takes the guidelines, my lord, the adoption guidelines.
Yes.
Lord, kindly takes Regulation 9, my lord. Priority of adoption referral. Regulation 9, my lord.
Yes, priority.
My lord, Rule 2. All prospective adoptive parents shall be able to indicate whether they want to adopt a specific category of child having special needs and shall be able to reserve a child from the hard-to-place child category. My lord, at the time of registration, my lord, we had placed our preference from the immediate placement category. My lord, this reference was not made by us. So, my lord, we did not opt for 9-2. So, my lord.
Yes.
My lord, the petitioners are both 50 years and up. My lord, Lord, adopting a child with special needs, my lord, comes with a lot of responsibility, my lord. However, my lord, the petitioners were not equipped, my lord. Still, perhaps they are not equipped, my lord.
So you have
Yes.
applied for the as a
Immediate
normal
yes,
process.
immediate placement category. So, my lord, after the referral is received, my lord, the medical reports are forwarded to us. My lord, we inspect the medical reports, my lord. There are discrepancies found in the medical reports, my lord. The child is diagnosed with health issues, my lord. That is given to us for the first time in the medical report at the time of third referral. My lord, we pointed that out, my lord. A grievance portal on the grievance portal, we pointed that out, my lord. The grievance is forwarded to the concerned authority, my lord. Sara forwards it to Kara, and my lord, these specialized adoption agencies, my lord, they look into it and they issue a reply to me stating, sorry, that is a different medical report that we have forwarded to you of an abandoned child who was with us at the time when you put this referral to us. This medical report is perhaps not the child, not of the child that has been allotted to you. Well, naturally, my lord, we were in the dark and we did not know, my lord, whether at all this medical report belonged to the child that has been allotted to us or some other child, my lord. Because, my lord, by their own admission, there is a specific confusion that is raised, saying that this medical report is perhaps the wrong medical report we've forwarded to you. Thereafter, my lord, we requested them kindly expedite the process, because if I fail to reserve the child within 48 hours of the third referral, my lord, I will lose my third referral forever, and my lord, I will be debarred for a period of 1 year. My lord, I'll have to issue a fresh registration, and my lord, the seniority goes back to the bottom of the list. Now, my lord, if the registration, my lord, if the debarment is to continue, my lord, the outer limit of an adoptive couple, my lord, the couple prospective adoptive parents, the outer cumulative age is 110. My lord, the moment I cross 110, I'm ineligible to adopt children forever.
110?
Cumulative age of the parents, my lord, of the couple has to be within 110. So, my lord, I was already 109 when the third referral came. Lord, I was debarred thereafter. My grievance was closed, and I was told you have to go for fresh registration. Now, my lord, if this debarment is to continue, my lord, I'll have to go back for a fresh registration, which, my lord, takes me to the year 2027, my lord. After which I will cross 110 and I'll be 111. But I'll be no longer eligible to adopt.
Where is the department order?
Yes, my lord. Lord, kindly takes. Page 45. Lord, kindly takes page 45.
40?
5, my lord.
Online department?
Yes, my lord.
In 190.
My lord, perhaps it's a bit unclear, my lord. The second line says,
no, as per the referral status, your profile, you have been referred with the 3 referral.
Yes.
Why?
My lord, I missed the first 2 referral. My lord, the third referral was my last
First
chance.
2 referral you refused. You are
No, my
not.
lord, we missed it.
Okay.
We missed it. We couldn't select our preference at the time of the first 2 referrals was issued. Now, my lord, kindly takes this in light of what has been issued to us with the medical report, my lord.
So what is the ground for challenging?
My lord, ground for challenges, my lord, twofold. A, my lord, if, my lord,
You are not ready to adopt the child due to the medical health issue, whatever is.
my lord, the health report itself was
Where is that?
Yes, my lord. Kindly takes page 36.
Forty-six.
36, my lord. This is in reply to. This is in.
Now that child has been given in adoption or is still with
No,
the home?
We don't know, my lord.
Already given or
Given
adoption?
in a normal category.
Huh?
Given under normal category.
Normal category.
Yes.
So what?
My lord, kindly takes this email, my lord. In connection with the above mail, the child Anamika has age-appropriate language development, which is mentioned in her medical report dated so-and-so, and her BAER study of both years are also attached. The medical officer of TLG SG hospital remarked that the child is health and developmentally normal and age appropriate in her MER dated. So this is for your kind information that the prescription attached in the previous mail dated so and so was the observation of the abandoned child who came into our GSSAM home on 28th July 2025.
Yes.
So, my lord, the medical report that was furnished to us, my lord, we are unsure whether it at all belonged to the child that was referred to us. B, my lord, from Regulation 9.2, my lord, I did not make this selection. My lord, with the deepest of respect, my lord, as I said before, my lord, parents willing to adopt a child have in fact, my lord, put in their preference. My lord,
Correct.
put in the
That's why,
preference of
see, third term, your turn has come and child was there and the proposal was given to you,
yes, my lord.
but you had some doubt.
Yes, my lord.
So what the authority will do?
Lord, doubts, my lord, we requested them to address the doubts. Instead, what they do is they close the grievance and they debar me
They have
forever.
given this but 36. They are telling that that is not the with regard to the same child.
Lord, that was
Inadvertently it has come.
concordance with the previous medical reports.
Hmm.
Therefore, my lord, the referral
Previous
itself,
medical report means?
my lord, the medical reports that were handed over to us with the email, my lord. Lord, kindly takes. Read it, Chief.
Medical officer of TLG also remarked that the child is health and
Lord,
developmentally
page
normal and
38.
age appropriately.
My lord,
In
page
her observation.
38, the CMO has given the report which is mandatory for addressing the grievance. My lord, the medical reports, however, my lord, I must indicate, Lord, forms part of the attachment of that email, my lord. However, we have not annexed those medical reports, my lord. We are carrying everything with us, my lord.
Medical report of the same child?
Yes, my lord, the attachments. Now, with your lordship's leave, my lord, Mr. Sharkar is leading me.
No, you can.
My learned friend was arguing very well, which is why I didn't.
Yes.
Copies, give copies. To take out the copies in that case. Why do you give it like that? Be rich.
Yes.
Triple C, there's inability to speak. Kindly see the diagnosis. This would indicate that the child and the name and the details would be the same. So it leads lordship to a situation.
The name of the same is same.
Anamika. That is what we've seen. Then we are told it's not the same child, but evidently there's been a mishap. Now, lordship all the time submitting is lordship will see that there is one part of my matter, lordship, which is what legal right would I have. The other part of the matter, lordship, as lordship can see from the facts, lordship, I believe there should be some space for sentiments in justice. My lord, in this case, lordship understands this is a couple. Lordship wants to adopt a child.
Okay, this certificate, this document, when it was forwarded to you?
My lord, this was part of the email, which is at page
38.
Lord.
38. 38. No, 38 is the mail dated. What is the mail date?
Just Lordship will give me a second. It's too small.
24 December.
It's too small. Lordship, this came on 24th December 2025.
Yes, 24 December.
At 2:54
And prior
PM.
to that, this page 36.
Lordship, page 36 is at 24th December 2025 at
1:34 PM. First, this was given to you.
Lordship.
So first mail is the 36, page 36.
Lordship.
Correct. Page 36 is 24 December at 1:34 PM. Got it?
Lordship.
And in that case, can you see the age appropriate? So there is nothing. The prescription attached in the previous mail dated 9th August 2025. Where is the 9th August 2025?
Where's 9th August? Lordship will kindly give me a second.
This is with regard to the 9th August,
Lordship.
not the 24th August.
So, Lordship, what happens is thereafter on 24th December 2025, they give me that clarification.
Correct. That's why
Lordship.
the first the child, the name which was the proposed child, which is to be adopted by you,
Lordship.
that started on 9th of August. Which date? 19th of August?
19th of August, Lordship.
19th of August.
Lordship.
Kindly come to the page 36.
Lordship, I've come.
Correct. Age and appropriate development, we mention the medical report dated 18 and so and so and so. But it is but the previous mail, 19th August was observation, the abandoned child.
Lordship.
So now, December 2024, it was informed to you.
Lordship.
And this.
But the name is the same, Lordship will
No,
see.
let me understand. It is 134. Then thereafter, page 36. Page 36, the document was given to you.
Lordship.
Which document? What are the document of page 38? Which you are referring? That is
Yes,
not
this
the.
one. 165028. Where is this? 165028. Where is this document?
Yes, Mr. Lairi,
Where is it?
you have to show me whether on 24th of December 2025, this is the certificate, this is the mail sent to the petitioners that no, there was some miscommunication, some other document has went to them with regard to the abandoned child. Correct. Then on 38, page number 38, you have sent the medical grievances. In the CMO report is mandatory addressing the grievances. After that, where is the medical document given to the petitioner of the child which likely to be adopted by the petitioners?
But kindly takes paragraph page 39. There are 3 reports which are attached.
39.
Problem is the mails have been given without the annexures. 39, there is, see, MER Part E PDF,
Medical report Part E, medical report Anamika, and medical report PDF. So what are the, so now the only question here. Question here, admittedly on 19th August, the document which was provided to the petitioners with regard to that was the abandoned child. Correct. Subsequently on 24th of December, you have clarified that. On the clarification whether the medical document was provided to the petitioner or not.
Yes, kindly comes
Where
to
is that?
paragraph 37, page 37.
What are the documents?
MER of Anamika 1605, that is there.
So where is that? What document you have received? What document you have received on 25th from the medical superintendent?
Malad, I believe.
CMO.
Malad, I believe. Malad, my colleagues are not being able to find that document. But what I believe is that what was sent to me revised was apparently that this is a normal child. There is no problem.
Correct.
Now, Lordship, I kindly.
So then on 24th of December at 3:23, you received the document with regard to the normal child.
Lordship.
What has happened after that?
Now, Lordship, whereas I sought that final clarification and I received, Lordship, kindly appreciate that the parents' condition, my lord. 2 contrary reports, they were unable to really gather which is the truth because admittedly there was an error.
That's why I wanted to know. Correct. Till 24th at 3:30, it is correct. Then you have received the normal report.
Lordship.
Now you have a doubt.
Lordship.
So there is a doubt has been created in your mind because you are adopting the child.
Lordship.
So why it has been happened?
Lordship.
So after that, what has happened?
Well, after that, I am debarred. After that, I am debarred. Well, after that, Lordship will see January 12, 2026, page 41. It is to inform you that the child Anamika referred to you has been declared normal by CMO. CMO report is attached for your reference. Hence, the grievance raised by you
when
is
the
closed.
CMO has given the report.
Malad, this has we do not.
So that's why I wanted to see with regard to the page number 34 on 24th of December. at 3:23, whether the
Lordship.
normal report was given to
Lordship.
you.
Lordship.
After receipt of this normal report, what the correspondence made by you?
Thereafter, the next correspondence is that I'm debarred.
No,
And it
you have
says,
not- you could have been. You
we
should-
could have said, there are two things which could have happened. We could have said that we are still in doubt
Correct.
because which is why we are unable to kindly give us another referral or an alternative arrangement, or we could have said we will take this child. Now, my lord, as far admittedly on record, we do not have a document. The next document we get is January 12th. Now, my lord, evidently, I'll be very forthright, lordship. Lordship sees the facts. I cannot improve the facts. There has been, my lord, this could have been dealt with in a better manner. However, lordship, we have only come up before your lordship for only one reason. Lordship will kindly see the substantive, which is why the first thing I said, lordship, was kindly consider the sentiment as well. It is not a litigation where we are contesting against any party. This is not a case of where I have something adversarial.
Problem is that now the problem is that what are the serial numbers in the are there?
I have no instructions regarding this.
Well, only if something could be done, if another chance could be given. It's really a prayer before the court, lordship. I leave it to my lordship understands we have come with our limitations, but it's only because it's under normal circumstance we wouldn't have.
See, something on after 24th of December, when you have received the normal report of the child from the CMO, you could have been.
Well, we could have made a formal communication.
Correct.
But all that I'm saying is
not made a communication. What is the wrong committed by the authorities debarring you in the month of December? Because 6 days,
Lordship,
what is the date of the debarring?
Well, 12 January 26.
Then 15 days was there.
Lordship. Now, my lord, may we do one thing if it commends to my lord, only considering the fact that this concerns a case of adoption. The annexures which are there, may I ascertain them, lordship, because my lord, I never got the chance to see all the other documents myself because not annexed. May we ascertain that? I'll do a supplementary. I'll come back tomorrow, day after tomorrow, whenever my lord pleases. Lordship kindly gives this a chance. Lordship understands this is not going to take much time, but
take instruction. This is with regard to some communication gap that has been happened. There's some communication because of this giving the one. Naturally, if one document has come to you, secondly, one document has come to you, there was some communication. Only to see take instruction from, because now 1 year, what is the now 110 years?
The fact remains that if he is debarred, he can.
Not going on that.
No. What I'm on is, my lord, what I'm saying, want to say is that it remains a fact if he is barred for 1 year, come January 2027, he crosses the threshold. That is a fact.
Correct.
He crosses the threshold. So his window is only this, a fair chance for this third. The only thing is
new one, not third.
No.
Correct.
Third revival with a new child.
Correct. That's why. No, that revival. No, what the court? I am now thinking, because this is not a negligence on the part of the petitioner. Totally. There was some doubt created from receipt of the one document. And this is the case with regard to the adoption of the child, the life of the child and the life of the parents. Correct. There was some mistake or whatever it is from your side also for forwarding the letter. So take instruction, because what is the age, what is the cumulative age of now as on date of both the
1 year, brother.
Now we are 109. So by the time the next 1 year period will get over, we'll cross 100.
That's why you have to see two things. What is the serial number of revival? Within 1 month year, it is not possible. Then how the out of turn it can be taken into consideration.
The only thing, my lord, who can happen, this is from my side, is to sensitize this. They get back their position number 1 and they get a child immediately, because otherwise it's not possible.
That's what I'm telling.
I understand, my lord.
That's what I'm telling.
That is the only thing that can happen in this litigation. Is this
No,
rejection gets set aside?
See, again the third party interest will accrue. That is also to be seen. If the child is there, the other person is there, they are in waiting. If this will become out of turn, then there'll be again might be again a litigation. So then the court has to see all the balance and has to pass. So you will see whether any further child is available at present with the home.
And Lordship, if my learned friend can take a little cooperative
at the
view,
home. If
maybe
it is
without a
there,
precedent, we can
if
solve
they're
it.
there, when with the order of the court, it can be
Lordship.
taken into consideration of the cumulative age and the circumstances of the fact.
Without treating this as a precedent, it may help everyone. in that.
Circumstances of the
I will
case.
try to convince, my lord, but
See to that, please.
I will
see
try
to
to convince, but my lord, from the time instruction has come, they have been very rigid.
Huh?
From the time instructions have come, they have been very rigid.
Now that it's I would just.
I have
request my learned
tried
friend.
to convince them.
Please, please.
I have tried to convince them, but from the time the instructions have come,
These
they have
two
been.
things, these two things is to be taken into consideration, because if we go revival 1 year time, and in the revival if the senior now serial 50 and 1 year only
No, the first thing today morning when I asked them is after 1 year, if they get a chance after 1
Correct.
year, but they are out of the scheme.
that's I'm telling, that will out of.
Out of the scheme.
So that is to be taken into consideration. This is not only totally mistake of the PTs.
No, but my lord, the problem is the offer is as on 23rd, not on 19th. The offer is on 23rd.
Correct.
So within 22nd. So as on 24th was the window of 48 hours. So within that window, they had said the mail that we have received the document prior. So kindly explain. And we have explained by saying that no, the child is normal.
But it left us with a very short window.
That is the problem.
Very short.
That is the
And then they filed their statutory appeals and everything. And 12th of, well, kindly sees
12th of January.
Okay, see how can we
12th of January we say that the CMO has certified that the child is normal.
When you will come? Take instruction. Because only to see with regard to the age, because if they will go for the revival, 1 year will be completed, then it will be difficult.
The only thing Lordship will see is I get it in the afternoon of 24th. I'm left with a few hours to take a decision for an entire lifetime. That's the only thing, Lordship. There's a reason. But there's a reason why.
This could have been think of when you receive the letter from the CMO.
24th.
Silent.
But I had only those few hours to address.
And we come back on 7th or 8th, Malad, because 6th there may be a holiday and monthly list.
Come on 8th. Though the land counsel for the parties has argued the matter at length, full stop. Then the counsel for the respondents prays for time to take instruction. Accordingly, case adjourned, let the matter appear on 8th within 5 matters.
Most obliged.
This has also happened here. I will. I can take it. Everybody knows. Let Mrityunjay Pali used to do like that. One judge, Justice Haridas Das. He never can. Normally case. Came.
क्यों नहीं?
Yes.
एकटाও নেই।
My lord, I will be no more. There is a rumor here that there is a book written by late Justice Tarun Chatterjee, edited by Justice Mrityunjay Pali, Law of Adjournment. One instance, one matter is going on, second appeal. Judge is reluctant to grant adjournment. Justice Tarun Chatterjee was the lordship was in the bar. He came. 6-0. And in that, one can recall, SCC is coming part-wise.
Part-wise, yes.
My lord, there is a judgment.
WP না পুরো নাম দিতে হবে।
Interest is not come.
এখানে তো
Kindly adjourn this matter for the next year.
হবে।
My lord, we are for Union of India in this matter.
Which matter?
This
Mandar Hotel
scenario, even our there's some affiliation of some political now has to be changed. This, that, and there is no affidavit also.
Item 58.
It cannot be harder.
58 to
64.
58 to 62.
58, I am appearing for Union of India, Your Lordship.
Till 64.
64.
Yes.
This is in respect of the Mandarmani hotels or the CRJ is actually affected or not. That was a matter of challenge. So the minimum first ground was GRT.
NGT.
NGT.
Jurisdiction to constitute a bench. This is the first ground.
Yes.
I am fortified by the judgment of the
Constituted the bench.
Bench.
Taking other judicial members from other place and fixed it. There is a Supreme Court judgment, you cannot do that. So, whenever I will be arguing this matter because
committee to পরে হলো bench
my lord,
all petitioners, you are appearing for the all petitioners?
Yes.
All writ petition. Who has not filed the affidavit?
The Central Pollution Control.
You didn't
We have to file the affidavit. No, the affidavit is there is 60 and 61.
Yes.
60, 61. Affidavit almost ready, it is not yet confirmed by the office. That's why and some accommodation is.
In all matters, after serving the pollution control will file the affidavits in all matters.
It appears in Lordship's order.
Central
Control Board
filed affidavit in opposition in all matters.
59, nothing has been filed. Item 59, I am for the petition. It has not been filed.
Not filed. But that on the last occasion it was mentioned.
Yes, mentioned, but
they're not.
Even some of the advocate records of mine said they are not received.
Yes.
And WPA number 2015, praise for extension of file affidavit in opposition.
Not filed.
Okay.
Number kota.
So how when the advocates all are appearing or not?
Yes, 66 to all the respondent time.
Your Lordship, I wanted to draw your Lordship's attention to order dated 25th August 2025, passed by the bench Honorable Justice Amrita Sinha, wherein your Lordship had directed that if they will run, the interim order was granted subject to them having the license as mandated from Pollution Control Board and others, because they need to have a valid consent to operate and consent to establish. Let PCB submit a report regarding or the petitioner may submit a report regarding whether they have the valid consent to operate and consent to establish licenses from the West Bengal Pollution Control Board, EC, environmental clearance or not.
CRZ, so I will grant permission.
And there is no CRZ.
There is no CRZ. That issue has been
decided. That will be.
And in spite of that, the order has been passed.
They are running that is the basic license they require to for running
tell your authority to make the inventory who are making running the business without license that come on the next day. The matter will be heard of record. The matter is specially fixed today at 2 p.m. for hearing, but it is submitted by the counsel for the parties. The pleadings are not been completed. In view of the above, the parties are directed to complete their pleadings by filing affidavit in opposition and affidavit in reply if it is not filed in all cases. within a period of 3 weeks from date. Affidavit be filed within affidavit in opposition be filed within 3 weeks. Reply if any that be filed within 2 weeks. 4 weeks kar do. 4 weeks, 3 weeks. The matter.
Union
31st of August at 2. 31st of August at 2 p.m.
Interim order, my lord, is
Interim order is extended till the next date of hearing.
till the next day, 31st August.
No, 31st August, my lord, unnecessary, my lord, is 60, I think.
Come, that they will see.
Monday.
Are you directed complete the pleadings? What can be done? If they're not pleading, then if the authority, then you
State, my lord, now the change scenario.
is appearing.
Only one, not in all matters.
Your Lordship, I have filed my affidavit in item 58. I have completed my affidavit.
Who is for state? Who is for state?
Who is appearing for the state?
Your
Like,
Lordship,
after the
they'll
court-
have to serve a fresh
It
copy.
is signed from it is none appears on behalf of the state. Full stop. The counsel for the petition is directed to inform the next date of hearing to the office of the office of the Learned Government Pleader. Full stop. The Learned Government Pleader is requested to assign the brief to any of the advocates so that the matter can be proceeded on the next date of hearing.
Lordship, I am appealing for the CPCB in all the matters. Lordship.
You give the name.
Grateful. Your
Yes.
I'm there.
Next.
My lord, this is my writ petition.
Yes.
My lord, my tenant is the State Bank of India. And my lord, since July 2025, they have not paid a single penny. Their rent, my lord, was.
What the red court will do?
My lord, may I, my lord, say? Firstly, my lord, I'm not, my lord, anticipating, my lord, an adversarial response from my friend. Because, my lord, the bank, I'm told now, is saying that they want to, my lord, somewhat call it a truce. So, my lord, let him perhaps, my lord, say what he has in mind. Because just, my lord, before the hearing, I've been told that they have some instructions.
My lord, I'm from the State Bank of India in this matter. My lord, the original lease agreement was between Hashimara Industries and my learned friend's client Davenport Company Limited. Now, there are competing claims. Now, it is an admitted position that we have not been paying since July 25. That is an admitted position. However, this is not something to do with the lease agreement itself. We have a competing claim from a third party, being some Shonapur Tea Estate Limited, who's basically saying that the land on which the premises exist, where we are operating out of, that land belongs to them. And Hashimara has basically assigned their leasehold rights to this particular Shonapur Tea Estate. Now we are at a fix over here. State Bank of India is at a fix over here. They are confused as to who to pay the rent.
With whom the State Bank of India is having the agreement?
Me,
Davenport India.
Tenant can't challenge landlord's title.
If you are having the lease agreement or rent agreement or tenants, whatever it may be, so you have to act in accordance with law. If the third party is having
Well, because there was a competing claim,
maybe
we had withheld.
they have a competing claim, they go to the appropriate.
My lord, just one minor extra submission. My lord, since July 2025, we have had bankers' checks being prepared for each and every month. Then that is a process that is still continuing. We have provided for the rent. It is not that we do not have the intention to pay. If my lord directs us to make payment of the rent to my learned friend's client, then we shall. But there is a dispute as far as the leasehold rights are concerned. Now the original lessee is Hashimara Industries.
You filed the civil suit by in the nature of the petition. Can you see the prayer? Eh?
Yes, my lord.
What do you think is the original side?
My lord, may I say? My lord, I have this entire plaint, so-called plaint that your lordship says, is, my lord, based on, my lord, 2 judgments of the Supreme Court. If it's clear and evident, my lord.
Admitted, they is telling that there is a third party claim.
Lord, may I just say this? I'll just clarify it in 1 minute. My lord, Hashimara was the owner of 2,600 acres.
Where is the property?
I'm coming to that. Property, my lord, is it's in West Bengal.
No, West Bengal, if it is in the jurisdiction of Jalpaiguri, how this court can...
Yes, my lord, it is Hashimara is in North Bengal.
May I the Hashimara, then it will go to
May I, my lord, clarify? My lord, the agreements The agreements are all signed by the head officer in standard. They are the bosses. It's all managed by them. The respondents also essentially the standard office. That's a small branch there. All decisions are taken from here. Authorities who have signed are also authorities of the branch office. That apart, may I just say, 2,600 acres belonging to Hasimara. Hasimara is the owner. Hasimara gives me a lease for 99 years of 0.3 acres that allows me to construct and sublet. I construct a ground plus 2 structure and I sublet to the bank. Bank pays rent until July 2024. July 2026. From July until June 2026. From July 2026, my lord, rent is not paid. They say
26 or 25?
25. I'm sorry, we are in 26 now.
Not
Yes, my lord, 25.
26, there is no cause of action.
No cause, no, 25. 25. My lord, admittedly, my lord, they are my tenant. It's under my deed that I, as sublessor, has got them in a sublessee. My lord, there are judgments galore that a tenant cannot question the landlord's title if it is claiming to be in possession based on an agreement with that landlord, which is the case here. Now, my lord, may I say this? If your lordship, my lord, today grants me my relief, as my friend is saying, he is willing to, my lord, even pay me the rent, no court, my lord, will set it aside.
No, he is not directly, is not telling that he will, he is telling that there is a third party claim. That's why he is not going to make. If the court will pass an order, he will give. But if the third party claims knowledge has come in before this court, how the court, sitting in the writ court, the court can pass an order. If the
my contention
third
is,
party is not a party here in the writ petition.
My lord, kindly just, my lord, see for one moment, my lord.
Yes.
There, my lord, kindly see the agreement, my lord, between me and them.
That's correct. No problem.
Now the bank, my lord, today, if he wants me to show proof of my, my lord, right, I have annexed that to the writ petition. Kindly see the lease given to me. It's a straightforward matter which can be adjudicated on the basis of documents. There is no order.
Telling that some other parties are also claiming
No,
the
just
rent.
say-
That's why they are not paid.
My lord, we want to put that on record. If my lord allows us, we can put that on record.
So, come and record, then you.
There is also a power of attorney that we also want to put it on record.
File a report.
We may file a report.
Let him file a
Let him
report.
file it, yes, my lord. And if the matter can retain its position, my lord.
Learned Counsel for the State Bank of India press for time to file report. Let the report be filed within 2 weeks.
2 weeks, my lord.
Within 2 weeks after serving the copy to the Learned Counsel for the petitioner, the petitioner has liberty to take exception to the report if any. Within a week thereafter, list the matter on 22nd July under the same heading.
My lord, however, Hashimara Industries must be made a.
Let your report come. Then we'll see to that.
Very grateful, my lord.
Because the report, I'm sure, will have some documentary proof.
That's
Just, my lord, orally somebody saying I have a right and him agreeing.
File a report.
I'm agreeing to, my lord.
Otherwise, my lord, what will happen? May I just, my lord, point out one thing? If, my lord, it is so easy for any random person to call the bank up and say we have rights, my lord, no writ will ever be maintainable. Writ jurisdiction.
That's why I want that if the report comes, there is no dispute, there is nothing. Then the court can dispose of if you're ready to pay.
Even if
there is a dispute
My lord,
with
we are
regard
a
to
sublessee over.
correct. So how the court can writ court
Even
can
if the
decide
dispute is, my lord, moonshine, if he's a
on
sublessee,
moonshine
and
law, how the writ court can decide with regard to the disputed fact is a moonshine or no?
if it can be seen from documents. If your lordship is of the view that
My only submission, my lord, is that
Come on,
the
then,
bank does not intend to pay. It's not that they don't intend to pay.
Yes,
Grateful, very grateful, my lord.
May it please your lordship.
I've been led by Mr. Abrotoshmi.
Yes.
May it please your lordship, Lord, I'm appearing for the petitioner.
On record, man.
Lord, I'm appearing for the petitioner in these two matters. My lord, would be pleased to recall very briefly. I'll indicate, my lord. My lord, this is a matter where, my lord, by an office order. My lord, am I audible to your lordships, my lord?
Sir, Bach conclude his submissions today. Your lordship will give me, because this is a ready matter. Give me another day. I will give my reply.
What is the matter? What is the prayer?
My lord, may I very briefly indicate? My lord, this is that matter where we had challenged my lord, an office order issued by the West Bengal State Electricity Distribution Company Limited, by which, my lord, they say that you cannot even participate in a tender if there is a litigation.
Electricity. Then how this
No,
code?
it is not. No, my lord, it is not electricity. It is not electricity, my lord. It is a work order which we have.
Where is the impugn order? Where is the impugn order?
But there is no impugn order. Kindly take up page 380, my lord. Page 380. What we are challenging is an order of WBSCTCL by which they say that you are not permitted to participate in a tender process if you have filed a litigation against us. Any litigation against us, you will not be able to participate. May not kindly take up page 380. Your Lordship will find office order number 2518 dated 8th of September 2025. Your Lordship will find in compliance of the, kindly see the subject, page 380, my lord.
380 is the some form is there.
That is it.
Form is
My lord, there are two writ petitions. The second writ petition is what is required to be looked into. That's item number 18, my lord. The reason is when we had filed the first writ petition, my learned friends took up a point that a particular work order which is related thereto has not been challenged. So we have challenged both in the second writ petition, my lord. Page 380 of the second writ petition.
Yes.
My lord, your lordship will find office order number 2518 dated 8th of September 2025. The subject is incorporation and redesignation of forms in e-bid technical proposal. In compliance with the recent amendments of the revised purchase policy of WBSCTCL, the following new forms have been incorporated in the e-bid technical proposal for mandatory submission. Kindly see Form 11, declaration regarding no litigation against WBSCTCL. And I pause here. This is my challenge, that they want a declaration that we have not filed any case against them in any other proceeding. If there is litigation pending which is initiated by the petitioner, he cannot participate in the bidding process. That's their case. Now, my lord, kindly see, very interesting. This is the office order which is followed, my lord, by Form 11. That's at page 383, my lord. This Form 11 is given at page 383.
Yes.
Declaration regarding no litigation against WBSCTCL. This is the form which, my lord, we have to file. We have to sign. What does it say? We hereby declare that no legal litigation, arbitration is pending or ongoing against WBSCTCL in any court forum against by the bidder or its sister concern, director, partner, proprietor. So any kind of litigation, if we file against them, then we are precluded from participating in the tender process. If it is found at any stage of the tendering, our offer will be rejected, and we do not have any objection on the same. So we give up our right to litigation if we have to participate in a tender floated by a government entity.
Yes.
This is under challenge in the writ petition, my lord.
Yes.
Lordship will find with this is a follow-up to page 387. The same date, my lord, page 380 is dated 8th of September. My lord, page 387 is also dated 8th of September. This office order number is one prior there to, my lord, 2514, page 387.
Yes.
My lord, invitation to tender. This is the original work office order as has been contended by my learned friends, my lord. Your lordship will kindly take up page 389, clause number 14. At page 389, my lord.
Yes, yes.
389. Clause number 14, litigation, arbitration against WBSC, newly inserted.
Yes.
The bidder should submit a declaration in prescribed format under form folder Roman 11 in that letterhead regarding no legal litigation. It should be litigation against WBSCTCL is pending in any court or forum. So this is the declaration that they seek. This is the crux of the matter, my lord. We say this is completely against the Contract Act. We, my lord, have a list of judgments which we will rely on and will conclude. If your lordship, my lord, permits me, I'll indicate it today or the day when my learned senior friend will also address the honorable court. I will take 15 minutes. I'll address this and then my learned senior friend may
I want
address.
to take the benefit that Mr. Bach concludes his submission on
So
one day.
the reason is, my lord, I will indicate those judgments
I
at
can
one go so
prepare-
that my learned senior friend can address on the same day.
Mr. Intention of the Mr. Bag that you should not get more time to prepare.
No, never. Your lordship knows me. I am always economical.
Mr. Bach, so that you cannot get more than 10 minutes.
Oh, I know that I get. My brain is a slow processing machine. So my lord, I have to get ready.
I do not agree to that.
You're the energy company. You're appearing for the energy company. And that too power energy.
Power energy.
Power energy, my lord. And
Not that the
the
council
only
would have
claim
to be
is,
empowered.
and no litigation against them. That's what they claim, my lord. No litigation
My
can be
lord, your
initiated
lordship
against
will
them.
hear it some other day, or my lord.
If you're ready, what do you want, Mr. Bag? Some other
My lord,
day.
we can come. I'll come physically, my lord, any day, and I'll make the
So,
submission in not less
Don't,
than,
my lord, my diary will not permit for any specific date, or I
my lord,
fix.
I'll be there. My lord, I'll be there all the days. My lord, tomorrow kindly don't keep it. Rest any day I'm there.
Not
my lord.
tomorrow, not tomorrow.
Next week, my lord, any day.
Wednesday.
My lord, we will
Except,
take our chance whenever it.
my lord, except 8. Any day I'm there, my lord.
An
I'll be
affidavit
there before the
signed
honorable
by
court.
the parties be kept with the record. Learned counsel for the petitioner has argued the matter at length, and he prays for time according to case adjourned. Let the matter appear on 9th July.
My lord.
9th July under the same heading within 5 matters.
I'm very deeply obliged, my lord. Very deeply obliged, my lord.
You are appearing for whom? What is your name? Kamal Dalal. Huh. What is the huh? Kumar KUMA? Kumaresh Dalal. DLL. Learned Counsel appearing for the Union of India submit that in the order dated 30th April 2026, his name has been inadvertently recorded as Kamal Dalal instead of Kumaresh Dalal.
My lord, may I just indicate one thing? My lord, I think the state of West Bengal, the government, in its appropriate department, I think power department, has been implicated as a party respondent. Presence of state would be extremely necessary in this matter. That is a policy decision of the state.
In the order dated 30th April 2026, the name of the advocate appearing for the Union of India shall be read as Kumaresh Dalal instead of Kamal Dalal.
And my lord, notice may be served upon the office
It
of.
is found that none
My
of
lord,
your of the
my lord,
state,
may I?
the petition is directed to inform the next date of hearing to the office of the government pleader so as to enable the government pleader to engage to assign the matter to any of the learned advocate on behalf of the state so that on the next date fixed the matter can be taken up for final hearing.
I'm very deeply obliged, my lord. Very deeply obliged, my lord.
So
I'm appealing for the petitioner in this matter.
And I'm for the respondent number 4, 5, and 6, Union Bank of India.
Yes, my lord, this issue has been dealt with, my lord, in earlier writ petitions, my lord, which were there before, my lord. I tell your lordship briefly, my lord. My lord, in its usual course of business, I'm a fintech company. My lord, in my usual course of business, I receive payments from my clients and my customers. My lord, in that, my lord, suddenly, my lord, I receive a notice from my bank that your account has been debit freezed. It's completely blocked. Now, my lord, I do not have any guesswork, my lord, how much amount, my lord, why they say that. They say from Bangalore police, my lord, from a station, my lord, they have received an information to, my lord, freeze block my account. Now, my lord, after that, my lord, I don't have any information. I write them a representation. This cannot be done. The present scenario, if at all, you can. If they say some amount, X amount is for that reason, you please have a lien on that. You cannot entirely stop my business day-to-day life affairs. Now, my lord, recently, my lord, the point I would be campassing, my lord, they have issued the notice. As per, my lord, what I have received is under 106 of BNSS. My lord has dealt in a writ petition in this honorable court, my lord, and my lord, relying upon Kerala High Court judgments in Bombay, where it says freezing, my lord, under 106 is absolutely illegal. 107 is the appropriate recourse. Now, my lord, if that be so, my lord, I have 2 points to canvass. My lord, they cannot freeze my entire bank account. My lord,
you are appearing for whom?
For the respondent number 4, 5, 6, Union Bank of India.
Now, my lord, kindly takes up.
Which bank you are having the account? Union?
My lord, Union Bank. In this, Union and Yes
why
Bank.
the Yes Bank has been made party?
My lord, because Yes Bank account has also been freezed.
Who is you are appearing for the Yes Bank?
Yes.
What is your instruction?
We could not take necessary instructions, Your Lordship, because we have not received the entire.
And whether the notice is served to the police authority. That's
Yes,
what
my
number
lord, we have
10.
sent it, affidavit of service.
Lordship, we have only received the application without any annexure.
Respondent number 10, have we served the
Yes, my lord,
notice?
yes, Because they are in Bangalore, my lord, I have to serve, my lord, rely upon.
Service affected.
My lord, affected, it is delivered, it shows, my lord.
So you are not have received the total writ petition you are having.
Yes, my lord. I have having, my lord, I have also got instruction that in terms of the police authority, my lord, I have freezed, my lord.
So
That
that's
is
why
my.
you both
Yes.
file the report.
Yes.
You both file the report.
Yes.
Why you have freeze the account of the petitioner and what is the amount pending lying in the account of the petitioner.
Very well.
Correct. And
Very.
whether the police authority have informed with regard to the any order from any court with
Magistrate.
regard to the freezing of the account.
Very well.
And you serve the notice to the respondent number 10 again and file the affidavit of service. And if the next date they will not come, then I will pass.
Well,
The affidavit of service filed by the petitioner be kept as record. Learned counsel appearing for the Yes Bank and Union Bank.
Yes, my lord. Union Bank 4, 5, and 6.
Union Bank of India are present. Full stop. Then appears on behalf of the other respondents. Full stop. The learned counsel for the bank, for the Union Bank and the Yes Bank are directed to file the report by way of an affidavit stating the fact that why the account of the petitioner is freezed, comma, how much amount is lying in the account of the petitioner and whether the investigating agency have reported to the bank whether they have obtained any order from the court with regard to the freezing of the account.
And also with regard to the fact how much account for which, my lord, it has been freezed, my lord.
That how it has been.
Yes,
police. Correct. The petition is directed to inform the next date of hearing to the respondent number 10 and to file the affidavit of service on the next date fixed. It is made clear that on the date fixed, if the respondent number 10, in spite of receipt of the notice, not appeared before this court, comma, appropriate order will be passed in the absence of the respondent number 10. Release the matter on 14 July.
14 July.
And give copy.
I shall give a fresh copy.
I am not recording
Yeah,
you
no,
the
no.
copy.
Only-
Otherwise, your matter will be.
Yes, yes, I know. But only one thing, my lord, 14 July, since my entire business has been, my lord, both the accounts.
What can
business
be done? How can you solve the respondent number 10? It is not here.
My lord, we have, it's Bangalore, my lord, I can't
Okay.
serve.
एक
take
काज
the-
करो 9 तारीख करो 9th within 10 matters.
No, my lord, keeps it on 14th, I will be able to serve and show delivery.
That will better.
But time, my lord, if
Huh?
time can be fixed.
Time not okay. 14 रखो within 10 matters कर दो.
For you.
I'm doing.
Next.
My application, my lord, I am an ex-occupier of a land of the Port Trust. My lord, I had surrendered my tenancy on 23rd April 2021 by way of a letter. Thereafter, on 26th December 2022, the Port Trust raises a demand on me saying that the certain rents are outstanding. But my case is that since I have surrendered from April 2021, I'm not liable to pay any rent whatsoever in respect of the subsequent
What
period.
is the demand?
The demand, my lord, kindly takes page 35, around 12 lakh
No,
5,000.
from which period to which period?
That is as on 20th December 2022. That's what they mention. Page 35.
35.
Yes. The principal lordship will see the chart.
Several breaches and identified and communicated to you what so and so. Reveals that this office record that huge amount of payable in respect of it. Principal 5, interest 6.
Interest 6 comes to 12 lakh. Apart from that, they say that I have inducted a third party in the premises who has made unauthorized construction. My case is that I was out of possession from March 2020 when COVID outbreak. And Marat, they mention a name of a person, Ashok Kumar Jain, which your lordship will find at paragraph 3 of this letter.
Yes.
Now, I have added him as a party in the writ petition, respondent number 4. I've tried to serve him, that has come back.
Now, I do not know this person. This person may have occupied the property. may
When you
still-
ended over the possession of the property.
I surrendered possession on 23rd April, which your lordship will find at page 30. I make a request that don't raise any further rent bills from April 2021, which they don't listen to, and they raise this bill on me saying that I have an outstanding as on 2022.
Yes.
My lord, I have repeatedly requested them after page 30. Lordship will kindly take page 31 onwards. I have repeatedly requested them not to raise any further bills on me because I am not in possession. And I was thrown out of possession during COVID, and therefore, my lord, I have surrendered my possession.
Tenancy agreement.
No, tenancy agreement, it's not with us, it is an old agreement, but the fact that I was a tenant is undisputed because they are raising rent bills
No,
on
if
me.
the tenancy agreement, so what? So how only by a letter how you can surrender?
But if there is an agreement which is not in my possession, I cannot find it. But I have served them a notice if that is treated as a 106 notice. My lord,
What you are doing in the property?
I was there, I ran my business.
Warehouse.
Yes, warehouse.
So warehouse, if the warehouse then handing or taking or why it is not there?
But I was in possession till COVID outbroke.
Correct.
Then I was not in possession because I could not visit the premises. Then when I visited,
Let the file affidavit. What can
but only one, I understand, but a report or an
how
affidavit
the
has to
court
come.
can decide all this?
But insofar as the bills are concerned from 2021, let them not raise those demands.
That is also in the affidavit.
I just want to say, my lord, two things, my lord, how this proceeding is at all maintainable. My
That's
lord, whether they are in possession or not, whether the possession was rightly handed over or not, my lord, what is the amount to be due is to be decided under section 4 and 7 of the public premises and under the estate officer. Now, my lord, ultimately, my lord, lordship also, my lord, my lord, under 4 and 7, it is the estate officer who has the power to do all this. My lord, lordship says 4 is the notice and then 5 is the order of eviction.
No, that is with regard
5
to
and 7, lordship 7.
That is with regard to your act.
Yes,
If you want to take possession, then you have to
I will
note
do
the
that.
provisions of
And
the
my
court
lord,
notice
in respect of dues also, my lord, kindly come to section 7.
require payment of rent or damages.
Where any person is in areas of rent payable in respect of any public may by order require the person to pay the sum within such under. And thereafter the proceeding will be initiated. No matter how can, there can be, it's against specific relief act. I cannot,
Insofar as the estate officer's powers are concerned, well, that is to evict an illegal occupier or recover arrears of rent. That is the estate officer's power to recover or to order recovery. I am saying I do not want adjudication of my rent. I am saying I am not liable to pay from 2021 because admittedly I have surrendered.
If they will initiate, you have given the letter.
Yes, I have
you
given the letter.
representation.
Yes.
So they will take appropriate steps. If they will initiate the proceeding and
They will defend. Whenever they
then
initiate.
you go and plead before the estate officer.
Whenever they initiate, I'll naturally have to defend. But as on this date,
so what the writ court will do?
Well, what is undisputed as on this date, which does not require any adjudication, is I am not in possession. According to the port trust, is some Ashok Kumar Jain is in possession, so I am not liable to pay since I am not in possession.
With possession.
But the demand shows that there are breaches and there are areas
which they say has been at the instance of Ashok Kumar Jain. Now I have added him as a party, and I do not know him, but I agree that cannot be determined in this writ petition. What I am saying is, since I have made a request to them that I have surrendered my tenancy, I am not in possession, I am not liable to pay. Insofar as the period from April 2021, let them not raise any demand. If they initiate recovery proceedings, well, that I'll meet.
How this court, without adjudicating the issue whether you are liable to pay or not liable to pay, how the court can pass an order not to raise the claim?
Very well, in those circumstances, let them file a report or an affidavit indicating whatever rent is due. And
you withdraw it, they will take appropriate steps. What purpose?
That is up to them whether they will take steps or not. But before they
without taking steps, well, I cannot do anything. I am a statutory authority. Of course, I will follow the statutory route. Well,
the Public Premises Act is no bar for filing of a writ or entertaining of a writ petition if the acts are arbitrary.
May be arbitrary, but with regard to the disputed question of fact, with regard to the tenancy, with regard to the areas of rent, demand, How the writ court can?
But as
Unless and until both the party admits.
As regards the questions
If
or
he
issue,
will, he will admit that yes, the authority will not claim any.
that will never happen.
Then I will.
But insofar as the undisputed issues are concerned, that is, I am not in
I
possession.
can assure my learned friend, no steps will be taken without taking statutory recourse.
That's even otherwise no.
He has already surrendered.
Well, it is not the question of my instruction is he has given the tenancy to somebody else, parted with possession. Now say I am not liable.
No, I have been saying so since 2021. It's not that I've woken up now. But no, let the port trust file an affidavit to this effect. I'll come back after affidavit.
It will.
But I know no interim order can be passed. But
Why the matter can be kept in the
Well,
file?
another pendency, my lord, to lordship's long list, my lord.
And you already written to the state manager, then he will take that.
He will take that, my lord. I have written to the police officials also that you remove whatever unauthorized structures have been raised by somebody else. I do not know about that. But my lord, may I do this? May I take instruction on this? My lord, come back or something. But I may have to, my lord, take instruction to even to withdraw. So my lordship may keep it some other day. My lord, I'll take instruction and come.
Take instruction. Otherwise, if any merit will pass, then may affect in future also.
I understand.
That will-
Lordship may make it not today or will keep it next week. My lord, I'll come.
As per the prayer made by the council for the learned council appearing for the respondent authorities have raised the point of maintainability of the writ petition. Full stop. Council for the petition prays for time to take instruction. According case adjourned, let the matter appear on
7th,
8th July.
8th July.
Lordship.
Under the
Grateful,
day
my
meeting.
dear. Much obliged.
Next.
We
for the petition. Yes.
With the affidavit satisfied. So this is petitioner had an application before the board of Waqf for appointment of Motwali for the Waqf. The court took the hearing and took the state direct management under section 65 of the Waqf Act 1995. Against that order, the petitioner made an appeal before the secretary of the Madras Education. This appeal is still pending. The appeal is papered in the month of September 2025. But this appeal, till that, appeal has not been considered.
Appellate tribunal is there.
Lordship.
It's functioning.
Lordship. The Waqf tribunal is there.
Functioning.
Tribunal is there. It is functioning.
Secretary of the State of West Bengal.
Lordship, I'm placing in
I will come to page 65, man. This is my appeal. Page 65. Yes.
Yes.
Paragraph 30, Your Lordship. May I read, Your Lordship?
Yes.
To the mind of the bench, determination of any dispute, question or other matter relating to the Waqf or Waqf property used in subsection 1 of section 83 as well as section 84 as well as an order made under this act or rules made thereunder used in subsection 2 of the section 83 of the act read with section 65 and 51 thereof are of wide and expansive and embrace grievances raised by the petitioners in the writ petition, which can legitimately be raised before the Waqf tribunal for a decision by it. The decision to take over direct management of property under section 65 of the act. So, Your Lordship, this writ petition concerned is in respect of section 65 of the Waqf Act for the direct management, Your Lordship. So, and the decision to develop the property followed by the execution of the development agreement such and such must be construed and included in the order made under this act and therefore amenable to challenge before the Waqf tribunal, which has the powers exercisable by a civil court under the civil procedure code to be to decide by it. So this matter may be referred to the
correct. What is the prayer? Kindly, that's he asking for the direction to disposal of the appeal prepared by the petitioner.
Yeah.
Not to decide the appeal filed by the petitioner.
So it can be, but he has not exhausted his provisions. He has to approach the Waqf tribunal for such orders as well, Your Lordship.
Where your application is pending?
Kindly come to
before the MA and ME department.
Kindly come to the prayer.
Page 65, my lord, this is
Page 65.
Yes.
Where it is pending? Principal Secretary, Minority Affairs and Mother Secretary. Where is the order of the tribunal? Waqf tribunal has passed an order.
Order of the Waqf board.
Waqf board. After Waqf board, then you have to file a tribunal. How you go to the secretary?
There is a provision. Kindly come to section 65, subsection 2.
Where is the tribunal's order? First, you show me the tribunal.
Tribunal. This is not tribunal order.
Yeah, the Waqf board order.
Page 77.
77.
Yes. And page 79 is the notification.
Heard the matters are done, considering the prevailing circumstances, etc. Also considering the inquiry report submitted by Janab so and after due deliberation and discussion, that the order of appointment of Muntawali in respect of the Waqf estate is hereby rejected, and the Waqf board property assumed under the management of the board 60 years. Then this order is passed under which provision?
Under 65(1). The Waqf Act.
65(1). Yes. Then
thereafter they have
order of the Waqf board where the appeal lie.
This 65 to the state government.
Yeah, kind of
একটা বই নিন দাও না দাও না একটা বই দাও না Your lordship, it lies before the MA and ME department. MA and ME department. So that's minority affair and madrasa affair.
That's yes,
subsection 2.
Yes, fine. Section 65.
Subsection 2. Order
assumption of direct management sources. The state government may on its own motion or application by any person into the Waqf call the records. Yes. Notification is 65(2). So I am disposing of when you file the appeal and this application before the
when the coordinate bench, your lordship has already decided
10 September 2025
that any question.
Correct. I am not deciding.
Lordship.
Only his prayer that kindly come to the page 65.
Lordship.
This is to be disposed of by the principal secretary under section 65(2). This court is not going to decide any facts in the matter.
He is asking for a direction.
Yes.
For the speedy disposal.
Speedy disposal. You said that this court is not having determination to decide that.
No, your lordship. But your lordship, it has been decided by the apex court as well. Any dispute, any matter concerning.
That's what I'm telling.
If any order has been passed as well.
The only grievance of the petitioner in the present date application that the petitioner has preferred an appeal before the principal secretary, minorities affairs and madrasa education, Shibpur Howrah under section 65 within bracket 2 of the Waqf Act 1995, arising out of order of resolution dated 5th October 2023 passed by the Waqf board of Waqfs, West Bengal. Full stop. Learned counsel for the petitioner submit that the appeal prepared by the petitioner is pending before the principal secretary, but till date the appeal has not been disposed of and prayed for a direction upon the principal secretary for disposal of the appeal. Learned counsel for the respondents raise the objection of maintainability and submit that any matter connected with the Waqf property is not maintainable either in the civil suit or in the writ judice. Full stop. This court find that the petitioner has not prayed for any adjudication of the Waqf property, only the prayer of the petitioner for disposal of the appeal filed by the petitioner by the principal secretary under section 65 within bracket 2 of the Waqf Act 1995. In view of the above, the writ petition is disposed of by directing the respondent number
3. No, 2 however, na? Respondent number 2, your lordship.
By directing the respondent number 2 to consider and dispose of the appeal preferred by the petitioner against the order passed by the Board of Waqfs dated 5th October 2023 within a period of 8 weeks. Within a period of 8 weeks from the date of receipt of this order after giving an opportunity of hearing to the petition.
Well, in this matter, I appear for the petitioner. Well,
Yes.
this matter relates to the SIR. Well, the petitioner filed an appeal. Well, thereafter, without proper hearing, well, the appeal was, if your lordship may come to Annexure P9, well, the without hearing, well, his name was excluded from the
Where is the
list.
page?
Well, Annexure P9, page number 85.
Page 85.
Well, 85.
What has happened?
Well, the order was.
Why you are not appeared before the appellate authority?
Malad, he has been
Appellate tribunal.
Malad, the appellate tribunal has not been called me.
So there is an order.
Malad, I am praying for reconsideration, Malad, and rehearing, Malad, one. This is my only prayer here.
Where is the notice?
Your Lordship, it can be remitted back before the tribunal, but the time was one humble prayer, Your Lordship.
Affidavit of service.
What is happening?
That is the problem. Now I find my diary is going up to September.
Your Lordship.
If every week I am taking 30 matters, then it is going now my diary still September and the all SIR matters are there.
Kindly give me. Where's the tribunal to dispose of it?
I am not fixing the time.
No, Your Lordship's order, they are taking it immediately.
First, okay.
Yes, that's the.
Okay.
Much obliged, Malad.
The petitioner has filed the present writ application being agreed with the rejection of the appeal filed by the petitioner by the appellate tribunal, SIR appellate tribunal, dated 26th of May 2020. When it was dismissed?
It was 26th of May.
26th of May
2026.
Land counsel for the petitioner submit that due to inadvertence, the petitioner could not appear before the SIR tribunal when the matter is called, and accordingly, tribunal has dismissed the appeal filed by the appellant. And he prays for restoration of the prays for a direction upon the SIR upon the appellate tribunal for restoration of the for recalling of the rejection order for restoration of the appeal filed by the petitioner and to dispose of the appeal as early as possible. This court find that the petitioner had preferred an appeal before the appellate tribunal, being appeal number APS 251G 290326258425 dated 29th of March 2026, and the appellate tribunal has taken up the matter on 26th of May 2026, but due to non-appearance of the petitioner, the appellate tribunal has dismissed the appeal preferred by the petitioner. At the learned counsel for the respective parties, this court find that due to non-appearance of the petitioner, the appellate tribunal has rejected the appeal. Accordingly, the tribunal is requested to restore the appeal preferred by the petitioner dated 23rd of March 2026 and to 29th of March 2026, and to dispose of the appeal as early as possible within a period of 3 months from the date of receipt of this order.
Well, item number 23 is a similar 20.
Same. That all dismissal.
No, Malad. 23 is Malad relating to the expeditious disposal. Malad.
Not dismissal.
Not dismissal, Malad.
And which is the dismissal?
22.
22 only.
Only 22.
And
Malad.
23 direct.
23 direction for Malad expeditious disposal.
24. 23. The petition, the grievance of the petition that the petitioner has preferred an appeal before the SIR appellate tribunal, and but the same is pending, and prayed for a direction upon the appellate tribunal for disposal of the appeal as early as possible. In view of the submission made by the counsel for the petitioner, the WPA number 12292 of 2026 is disposed of by requesting the appellate tribunal to dispose of the appeal filed by the petitioner, being appeal number APS 2508G 1004267228881 dated dated 10th of April 2026 as early as possible within a period of, preferably within a period of 3 months from the date of receipt.
Let the affidavit of service.
Next.
For 24 and for a petitioner, my lord, this is the case, my lord, where the petitioner was issued a show cause notice for not participating in the electoral duty. Now, my lord, if your lordship kindly comes to infructuous because no steps have been taken. Admittedly, they have not taken any coercive step against me. The reasons have been assigned, my lord, at page 68. I've annexed the medical documents. No, medical documents.
So what do you want?
No, withdrawal.
Withdrawal.
Yes. It has become infructuous. No coercive.
Learned counsel for the petition submitted. The petitioner has filed the present application against the show cause notice.
Yes.
Against the show cause notice issued against the petitioner for not
page 65
for not performing the election duties. Now the writ petition filed by the petitioner has become full stop. After the election is over, no action has been taken against the petitioner, and thus the petitioner has filed the present writ application challenging the show cause notice issued by the. Where is the show cause notice?
All right, the page 65.
Issued by the district election officer dated 1st of April 2026 due to non-appearance of the petitioner in the election duties. Full stop. Counsel for the petitioner submitted the petitioner could not report the election duty due to his ill health. And
Of the wife of the petitioner.
Wife's ill health.
Yes.
Due to the illness of his wife. Illness of his wife, as the wife was under medical treatment. The petitioner also disclosed the medical documents, and it was found that the petitioner also you are informed to the authority.
Yes, my lord.
Petitioner also informed to the authority with regard to the illness and medical treatment of his wife.
Page 64 is the medical document.
Full stop. Consider the full stop. Learned counsel for the petition submitted. Yes, what is the submission? No action. Record that. The full stop. The counsel for the petitioner submitted after the election is over, no further steps has been taken against the petitioner. Full stop. In view of the above, this court find that only the petitioner has not attended the election duty, the show cause notice has been issued. Now the election is over, the authorities are not taken any further steps. Thus, the petition filed by the petitioner become infectious. And become infectious when the dispute.
Grateful.
Next.
This is my application, my lord. My lord, innocuous prayer for my lord, consideration of representation so far as my lord, the representations made by the petitioner for my lord, to get out of the shell company list. I'll tell you, lordship, my lord, what has happened initially. Initially, my lord, SEBI had, my lord, identified, my lord, around 140 banks or odd to, my lord, say that, my lord, these are, my lord, shell companies. Now, my lord, SEBI thereafter referred the matter to the Calcutta Stock Exchange. Calcutta Stock Exchange thereafter, my lord, pursued the matter. Calcutta Stock Exchange, my lord, thereafter, my lord, asked for these entities or the companies to, my lord, get documents. My lord, we submitted documents to that effect. My lord, there was a series of correspondence which were, my lord, going on, my lord, where, my lord, finally, my lord, the Calcutta Stock Exchange said that, my lord, you finally submit a representation to SEBI saying that you please get me out of the shell company list because you have complied with all these things. Now, my lord, after, my lord, writing it to SEBI, thereafter they reverted back the matter to the Calcutta Stock Exchange. Now, my lord, finally, my lord, if your lordship kindly sees, my lord, two correspondence, my lord, the final correspondence, but I'll not trouble your lordship to the entire thing because really, my lord, innocuously, my lord, your lordship may find, my lord, the petition is bulky because, my lord, I have given, my lord, my audited transaction report, the balance sheets, my lord, everything, my lord, which we have forwarded by, my lord, correspondence, my lord, to, my lord, either SEBI or the Calcutta Stock Exchange. Now, my lord, if your lordship kindly sees,
you are appearing for whom? SEBI. Who is for the SEBI?
My lord, SEBI and my lord, Calcutta Stock Exchange, my lord, both we have served, my lord.
Yes, sir.
Oh, we have also received an email that SEBI will be representing today. My lord, my learned advocate on record has also received an email saying that SEBI will be represented today.
SEBI, Mr. Bose is appearing, Manak Bose was appearing.
Or Mr. Rupak Ghosh also appears at times and my lord, Mr. Bose also appears at times.
Sanderson.
Yes, madam, you are appearing.
25.
Yes. Which matter? Which respondent?
No.
Then I think.
Without their
But
presence.
really, Mulad,
Issue notice day after tomorrow. I am not. Issue
but,
notice.
but on the last occasion, I also did the same. Mulad, we got a chance after a long time. That is why, Mulad, nothing. Mulad is that is the only predicament, Mulad.
As none appears on behalf of the SEBI as well as the Calcutta Stock Exchange, according the petition directed to serve the notice upon the SEBI as well as the Calcutta Stock Exchange by intimating the date of hearing and to file the affidavit service on the next date fixed, list the matter. How soon?
But as you can serve it, Mulad, by Mulad tomorrow also.
And let the matter appear on 13th.
Tuesday.
13th.
Tuesday, Mulad, if your lordship so pleases.
Next Tuesday. It will be done. As SEBI can you serve?
SEBI.
Their advocates have been appointed here. We'll serve them over here.
No, on 8th July, within 10 matters.
I'm so grateful to you.
Next.
Number 26, Lordship, I beg to appear on behalf of the Union of India. Matter,
I appear.
Bengal Power Development Corporation has.
But I appear for the petitioner.
Yes, what is the matter? Electricity. Yes, what is the prayer?
No, Malad, this is not no, Malad. Malad, this is not electricity. Malad, this is regarding Malad,
yes.
Cancellation of a coal block.
Only thing is that, Lordship, in fact, this was fallen from a Lordship on the previous occasion, that in view of the change of circumstances, whether the petitioners would like to proceed ahead with the matter. In fact, as I have been instructed, Lordship, we are already taking steps with the London Advocate General, Lordship, as to whether this company undertaken by the state could proceed ahead challenging the policy related issues so far as respect of the central government. I was humbly beseeching Lordship, if your Lordship can kindly takes it up after 15th of July, we will be hopeful that in the meanwhile we come up with some decisions.
Learned Council for the Union of India submits that the matter will be taken up for with the competent authority to decide whether the state government, the corporation.
Yes, Power
Yes, my lord.
Whether the matter can be proceeded for further or will take any further decision in the matter. In view of the above, the case is adjourned. Let the matter appear on 21st of July 2026 under the same heading. Full stop.
Mr. Mitra, I think the interim order is there till 21st
28th July.
28th July.
28th July. I am
28.
on 21st.
Yes.
Great.
I am deeply grateful.
Grateful.
Next.
So I appear for the petitioner.
1 minute.
You guys are trying to pass any order.
And yes.
This pertains to, my lord, a contract which had two parts, part A and part B. To cut the long story short, I have completed in respect of part B. As per the respondent's direction, Millard, since there were hindrances in part A, I was directed to move my machinery to part B. Part B is completed, part A is part completed. Millard, I apply for foreclosure of the contract. The respondents accepts my foreclosure
and thereafter imposes penalty on me. This is the subject matter of challenge before my lord, They refer to a clause 6.3.1, which according to me is, inapplicable in this case, because this is a case of which is recorded that the part A was hindrance, suffering from hindrance. Therefore, I was told to move to part B. Now, this is the case, we have completed our affidavits, It's a old case. Kindly fixes a time and give me half an hour. I won't take more than half an hour. Because facts are admitted. It's only, on the issue of law.
Not counsel for the petition has argued the matter at length, but due to paucity of time, matter could not be taken up hearing. Let the matter appear on.
But whichever
much
date
time will it take?
convenient to the court, give me at 2 o'clock or 12 noon.
That's why, but 2 o'clock, then it will go to the 1st September.
I have no problem. Any day, any day. Any day.
No problem.
I have no problem.
Because LD is there. And it will, interest will also occur.
Yes.
That is the only problem that my client may suffer, but.
से पहले नहीं है अगस्त में कोई है 2 बजे 2 बजे 2 बजे
Or at 12 noon, without any day, because 1 hour I think is sufficient for both of us.
July 23rd at 12 noon. 23rd July at 12 noon.
I'm so grateful.
Yes, close. Close appellate side, let the original side come.
No, you're not. Let us bring for my lord's leave, to mention, Lord, item 192, Lord, of your lordship's list, Lord. This is a part of matter, Lord, which your lordship has heard. Lord, it was specially fixed for hearing, Lord, on 13th of May, or 11th of May, Lord. On which day, Lord, because of the resolution, Lord, it could not be taken up, and thereafter, Lord, it could not be called on, Lord, because of its position in the list. Lord, if a date note could be fixed, Lord, any day at 3
Who is
p.m.
on the other side?
Lord, I'm mentioning upon notice. Lord.
PNB, you are for the plaintiff.
I'm for the plaintiff, Lord. Any day, Lord, at 3 p.m., Lord, if it commences, your lordship.
Item number 195.
192.
Though the matter is listed as item number 192 of the today's list, but the land counsel for the petition has mentioned the matter praying for fixing a specific date and time, so the matter can be taken up for hearing. At the land counsel for the petition plaintiff, let the matter appear on 31st July at 3 p.m.
I'm really grateful.
At 3 p.m., the petition is directed to inform the
defendant
date to the land counsel.
I will inform. Very grateful to Lord.
I am very permitted to mention this matter for inclusion, my lord. Application for extension of time to file written statement. Application for extension.
Why here? Assigned matter.
This is an assigned matter. May I request?
Assigned matter.
Yes, no, this is the
Assigned matter. W is not filed. Why the assign is given?
This is the circuitous transaction matter where your lordship was. Our judgment upon admission application has not been
Allowed.
fallen for
Acha, in that case.
Yes, that case.
So you file appeal?
No, we haven't filed appeal yet. But may I not make this submission? We also keep this matter under the heading of action. Pleadings are complete.
Lordship.
One matter on notice, Lordship. Lordship was taken up by a coordinate bench, but there was understanding regarding the determination of it. It does not come under the surface, Lordship, but the entire clarification in the package has been disputed, and that is why bank is not being able to proceed with the recovery of the person. The matter have been completed. There were
You are for the bank. Who is for the petitioner? You are for the petitioner.
Lordship will kindly keep it as to be mentioned on any of the days. Why I say so? Because there was also certain directions on making deposits for the purpose of processing OTS, Lordship. But also not considered, Lordship will keep it as a to be mentioned, then thereafter Lordship
Will probably have to be on similar lines.
We deferred that. Lordship will keep it as to be mentioned any day next week, Lordship. Lordship.
7 तारीख को रख दो. To be mentioned. 7 to be mentioned.
Lordship, my number is 19, I think, item number. Could you just, 19, I think, if you could just give me a date or something like that, so I don't have to come
What is the
every.
matter?
So it's the matter is there. The eviction suit was given in the trial court in my father's time. I am the landlord of the building, and what they did, they removed the ground floor and made it second floor, and that couldn't be eviction, couldn't be done. And I tried rectification in the court of fourth.
Court has passed the decree.
Fourth court, Hare Street. And
so
that has to be
why
corrected.
before this court?
So that is restitutory.
This court has passed the decree.
No, this court, the trial court in
Trial court has
2001.
passed the decree. Why before this court?
So I've come for.
This court is not the appellate.
So for rectification, I.
Okay, let us इसको कर दो ऊपर कर दो.
So if you could just give it, give me a date, please.
कब देगा? At 3:40. 17 July 3:45.
Much order. Much order.
What is urgency?
The urgency being marriage certificate has been declared as illegal and authorized. Lordship, the petitioner's marriage certificate has been declared as unauthorized and illegal by the marriage registrar. Lordship, my husband has also passed.
Marriage certificate is revoked.
It has been declared as illegal. It has been declared as illegal and unauthorized by the Registrar General of Marriages. Lordship, kindly.
So that is under there will be an appeal.
Lordship, it is an appeal. The matter is for an appeal.
Why before this court? You challenge the order of the Registrar General.
Lordship, I have only been informed by an RTI that my marriage certificate has been cancelled. He fixes the date.
Which matter? It is listed matter. It is listed.
140 to read.
Yes. Wait, दे दो कोई 345 number.
Mentioning upon notice, kindly fix it.
So the matter is listed as item number
141.
144.
140.
140. देख कर check कर लेना. 140 of today's list. And counsel for the petition and mention the matter and paying for fixing a specific date and time for hearing of the matter. In view of the submission made by the counsel for the petition, let the matter appear on 23rd July at 3:45 p.m. Solicitor, the petition is directed to inform the next date of hearing to the respondent authorities and to file the affidavit of service on the date fixed. Yes, call the list.
Item number 1 to be mentioned.
Why to be mentioned?
What? This matter was mentioned. This writ petition, will recall that Mr. Jishnu Shah was leading me in this matter with regard to the civil reporting the loss of my company. Now, during the course of hearing the last order of 12th of June,
19
June. Yes, it was pleasure to directing the parties to submit the details of the amounts which is required to be paid. This is the matter where the division bench order of IP Mukherjee recorded the principal amount has been paid off, the interest falls due. Now, today, Malad, so far the interest is concerned, we have prepared a certificate from the chartered accountant which shows the amount in terms of the OTS. The interest calculated in terms of the OTS is 1,46 lakhs and odd. Now, this money, this is the.
What is the bank claim?
Now, bank, I'll just tell you, the bank has, yes, bank has filed an affidavit. Bank has filed an affidavit with a 2-volume. Now, if Lordship's pleasure to take, the affidavit is 2 pages. Rest are. Now, paragraph 3 of the bank's affidavit, it records that current book balance
5 crore 35
Now,
lakh.
how it coming? He's saying is credit 5,700 rupees. That's the same figure. Then legal expense, accrued interest. Accrued interest, the period of interest is up to date. The bank statement which is given from 2010 to 2026. So bank is not calculating in terms of the OTS. Bank is calculating till date and has come to accrued interest of 5 crores 35. This is for one account. If Lordship turn over to the next page, the other current account which is 9927, it also they admits 1 rupee. Then what is the civil reporting is 1 rupee. So the principal is paid off. That's same thing which is recorded in Justice Mukherjee's order. Then accrued interest 1.14 crores, and then penalty it's coming to 1.29. So this is on account of interest. Now, today, in terms of the OTS, once I pay the money, you appropriate my money in terms of the OTS, a part of the money, the principal of the money. And then you say that you, and the rest, so when interest is concerned, you say the OTS is not applicable. This can't be. The half of my payment is in terms of OTS, and the balance you say the OTS is not there charging interest. In terms of the OTS, if I can place
Where
the...
is that Justice Mukherjee
Yes, Justice
order?
Mukherjee in the petition. Justice page 31. Petition yeah, page 30. Sorry, madam. Page 31 of the petition. Justice Mukherjee's order. Page yes, on page 32.
Yes.
On 16th of March, the bank, by letter of approval of compromise offer, the accepted amount is 4.11 crores, which has been described as a one-time settlement. This settlement amount was to be liquidated by down payment of 5% amounting to 20 lakhs and odd, and the balance by equated monthly installment. On 27th March, WBIDC decided to issue a show cause to the appellant for declaring them as a willful default. Apparently, as per the master circular of Reserve Bank of India. On 6th of April, then when the show cause goes, next page, with regard to the first ground taken by Mr. Such and Such, which is considered by us to be most important, it does appear from the supplementary affidavit prepared and filed by the appellant that from January 15 till August 2020, substantial payments aggregating to 4.11 crores were made and only interest amounting to 1.46 was outstanding. Furthermore, Mr. Sajjan has submitted that his client is willing to repay whatsoever amount outstanding in terms set by the court. Then Ms. Lairi's submissions are recorded that the outstanding, the hand-upper statement showing that the outstanding dues, credits and adjustment in relation to the account of the appellant. She prays further time to produce more accounts. It would not be necessary in view of a submission that what is due and payable by the appellant to the bank is interest, as stated by her client in the affidavit. The principal sum appears to have been paid. So the principal sum of 4.11 was paid. In such a situation, prima facie, it is not possible for this court to accept the appellant could be declared as a willful defaulter. Prima facie, the intention to deprive the bank appears to be lacking. The factum of periodic payment by the appellant of the loan amount which has resulted in repayment of the entire principal and their willingness to pay off the outstanding would at least prima facie not depict the appellants as willful default.
So as on the date of the order, as on date of the order, what is the date of the
22nd August 22.
22nd August 2022, the interest is 1 crore 46 lakh 98.
My lord.
Correct. And as per their calculation, as on date, 5 crore 35 lakh.
In respect to one account,
No.
and the other one.
Correct.
If we add that with 6.5, if we add both the thing. Now, if you go back to the OTS, because this order is based on the one-time settlement was proposed, the OTS is at page 28 of the writ petition. Yes. Now this is this OTS of 2015.
Correct.
Now the order is 2022.
Correct.
We are now the OTS. Amount of acceptance is 4.11. The first column.
Correct.
Has been paid off. Down payment 5% done. Those have been done initially. Balance payment 18 equated quarterly installment of 26 lakhs.
See,
Now the interest component.
that is not, that's the interest compound. So admittedly, you're not paid the even the order of the division bench, you're not paid the interest of 1 crore.
But we have by letters, we have offered them, letters are on record. They were ready to pay you 1 crore, they refused.
Correct.
Bank refused to, because the bank tried to, bank's contention is OTS has failed. So I said, I'm ready to pay you, it has failed. Now what's happening, bank, the issue before now is bank is reporting loss before CIBIL on this account.
Correct.
They have a recovery proceeding before DRT.
Correct.
Once bank is reporting loss after getting the entire principal, now can the bank report loss to the CIBIL?
That is the main issue.
That is the main issue. Now by reporting loss to CIBIL, the mechanism of CIBIL, my score is falling. That's it. But
so what is the contention? Your contention is only 1 crore 40.
I am ready to pay 1.46 and whatever the interest here, I am ready to pay this. The interest company is the OTS only. Interest will be applied and realized base floating rate on reducing balance from 19 January 2015 to the last date of payment of the entire compromise amount.
Correct. What you are claiming 146.98, that is the same of the order.
They're the same of the order. They're the same of the
order.
But
correct. Now, 2022, you lost your chance because 2022 court has given a direction, you not deposited the said amount. So bank has to charge the compound interest on that.
Now, for charging a compound interest, so far this order of Justice Mukherjee is concerned, we offered them, bank did not accept. Yes, offered us to the.
So you could have been taken the order from this court without prejudice. You have not taken the order from the court.
No, but today, my
who will take the risk of the bank? If today the manager will accept this, who will take the risk in future?
No, the recovery proceeding is there. The recovery proceeding is there. Whether bank I'm not saying bank to settle in 1.46 or in a full and final settlement. To that extent, I cannot go in this repetition.
So
I am only contention if I pay you
146, you will pay.
Yes.
And they will clear your civil.
The loss reporting.
Loss reporting.
They can argue that sub judice.
With regard to the interest part, that is to be decided whether you are liable to pay or not.
With balance, that can be. Only the loss reporting is what happened, Malad, in Justice Mukherjee's time also.
I understand.
They say this sub judice.
See, that's why.
This that they want to pay this and their reporting can be
taken out.
The reporting is we have I have placed on earlier occasions also. Not only in respect of these two accounts, they are directors in other accounts also, which are also NPA, and the bank has to, as per the rules and the act, we have to report everything.
Every total needs to be taken.
All bank will bank. That I have placed. I will once again place that, Lordship. However, whether if they want to pay, Lordship, it is not that they want to pay, bank refuses. It can never be so. They say we want to pay in terms of the OTS. We say that no, the OTS is not surviving as on date. So that is the dispute. Now, without prejudice, if they want to pay that, there was
no even OTS survive also. The
OTS does not survive. Today, indirectly, they are trying to get an order of your lordships that the OTS is binding on the bank, which they cannot do in terms of Arvind Electronics and others. So, Lordship, I can take it. I will.
You do one.
If the bank is going to receive a substantial amount, the bank might say, and then they can.
With regard to the interest, yes.
With respect to that account, whatever the.
With regard to the interest, the court will decide whether the you are one OTS continuing or not.
Not
continuing. Now, with regard to the at the final stage.
Yes.
Normal.
And you also think if suppose they will say yes 1 crore 40 you deposit and tomorrow they other matters are there, then again
I'll tell you
your civil repeat is continuing. So what will happen?
No, Lordship.
No.
It is voluntarily done. It is the CIBIL is of the company.
Correct.
The CIBIL is of the company. The petitioner before Lordship.
Correct.
So
petitions also before you.
No, that's the only the director has come in as the capacity director.
Now that's why
So it is only
you
the
check also.
My lord.
If she will take the instruction, I don't think the bank will refuse
refuse.
that.
But
That is the
once we're
subject to
saying
subject to
the
outcome of the-
other my directors or other entities or other individuals separate loan accounts cannot be clubbed with the company's loan account.
The
But just one submission, Malaz. I filed an application, Malaz. All these days I had indicated to
You
you.
are appearing for whom?
Malaz, I am an applicant in J1. Your Lordship knows I am appearing for.
Who are you?
Malaz, I am the brother of the petitioner. Your Lordship knows that there are disputes pending. Malaz, all these days we indicated to your Lordship that we don't want to intervene in the proceedings or agitate our case unless and until our properties are encumbered, because this has happened in proceedings earlier.
So-
Malaz, on the last occasion when Mr. Learned Senior Mr. Shah Malaz was placing their case, Malaz, he relied upon a particular deed that was made over to the bank. The bank had verified upon inspection that the deed is valid. Now, Malaj, we had noted down the deed number. We found that that particular deed pertains to an NS Road property which they could not have mortgaged to the bank at all. In fact, Malaj, there are family disputes that are pending
cannot
between
be
the party that your Lordship is aware of. The difficulty here is, Malaj, that today they are making over a property to the bank and saying that you can check these title deeds and you can clear off my loan accounts, when they, Malaj, are not entitled to, Malaj, place those documents. They're not entitled to make over that particular property. The property was supposed to be in terms of a family settlement.
That I am not deciding. Yes.
There is no subject matter. No. When
The,
given to the bank illegally, that cannot be decided here.
the petitioners
No,
have
no,
filed
keep bullshit, bullshit.
a certificate on computation of delayed payment interest under the OTS and submits that the petitioner is ready and willing to pay rupees 1,46,98,630 being the interest amount, being the delayed payment interest as per computation
On the OT and in terms of the OTS. man.
of the OTS.
Under the OTS, yes. Obliged.
Under the OTS. Full stop. The bank has submitted the report, submitted an affidavit disclosing documents and submit that in one account against the current bank, bank account number
No.
50018621165 in the name of the petitioner company, the credit is rupees 5,710 only, and the other legal expenses is rupees 18,437.50, and the accrued interest is rupees 5,35,84,905. And with regard to another current bank account number 50022869927 in the name of the petition company, the credit is rupees 1 and accrued interest is rupees 1,14,60,743, and as on 16/6/2026 the arrears penalty is rupees 14,69,141, and the net discharge amount against the said account is rupees 1,29,29,885. Learned counsel for the petitioner submits that the petitioner is ready to deposit the amount of rupees 1,46,98,630 being the delayed payment interest as per computation on as per the OTS.
Right.
As per the OTS. Full stop. And submit that with regard to the further claim of the interest as he submits that the further interest claimed by the bank shall be subject to the outcome of the present writ application. Learned counsel for the petitioner, learned counsel for the bank submit that the petitioner is intending to take the benefit of the OTS dated 16 March 2015, but the OTS has OTS is not ineffective.
Yes, it has failed.
But
this I dispute, but-
the OTS has failed as the petitioner has not complied with the terms and conditions of the OTS. Thus, the petitioner cannot take the benefit of the OTS. She further submit that she will take instruction from the bank whether the bank will accept the amount of rupees 1 crore 1,46,98,630 subject to outcome of the result of the present writ application, whether the petitioner was liable to pay the further claim as claimed as demanded by the petitioner.
She will also record that they will remove the loss reporting. That's important.
The
That is the most important thing.
The petitioner submit that the petitioner is intending to deposit the said amount of rupees 1,64, 46,630, only for the purpose of clearing the civil report. Civil report. Police.
Mention the loss reporting because that specific civil reporting has to be
The
done.
loss reporting should not report.
The land counsel for the respondent bank submit that she will take instruction and make appropriate submission on the next date fix with regard to the acceptance of the amount and the civil report. Let the matter appear. How much time will it take? Within a week? Let the matter appear on
next Monday. Monday, Monday can be holiday, maybe.
Monday you come?
7th. No. Holiday.
Yeah.
Might is already no might. There is no might in it.
8 July.
8.
Time fixed, my lord.
No, to be mentioned.
To be mentioned.
আরে কেন করাচ্ছ জানো তো না ডায়েরি ফিল আছে নিজের পেপে পড়ছো
He is very punctual at the time.
Falling in the trap.
The energy is very punctual at the time.
To be mentioned. Is there to be mentioned? Why?
Yes, next.
Our application may also appear on that.
Obviously,
Let
they're
it
together.
Yes.
An offer is being made.
Next.
Obliged.
Time is consumed.
Loss reporting company going.
I had told not the
Joint development agreement.
and the relevant process have been left out, not those things.
Exhibit A देते हैं? अच्छा.
But on the last occasion, your lordship recalled that sale, transfer or dealing with the property, specifically no consent would be required and execution of this agreement would be construed as a consent. I have indicated to your lordship, now not kindly it comes to clause 11.8 that your lordship would find
Yes.
I'll place the developer shall in consultation with the owner and her approval frame the rules and regulations regarding the and regulation of common services and also common restrictions. So, Lord, parties had contemplated two situations.
Yes.
Situations where Lord, no consent from the owner is required and situation where consent would be required. So, Lord, today there is no Lord the owner or Lord the plaintiff cannot say that it was a usual clause written. So, Lord, parties were conscious about what are their rights. My Lord will also come to clause number 11.1 and 2.
11 point?
Page 24, Lord, 11.1.
Yes.
The owner and the developer have entered into this agreement purely on principle to principle basis. And nothing stated here,
and nothing stated herein shall be deemed or construed as a partnership between the owner and the developer in any manner constitute an association of persons. Each party shall keep the other indemnified from and against the same. 11.2, the developer shall be entitled to nominate this agreement purely on principal to principal basis, and nothing stated herein shall be deemed as a partnership, and the developer or as a joint venture or joint ventures, nor shall the owner and the developer in any manner constitute an association of the parties. But why I am showing this? So there is a case made out in the claim that I would have required a consent, some kind of supervision was required. No such understanding was between the parties on the date of execution of this document. It was principal to, so I knew what I had to do. The owner also knew what I was to do. I had a complete freedom to do whatever in the manner in accordance with law. And more so,
What is the main allegation?
The main allegation is a portion, I'll take your lordship to that, 2 portions of the property sold to the different number 1. Now, they say without their consent, I have sold it to them, which I could not have done. Because 1, I did not have the power to sell. Second, they are using it commercial. This is the long and short of the story. Now, admittedly, land is there, development agreement done. I have put my hard-earned money, construction made, and thereafter, whatever it follows, so interest in the land has already been created in my favor because the construction has come up. Now he cannot turn back and say, no, I am cancelling this at my whims and fancy. Look, this is what I have to show to your lordship with respect to the joint development agreement. Now, kindly comes to Exhibit B. But I also do not know, although this point is not German today, but how a certified copy has come up in evidence without even one explanation. Where is the original or where is the whereabouts of the original? See that as you may, because this is an admitted document, but I don't get that. Kindly also takes the print once, because the photocopy of the original is there in the plain itself. Page. Kindly comes to page 79 of the plane. Perhaps straight away comes to page 84. I understand your lordship has a legible copy because
page
84 of the plane.
Yes.
Clause 10, your lordship has.
This is Exhibit B.
Exhibit B. Although Exhibit B is a certified copy,
yes.
This is a photocopy of the original.
Yes.
To file, submit, appear, and represent me before a notary public, registrar of assurances, district sub-registrar of assurances, metropolitan magistrate such and such authorized, having jurisdiction to execute, present for registration, and to acknowledge and register or have registered all deeds, instruments in writing.
This is a power of attorney.
Power of attorney. Who has given? Lord, kindly straight away comes to.
And who got this this power of attorney exhibited Exhibit B? Yes.
Document. Kindly Lord comes to page 79 once. Who is giving it? The plaintiff is giving it in favor of whom? The defendant number 2. My take.
Have that challenged this power of attorney?
Rather, they have pleaded it. Lord, I'll show to your lordship when I place the plane. But for your lordship satisfaction now, for the time being, Lord, kindly comes to page number 7. Lord, kindly comes to page number 7.
Of plain.
of the plain. Paragraph 7. Page number 8. Although, my lord, I do not know why one word has been missing in this pleading. That you should find. My lord, last paragraph, clause 10. Verbatim, my lord, they have quoted to file represent. The lord should have seen that. So, my lord, this is a specific case. And my lord, this was the situation when the and this was done on, my lord, January 19, 2006. Immediately after, my lord, the development agreement has been executed. Because, my lord, all of us know, my lord, without this development power of attorney, my lord, things cannot proceed for construction. Now, my lord, kindly comes to Exhibit C that your lordship would find at, my lord, page 51.
Of the plain.
Of the blood
Plain.
that is before cover. That is before. This is Exhibit C, right?
Page
51. This is also a very vital document. Look, these are the flip of this entire piece.
Yes.
First, joint development agreement. Second, power of attorney. And third, this minutes of meeting whereby parties understand whose allocation with respect to the owners and developers, what are the properties to be gone. Lord, your lordship sees, Lord, who are present, Shorbani Banerjee and the defendant number 2. By and under the agreement for development such and such made between such and such, share obligation in equal share. By and under the said scheme of development, 50% of the total built-up area of the proposed newly constructed building has been agreed to be shared and allotted unto and in favor of respective parties. It is further agreed that immediately after the building plan of the new proposed building is sanctioned by the KMC, the parties hereto shall identify their respective allocations in the built-up area on the copy of the said plan. Not usual understanding what happens. 50. In terms of the said agreement, look, this part is very important. Entirety of the built-up space of the 5th floor shall belong to the owner exclusively, whereas the entirety of the 4th floor shall belong to the developer exclusively. Now, this portion not in dispute. The total built-up space of 3rd floor shall be divided in northern and southern part in equal half share. The northern part of the built-up space on 3rd floor shall belong to the owner exclusively, and the southern part to the developer exclusively. So, look, this part is also not in dispute. The total built-up space on the 2nd floor shall be divided into northern and southern part in equal half. Northern part belongs to the developer, southern part belongs to the owner. The transfer with respect to the 2nd floor's portion is the northern part.
So second row divided northern and southern. The actually southern will be the developer. And northern southern will be
northern built-up space belong to the developer exclusively, southern to the owner exclusively.
Correct.
The northern part of the 2nd floor has been transferred in favor of the developer 1. Admitted. So, developer's allocation has been given.
So this is the dispute now.
The second dispute is subsequent. Roman 4. The 1st floor shall be utilized for commercial purposes, and the entire proceeds out of sale and or transfer of the total built-up space in the 1st floor after defraying all expenses shall be divided between the parties, owner and developer in equal half share. No allocation. The question of whom I am selling to whom, how I am selling, not important. They are only interested in this is the sale quantum, whether I have received 50% or not. Their right is only restricted to that, nothing more.
So this is also dispute.
This is also disputed. They say how I could have sold this property to defendant number 1 because I did not have right. From where, Lord, I do not know. Lord, this.
So the deed executed, registered
yes.
in terms of the power of attorney.
Yes. not in on 2 dates. But
Okay.
first-
Okay.
But the part of the ground floor, this is not German because the ground floor is not in this. So this was kindly page 54.
So ground floor, there is no decision. Only this.
No, there is no.
That with regard to northern, southern, and this is the ground floor.
So, there is only one allegation with respect to generator and all. They have not proved and they have not pursued that claim, I understand, because nothing is there on evidence. Kindly comes to page 54. Accordingly, the second paragraph, you would find the entire plan was made with allocated space with red borders, whoever what is to be receivable, and not signed by both the parties. This is also not has gone an exhibit and proved. So plaintiff and the defendant number 3 and defendant number 2 is signing here as the deal. At this juncture, he became the deal. Now, this is the basis on which parties enter into a transaction.
What is the contention about this document by the plaintiff admitting this?
No, this is also one, if I'm not mistaken.
There is no issue. There is no issue. There is no issue with regard to the stamping.
But I understand no stamping would be required because this was prior to 2012.
Okay.
But stamping came into question after 2012 amendment of the Stamp Act. So this was in 2008.
Okay.
And in any event, it has gone in exhibit. So
That's why I'm asking. That's why I'm asking whether it.
I am secure on that score. Even that. Now, this being the plinth of the case, may I now place the plaintiff before your lordship? What is their case? Kindly take the plaintiff. Paragraph number 1, 2, 3, 4, not relevant. Kindly straight away come to paragraph number 6. The plaintiff, as the owner of the said premises, entered into agreement dated. So, exhibit A, admitted case, there is a photocopy of the agreement such and such. The agreement dated contains arbitration clause. None of the claims made by the plaintiff in the claim such and such, that is also irrelevant today. Paragraph number 7, the plaintiff executed a power of attorney dated such and such in favor of defendant number 2, thereby nominating defendant number 2 as the true lawful attorney of the plaintiff with power to do the acts, deeds, and things mentioned therein. So it is their case, their pleading. Now, straight away comes to page 8. I have shown to your lordship. So it is their plain case that I had the right to deal with the.
That's the condition of the power of attorney.
And they are pleading also.
Yes.
Now, kindly turns over. Now, kindly comes to page 9.
Yes.
Your lordship sees the proviso, that's a part of the power of attorney, provided that my said attorney shall furnish
information in particular
such and such. This was given, admitted in the evidence also, in the witness also, and the plaintiff also. Now, kindly comes to the second paragraph, the third paragraph. The said power of attorney dated such and such was executed on a non-judicial stamp paper of ₹50. And the same was registered before such and such within the jurisdiction of such and such. Now, there one of the contention was that this is insufficiently stamped, so I couldn't have transferred. Now, kindly consider Article 48 of the Schedule 1A of the West Bengal schedule. Perhaps it's marked there.
Each eye.
But 48,
Yes, yes,
Article 48,
yes.
power of attorney. Kindly note comes to D. When authorizing not more than 5 persons to act jointly and severally in more than one transaction or generally. So, not here, only the defendant number 2 was authorized.
When authorizing more than 5,
More than 5.
but not more
Not
than 10.
Than 5, then rupees 50. And more than 5 rupees 100. Here, Milord, only one defendant number 2 who was authorized. So, Milord, 50 is the accurate stamp duty that has been paid. Now, the other point, Milord, that they have tried to indicate kindly comes to Milord F, clause F.
Yes.
When given for consideration and authorizing the attorney to sell any movable property. So, Milord, if the power of attorney is coupled with some
Interest.
consideration in the nature of sale, Lord, Your Lordship, this thing, Your Lordship would also find in the 2001 amendment of the Registration Act, Stamp Act, everywhere, Lord, this amendment was introduced as a whole. The reason was through power of attorney, sales were conducted, out of consideration was also taken. In this situation, Lord, the power of attorney was executed to sell on their behalf, receive the money, and then will not again give it back to them because owner's allocation and developer's allocation was there. So, Milord, with respect to developer's allocation, which is an interest created on the land, that is of a peculiar nature, Milord. Our special bench has also held that if a development power of attorney is executed, Milord, then this becomes an exception. Here, there is no such case, Milord, that out of consideration, some consideration, Milord, the power of attorney was executed. I have shown Your Lordship the entirety of the Milord power of attorney. So, Milord, the F does not apply.
Yes.
Now, Milord, kindly sees paragraph number 8. On or about such and such, the plaintiff, along with her husband and only son, left Kolkata for New South Wales, Australia. And since the end of January 2006, the plaintiff and her said family members have been and still are residing in New South Wales.
Yes.
So this is the reason for which the power of attorney had to be executed.
Yes.
Since December 2006, the plaintiff along with her family members has been coming to Kolkata once in a year, and whenever she comes to Kolkata, she resides at the residence uncle's premises such and such. In 2008, the plaintiff and her family members became citizens of Australia. Now, Milord, that's the reason. This is the reason for which, Milord, that proviso part I indicated to Your Lordship is existing. Milord, paragraph number 10.
Yes.
As per the said plan sanctioned by such and such corporation, the ground floor of the proposed 6-storied building at the said premises was to be used as car parking space only. Apart from the 2 shop rooms of the existing tenants of the plaintiff, according to the said plan sanctioned by the KMC, the first floor of the said 6 stories building was to be used for commercial purposes only. The remaining 4 stories, such and such, for residential purpose. So, Milord, this is another limb of their case that I had, Milord, transferred a portion of the 2nd floor. First floor, there is no dispute, commercial utilization. With respect to the 2nd floor, Lord, they are saying that because it is residential, I could not have transferred to a commercial entity. Now, Lord, this aspect is neither here nor there. Lord, the corporation.
No, as per the sanction plan of the Kolkata Municipal Corporation, the ground floor of the proposed 6-story building at the premises was to be car parking space only.
No, the ground floor. There is no dispute with that.
Ground floor.
Ground floor, there is no dispute.
Correct.
Lord, the only dispute here is first
Apart
floor
from
and
yes,
2nd floor.
According to sanction plan, first floor of the 6-story building was to be used for the commercial purpose. Remaining 4-story, 2 second and 4 proposed to be yes, no
The
problem.
dispute here is only with respect to the first floor and second floor.
Correct.
Not second floor. Why the dispute? Because this was
Northern and
residentially sanctioned, but they allege that I have sold it for commercial usage. Now, two things. One, this cannot be the subject matter of this suit. The usage of the property. With respect to corporation, they have failed to show any notice even or any letter written by them to the corporation complaining about the misuse of that space or wrong usage of that place. Nothing has been done. And they have also failed to show that they have suffered some kind of damage or some kind of encumbrance for the said sale. The issue here is only with respect to one, that I did not have power to sell or I have misused by power of attorney. This aspect does not surface with respect to such allegations.
so if suppose also because there is no dispute with regard to the construction. There is no dispute with regard to the all measurement and all these things. Only with regard to the commercial and allocation of the first floor.
But allocation also
That is also not there. Only with regard to that.
Why I have not taken permission from them for selling number one?
What is the prayer?
But kindly straight away comes to page number 34. Decree for declaration that the registered deeds conveying such and such executed by defendant number 2 purportedly on behalf of such and such, and this is with respect to the first and second floor. August 17, 2010 is the first floor and March 4, 2011 is the second floor. These are the two deeds which by way of which I had transferred. That decree directing the defendant deliver cancel, decree for possession against the defendants and each of them in respect of the portion of the said premises, mandatory injunction to defendants here makeover peaceful possession, decree for mean profits such and such, in the alternative inquiry damages, perpetual injunction on claiming right.
So with regard to the you are the developer.
Right.
Correct. And you got northern portion of the second floor. Second floor. First floor is the commercial.
Right.
Commercial. And commercial is sold it out. If it is sold it out, how the plaintiff will be affected?
But at least we do not know. Because with respect to the first floor, they were only entitled to receive money.
Correct. That's why. So if it is sold it out, so she is not the owner now. She is not the owner, and there is no allegation that you have sold the amount. The amount has not been paid. You have paid.
That amount has been misappropriated.
Misappropriated. That is not the case. And with regard to the first floor, the southern or northern portion at all.
Only southern portion.
Southern portion, and she is occupied that.
With respect to first
That
floor,
has been occupied by her.
No, with respect to first floor, the understanding was entirety will be sold. 50% of the sale proceeds will go to them. That was the understanding. So no allocation with respect to first floor.
First floor, no, ground for second floor.
Second floor.
Second floor, northern portion is a developer. And southern.
My allocation, I've sold it to different number 1.
Okay.
And she is enjoying her portion, whatever she was entitled to.
That's why
There is no allegation that I have not made over whatever.
That's why with regard to that second floor allocation is also not dispute. Only the commercial portion.
Whether it was, I could have sold it for commercial usage or not. And I shall indicate to your lordship from the evidence also that it has come up from the evidence, through the evidence, that the second floor's portion is not being used commercially. I might be a commercial entity. That does not mean that I use all premises for commercial purpose.
Okay.
If a company acquires a flat for residential accommodation of a director, will that be for a commercial use?
And the total property remains in the name of the plaintiff.
But after, not for that, I'll show that
So
judgment.
what will happen? What will
The
happen to
developers
that?
agreement, once the construction comes up, the developer's allocation, a vested right is created upon the developer. The owner's
Correct.
allocation, she remains the.
Correct. That's what I'm
But
telling.
not on papers, not that for transferring the property, not the power of attorney is required, because formally on records, the owner is the developer. I'm sorry, the owner remains the owner. That's why the developers.
That today, who is the owner?
Not today the land, Lord, if your lordship says that belongs to the plaintiff, but I have as a developer a vested right through this development agreement. That is how, Milord, our special bench has clarified the position of developers agreements. The judgment specifically says that this is of peculiar nature, of peculiar transaction. And that's the reason why, Milord, this 2000 amendment was brought in and 75,000 stamp duty has been fixed for entering into a development agreement, because interest is being created on land.
Yes. Okay. Come next day.
But Friday, I think.
Friday is fixed.
Lord, may I, Lord, request your lordship, Lord, to fix, Lord, two other dates, Lord, so that your lordship's.
শুক্রবার আসবে না ওই প্রিন্টটা করে প্রিন্টটা
So I asked Mr. Prabhakar, we can itself not wait for.
Friday.
So I try to be as brief as possible, Lord.
No, next day I will hear first, Mr.
Friday.
I will hear subsequent.
The Friday I have to make submission.
Come ready.
Friday. Okay. So
I understand. So what is your claim? Let me understand.
No, but Mr.
I have my right to show the evidence. If your lordship
No,
requires.
that's fine. Let me understand with regard to the what the plaintiff's claim.
Plaintiff's claim. The Friday I will make
The plaintiff's now the overall it has come. Now the plaintiff, what is the plaintiff's claim? Let me then we'll see to that. What is the law point is to be decided.
Lord, only.
At the next date.
Counsel for the defendant has argued the matter at length, but due to paucity of time, the hearing could not be argument could not be completed. Full stop. It is fine from the record. The matter is already fixed on 7th, 3rd. Already fixed on 3rd of 7th. Hey. 3rd July at 3:30. 3 p.m. 3 p.m.
Can continue, my lord.
As well as full stop. Let the matter appear on 3rd July as well as 7th July at 3 p.m.
Lord, other dates, Lord.
7
July.
Oh, 7 July. Oh,
Grateful.
7 July. By chance.
Great.
7 July.
7 July, 3 p.m. 7 July.
7 July is 3 p.m.
3 p.m.
Yes, call them.
Lord, Mr. Bachawat was making his submissions for the respond number 5.
Yes.
It has been some time since your lordship has heard the matter. It has been some time since your lordship has heard the matter, my lord. Only to recap, my lord, in gist. The petitioners, my lord, they are persons, my lord, who had purchased shares, my lord, through a broker, which is the respondent number 1. There were, my lord, allegations against this particular broker, my lord, for unauthorized pledging of shares. Lord, into that, my lord, SEBI, which is the investigating authority, Lord, they had conducted investigation, and my lord, they had passed, my lord, 3 orders.
Yes.
Lord, pursuant to those orders, my lord, the broker was held liable. And my lord, there were certain directions passed in those orders, which was, my lord, really for returning the money back to, my lord, the shareholders who would have been affected. But after those orders came to be passed, my lord, there is, my lord, an investor protection fund, So whoever has lost the money, they can apply, my lord, to that fund to get back, my lord, compensation. So the petitioners had, my lord, applied there and had, my lord, gotten compensation. To the extent, my lord, there is a shortfall, they have, my lord, filed this suit, my lord, against the broker, my lord, the shareholders of the broker, as well as, my lord, ex-director shareholder, which is really, my lord, one of whom is me. The other is, my lord, the respondent number 6, which is, my lord, Mr. Thakkar's client. But here, my lord, if I may, first, my lord, if I may, my lord, first place those three orders, because those three orders of SEBI, my lord, those are the basis for, my lord.
That is Mr. Bachawat has already argued on that.
My lord, only, my lord, to show, my lord, to what extent, my lord, what's the final order, my lord, that was passed.
Yes, yes,
Mr. Bachawat is here, my lord.
yes, yes, already argued. Yes.
वो बोल
You
Yes.
finish summarizing, you finish summarizing that.
Now he's on the three orders.
Yes. Well, little unlucky. On days when I'm there in time, Lord, that Lodha matter goes for 6 today. But now, so Lord, if I can just not summarize, I'll take your lordship into the orders last. I'll tell your lordship why there's a legal point which arises out of the orders. So, Lord, my learned friend's case, I'll summarize in 2 sentences. Is that there is a broking company. I was a director and shareholder. He has done transactions through him. The company has then misused his pledge shares by his shares by pledging them to HDFC Bank and other banks. The banks have exercised their right and sold pledge shares, although there was no pledge created by them, or it's been done improperly. This is not really their argument. So they say, look, the broker company is liable, and all the directors should also be liable, and their shareholders. Now they say I have no connection with them now, but I was the brains behind it. Now why do you have to say that? But the reason is very simple. I had not resigned and gone long for the long. That point of time, your lordship, I don't know whether your lordship has the notes, otherwise I'll summarize very quickly what my connection with the company was. But one, I was not engaged in any day-to-day activity of the management. That's not, I'll just give your lordship the para numbers. That's para 11A of my affidavit. I'm for the respondent number 5.
11A to CE.
Yes. 11B is that when the business was handled by this one, people were designated. So under the stock exchange rules, designated. Para 11C, you will find a resigned on 17th of September 2018. All the acts which are talked about have happened long thereafter.
Yes.
The pledge shares were sold by the banks, if I'm not mistaken, sometime in 2020. Just check the date and tell me. Now, I have also specifically said that I have never or had any. So I and I have done that one. See, because a broking firm, also the Ministry of Corporate Affairs. So those are all on record. This show had left. Now, I've also said my shareholding was reduced to nil by September 2018, and the NSE acknowledged that acknowledgement letter at page 56. Also, when I exited, since I had a dispute with those other people, I asked them to change the name of the company because it was associated with my other businesses.
Yes.
So the name was also changed. I told them I'm not permitting you to use it. That letter is 14th August and that's also annexed, and they changed the name to BRH thereafter. But I also have other complaints against them. My name has been forged on personal guarantees by them. I've informed HDFC of it. Writing that I am not in the country, so-called bank guarantee, personal guarantees were executed. Now, a forensic audit was carried out by the statutory authorities in the course of their investigations, and they note that my signature is forged. They also note that I have also lost a lot of money, and money is outstanding to me, blood running into crores. So blood, he is not the only loser. I'm also a loser. 54.66 crores is the net debit balance in my favor. Now, in addition to this, blood, after all these things happened, well, after the blood, the banks had enforced their pledge, blood, a writ was filed in Gujarat seeking a direction on SEBI to take action against me.
Yes.
And your lordship will find SEBI filed an affidavit saying that they had investigated and there was no involvement of this respondent after the forensic audit. That's at page 66. And the writ petition was disposed of on 29th of June 2022. And the economic economic wing had the criminal proceedings in Delhi. They go into it. They've also filed a status report saying that the respondent number 3 was the sole authority to decide all financial matters. I have no connection. Now, in this background, pledge of shares that he is talking about have obviously happened after I have left. I'm not connected to the pledge of shares. I can't be liable. That's the other part. Now, there are 3 orders of the SEBI in this case, which are annexed, and there is no finding against me. On the contrary, your lordship will find by the second interim order of 2nd of January 2020, now your lordship can make a note of the page 236. I've placed all this. That's why I'm not placing it again. At 236, now the order is at 236. At 249, para 10, an order is passed saying that the role of the respondent number 5 and 6 should be looked into by a forensic audit to see if we had any role in the unauthorized pledge of shares based on an oral submission of the respondent number 3, who is the level of the piece. Since he was in court, he said, look, catch 5 and 6. So based on that, when the final order comes, the finding is that the respondent number 3 was managing the affairs of the respondent number 1. That's at page 398, para 60. And there is no finding against me. So, my lord, I am exonerated, I go scot-free.
Yes.
And the pages of these 3 reports, my lord, if your lordship sees, my lord, makes a note. One is the SEBI affidavit in Gujarat. But in the affidavit in opposition, SEBI says at page 66, after the forensic audit.
Page 66
of my AO. Respondent number 5 is affidavit. No department. Please see para 4 at page 67.
Yes.
As the respondent number 3 did not find any evidence of involvement of respondent number 5 and 8 in the unauthorized pledging and misappropriation of client security of respondent number 4, it has been decided no further enforcement action from the Sansing respondent against R5 and R8 is necessary. So, yes. The statutory authority which goes into it carried out a forensic audit, found that I have no involvement. In addition, give me page 69. But in addition, your lordship will also take page 69 of the same affidavit.
Yes.
Page 79.
Yes.
At page 79 of this report, this is the economic offences being blood. Their report, page 79, para 13. During police custody of Mukesh, it came to notice that Anu Bhattar was the mastermind and sole authority to decide on financial affairs of the company. So it's not me, it's respond number 3. Loans against securities was the brainchild of Anubhav Bhattar, and he alone decided utilization of proceeds obtained from the loan investigation on the part of Anubhav Bhattar and Shiv Kumar Damani is yet to be finalized. Out of 3 directors, only 1 director has been arrested so far, and the other 2 at large, etc., etc.
Yes.
So now I'm going to also take the SEBI third final order. That's in the petition. Petition page 396, volume 3. Hey, But this is the concluding portion of the SEBI third final order. Now, please take page 396, para 57.
Yes.
Now, the other thing which I forgot to show Your Lordship, I'm just telling Your Lordship this orally. Your Lordship will find that I'm not a notice because I'm found to be clear. Now, the finding at 57. As already stated in the preceding part of this order, notices 1 and 2 have violated service circular by misappropriating client funds. Said related entities have also played a major role in misappropriating the security and funds of the claims. Further, notices 3 to 6 were director of notices during the period when misutilization of security was happening. The same hold. The actions of the notices fall within the definition of fraud as defined in regulation so and so, and thereby they attract the provision of section 12A of SEBI read with section so and so. Further, such actions also attract the provision of regulations from February 1st, 2019 till the date of the. So there is no finding against me, no relief against me, nothing. Then what the actions are set out. And if Your Lordship comes to page 398 once. Yes,
Yes.
And question of monetary penalty to be imposed on respondent numbers 4 to 6. And they've already undergone debarment pursuant to interim order for a period of more than 3 years. I cannot also lose sight of the fact that notices 3 was managing affairs of notices 1 and 2, which is also borne out by the settlement agreement entered into between so and so. In view of the same, and of the considered view that no further directions for penalty are required against them. And then, my lord, Your Lordship will find, Lord, at page 400, and this is got the submission made was, I have lost, let's say, 10 crores. I have got back 50 lakhs. So I'm out of pocket for 9.5 crores. But please see the relief, page 400. Finally, so far as to notices 4 to 6 shall stand vacated. Notices 1 to 3 shall jointly and severally be liable to refund the monies due to the investors of clients of notice 1 under supervision of NC. So there is a full disgorgement order. Notices 1, 2, 3 shall jointly severally be liable to return the securities or the monetary value thereof. And Lord, H is disposal of 6. The fact is got entire so he has given them 5 lakhs per investor or whatever. So he's got full monetary relief. Now, one of 2 things. But either he accepts the order or he doesn't. If he doesn't, he is to challenge it. Hasn't done that. Second is, if not, you enforce the order. Nothing mentioned here about what he has done to seek enforcement of the order. Nothing. Now, this order is final. Now, how do you get around this order and come to me? Because there is a finding by the statutory authority and the not exclusion provision under the SEBI Act, which I showed your lordship. But the fact of the matter is that the statutory authorities investigate. It has given me a clean sheet. Now, can you come to court and say no? So, ask respondent number 5 to.
Yes.
But please see that same not the finding of fraud is there against the others. Now, in this suit, what is his case? That I am the brainchild, it is my brainchild, and I am in collusion and conspiracy with SEBI, with stock exchange, with the banks. I am in collusion with everyone, and they've conspired to let me go scot-free. If I have challenged the order, but today the order stares him in the face. He can't get around it. And I'll assume for a second there is no statutory bar. I showed your lordship statutory bar against all of this. The means given is challenge it, challenge it. If you haven't challenged it, it retains finality. But not assume for a second there is nothing like res judicata here. Assume for a second. Does it not mean this? That he needs a much higher burden of proof now. The specialist body has done forensic audit, investigated, gone into everything, but denied people were held. But police has gone into it, economic analysis or economic affairs wing has gone into it, everyone has gone into it. But no one has found me liable.
Yes.
Now, come in, some level of proof. There is none, nothing. And he's gone and got an order of injunction against my bank accounts. Please see the blood justice of it, and that too your lordship will remember. Serve me ex parte order, did not serve me not within any expressing the point, then your lordship said, I'll hear out the matter, why do it now, and all that. But the fact of the matter is, there's been no compliance with order 39. I've made detailed submissions on that earlier.
Yes.
The other point I had made was, my lord, limitation. Now, the limitation that your lordship will find, I think, problem with it. Now, my lord, limitation.
Limitation regarding filing of suit.
Yes. My lord, his knowledge, pleaded in petition page 166, is 1st November 2019. Our barcode, page 166. But before your lordship goes to that, would your lordship once take the cost title?
Cost title of plaint
Yes.
or application? Say.
Just see the array of defendants, they are not important. Defendant number 1 is that broker company, 2, 3 described as directors, 4 director, 5, he says I'm a erstwhile director. Now, how do you make a erstwhile director blood liable? Some pleadings have to be there. Then, my lord, please go on and see the array of parties. Lord, please see JM Financial Products, defendant number 9, Bajaj Finance, HDFC Bank, SEBI. 12 is SEBI, 13 is NSE, 14 is BSE, and so on and so forth. But 18 is CDSL, the depository participant. 19 is National Securities Depository. 20 is Axis Bank. Now, his allegation is that they have sold, some of them have sold the shares without having authority to do so. Now, how can I be involved in that? I can't be involved in wrongful sale of shares by HDFC. So, my lord, in this situation, my lord, please go back to that page. Page one, please see, my lord, page 166, yes. on 6 of the petition, Lord.
Petition.
He has himself annexed it.
Yes, page 67, 66. What is
Is to inform that the exchange by circulars has suspended BMA due to non-compliance of regulatory provisions. Further, it may be noted, SEBI has also passed an interim order against BMA for the aforesaid non-compliances, copy available on the website. So, my lord, he came to know of all this wrongdoing. Your lordship will find the date 1st November 2019. Now, the suit is filed on, just give me a moment, my lord, the suit is filed on sometime around October 2024. 7th October is the verification of the plaint. That's at page 71 of the.
Yes.
So, Lord, the gap of 5 years.
October 24.
Yes. So, Lord, that's a be acta second. The other parts I showed your lordship. I'll just show it just once more, Lord. I showed it. I'm just not. It's been a long time. I'm just rushing through it, so I'll finish.
Oh, yeah.
Well, I'll hand up my copy.
It is there. Section?
Oh, your lordship has 15Y. 15Y. First 15Y. No civil court shall have jurisdiction. I'm sorry. 15 capital Y.
Yes.
No civil court shall have jurisdiction to entertain any suit or proceeding in respect of any matter which an adjudicating officer appointed under the Act or Securities Appellate Tribunal constituted under the Act is empowered by under this Act to determine, and no injunction shall be granted by any court or authority in respect of any action taken in pursuance of the power. Now, therefore, my lord, civil court can't interfere with the order of the investigating authority over here. Now, in addition, my lord, the authority has passed orders. Now, also please see section 20 capital A.
Section
20 capital A. Bar of jurisdiction. No order passed by the board under this act shall be appealable except as provided in 15T or section 20, and no civil court shall have jurisdiction in respect of any matter which the board is empowered under this act to pass, etc., and no injunction. Now, my lord, given this, if your lordship cannot touch this order, these 3 orders or whatever, but argumentatively, then, my lord, if this finding stands, your lordship can scarcely in this matter come to or arrive at any of the findings that my learned friend looks for, even if there had been evidence. Here there is none. 3 documents that he relies on, I'll distinguish in a moment. Now, my lord, also see a very long X. No? Every section has got A. Yeah. Now, now, my lord, Section 11(1). Subject to the provisions of this Act, it shall be the duty of the board to protect the interests of investors in securities and to promote development and regulate the stock market by taking such measures as it takes things fit. So that power is there to not take whatever action it has done. So, not those orders have reached finality. It was for that. Then, my lord, 11(2), your lordship sees. Not it can take various measures. Not I'm not going through all of this. And in exercise of those powers, it has directed certain people to pay. Not whole lot of powers given over there, including, my lord, your lordship will find the power to direct audit. That is 11 subsection 2(I).
Print.
Coming there last. Praise up. Give me the praise from the print. Lord, the praise, the plain praise are set out at page 61.
Correct.
Alright. Now, Lord, please see prayer A doesn't affect me. Prayer B doesn't affect me. Now, please see prayer C. He is asking for a money sum against everyone jointly and severally.
So that's why I'm asking, but why the suit is not maintainable here?
Lord, because he already got the relief. They not the principal people. Not, let's put it this way. But SEBI has investigated, found defendant numbers 1, 2, 3 guilty. It has asked them to pay this money. He has got a decree against 1, 2, 3. I'm calling it a decree. It's not a decree, but I'm just calling it decree. He's got a decree against 1, 2, 3 with a finding that I'm not liable. It's the same relief that he's asking for here. And he says 29 crores, although I'll show your lordship from his pleadings that the loss suffered by him was 9. I'll give your lordship those figures. Then, my lord, please also see F and G. He's also asking for return of the securities. Now, if those securities are returned, can he have double blood relief? He wants the money and return of the shares held by the other defendants. If he gets his shares back today, there is no question of money decree. Pleadingটা বার করো যেটা আসল
Yes.
But please also in this connection have a look at petition para 8.
Petition.
Para 8. Just one more para, he's made a chart there, para 8.
Yes.
And he has said this is the value of his investments on 30th August 2019.
Correct.
Total value is 9 crore 92.
Correct.
Then he says he has received some money from the Investor Protection Fund. I'll just give you a lordship that. And he knows of all these SEBI orders, he's pleaded them in his plaint and he's annexed them. That's where I showed it from. Now, just give me a moment. I'll just give you a lordship that para where he says he has got return of the money. Part of it. Yeah, just pull it out. No, I won't waste your lordship's time. My junior will pull it out. In the meantime, Lord, may I just finish with it? Not section 15(2), 2 sections left of the SEBI Act. 15(2). 15T,
15?
capital T.
Appeal.
15 Yes, appeal. Seva is provided in subsection to any person aggrieved. Now mark the words, not any person. Any person aggrieved by an order made by the board, etc., may prefer an appeal. So anyone aggrieved can file an appeal. He could well have challenged these orders. He hasn't. We got the amount. Tell me. But SEBI has taken action in the interest of the, I've showed your lordship the of all these people. It has done so. The order have come. He's unhappy. He should have challenged it. The Supreme Court is not the right place to do it. And what the amounts that he has got are mentioned in para 55.
Para 55 of AO.
Yes, but petition.
Of there.
Page 58. Petitioners have also lodged their claims with the respondent 14 in respect of the fraudulent actions of the respondent number 1 by an email of so-and-so, respondent number 4, 14 intimated petitioner number 1, IPF trustees have approved payment of compensation of 9,99,000 as against a claimed amount of 10 lakhs as against petitioner number 2, so-and-so, so-and-so, so-and-so. So, he's got back some money, but this is from the fund. This is from the investor protection fund. In addition, he has got the relief of defendant numbers 1, 2, 3 to not return this. In addition, in the plaint, he has made a prayer that the pledges. So, one hand, he's got a decree from the pledgers, and on the other hand, he is seeking a decree in this court against the pledgee, saying you have wrongfully gotten rid of these shares. So, and the last section, which is not material over here, your lordship sees, this is the section which he had relied on for jurisdiction. No, not 20. Oh shit. Yeah, got it. No. Yeah. Where a contravention of any of the provisions. It's 27. Sorry, I forgot to tell you.
Yes.
Where a contravention of any of the provisions of this Act or any rule, regulation, direction, or order made thereunder has been committed by a company, every person who at the time of the contravention was committed in charge of and was responsible to the company for the conduct of the business as the company as well as the company shall be deemed to be guilty and shall be liable to be proceeded with. So now he falls within this deeming clause. Now, look at the words, every person who at the time of the contravention. The contravention took place after it had gone away, I can't be liable under this.
That is sad.
And even otherwise, how, in what way, Lord, please see.
Yes.
This will apply, my lord. Now, Lord, looking at 27, where, Lord, there is contravention of any provision of the Act or rule regulation made under it. Now, my learned friend will then have to point out that I am guilty of, Lord,
which provision?
He has not done that first. If he had, but if he does, then he has to proceed against under the provisions of the Act. He can't get out of it. He can't on the one hand say, I want to proceed under the Act, on the other hand say, no, I will file a civil suit. Because there is a bar of a civil suit. civil suit is barred. So he will have to have his remedies under this act, for which the authority is provided, and he has been given relief. Now, but the point is, can he not jump over that? He's got to cross blood one moat and one hurdle. One is bar of civil court's jurisdiction, the other is not appellate remedy. Now, if he gets around it, not his right of action is where.
Yes.
Having got that relief, because blood, the SEBI has directed in its final order that someone is to pay the full amount. Return the shares, return the money, pay up. This is the order. Now, it's not my learned friend's case that he is dissatisfied with it. So why is he not seeking to enforce the order against the persons against whom it has been passed? It's not something which is very clear to me. He has the relief. He does not go after them. He doesn't try to recover it. Instead, maybe they don't have the money. Maybe. But will that give you the right to proceed? This is the point I'm on.
That's what their case is, that the respondent number 5 is been left out by the SEBI, so respondent number 5 is liable for the same. This is the case.
Now, can he get around all these sections I've showed your lordship?
Correct. Now, that's why you are raising the question, even though if it is said and they are not satisfied with the observation or order of the SEBI, there is other provisions.
Not just that. I say first, you have got relief. 2, you have not challenged the order.
Correct.
Although statutory remedy is there, appeal remedy is there. I've showed that to your lordship.
Yes.
3rd, there is a bar to a civil suit. Now, given that, 4th point which he has to circumvent then is, how do you get rid of this finding which is over there that I am not guilty?
That's why
So, I'll assume he can cross all of this at the final hearing of the suit. I'll assume that. At the moment, there is nothing. Now, the point is this enough to simply say that he is the brain behind it? Or do you need to show something much heavier now that there is a positive
what is the injunction against you?
Restraining me from not operating my bank accounts. Please see the order. 8th of November. 8th November. Yeah.
Injunction restraining the respondent number 1 to 8, dealing with and disposing of okay. Period D.
I'm affected fully.
They don't show that SEBI had examined.
But at the time they obtained the order, was it not required for them to show your lordship that the SEBI had refused to pass anything against me? That the finding was against?
They have not disclosed. Their case is they have made out the intentionally the SEBI has left out this two persons.
No, please see the order.
That is the case.
No, that's the case.
Yes.
But that's not the case on the basis of which interim order has been obtained. Please have a look. Please have a look at the ex parte order once. Please have a look.
ये order होता है. Order dated
8.
Yes.
Now, I'll just take your lordship to that order once. Maybe I'm wrong, but your lordship will see. 1, 2, 3. Is all the background. What had happened, shares blocked. Then, para 4, final order. Then, forensic audit that's mentioned in para 4. Then, Arindam Banerjee, learned advocate, represents the plaintiff, submits the allegation of involvement of 5 and 6 on examination of material available on record, but defendant number 12 decided not to proceed against defendant number 5 as they are not made notices. He submits that no step has been taken against them against the defendant numbers 5 and 6 who are very much instrumental in commencing and establishing the practice of misutilization of client securities, particularly the defendant number 5, who was the director of the defendant number 1. He submits that the defendants are in collusion, and Millard, he says that 1 to 8 and 15 to 17 have committed fraud in collusion with each other. Then, Millard, please see the rest of it. Where is this evidence against me? Simply saying that I am in connivance will entitle him to an order against my assets. This is the point. Please see, Millard. His claim sounds damaging, Millard. He said he lost 9 crores. He got back, let's say, 50 lakhs or 60 lakhs. His claim in the suit is not 23 crores. You got an injunction against me on that value. Both commentary হচ্ছে না Now, Millard, please see para 12. This seems to be the basis of the order against me. Para 12. The defendant number 13, without assigning, decided not to proceed with 5 and 6. But it is found that 5 and 6 are equally liable. This is the finding. Now, number 1, it conducted a forensic audit and found me not guilty. That's probably not shown, I take it. Number 2, but it is found that 5 and 6 are also equally liable. How can I be equally liable if I've ceased to be a shareholder and a director long before this happened? And when you find SEBI has filed an affidavit in the Gujarat High Court saying I have no involvement. I've showed your lordship this. Extra material down. So, Millard, today, this is the only material against me.
Yes.
Para 12 is the only reason that I could find that they have proceeded. Now, if defendant number 13 has done it without assigning any reason, challenge the order. It can't be challenged in this court.
Yes.
And Millard, one last thing. Actually, tell me something. No, you're asking her.
Yes.
You aren't asking me. And Millard, now, the things, Millard, the documents on which.
How much time?
3 minutes.
Proverbial 3 minutes.
3 minutes. Kon proverbial about 3 minutes?
There have been 5 amendments to the SEBI Act during the submissions.
But my learned friend has got some connection with SEBI, which I don't know of, and he's accusing me of colluding with them.
Some people have it on record, some have it off.
Document gulo bar koro na baba. 446 hai.
And has it on record.
446. But now 3 documents that he showed. I'll just page 446. Oh, Millard, I hadn't realized. I'm very sorry, Millard. I hadn't realized.
15 minutes, those were not his submissions. Kindly consider it to be part of my advance reply.
Give me 5 minutes on the next day. 5 minutes. Key code boy. I hadn't realized it was 442. I really thought. Millard, he has eyes at the back of his head. Millard, but I don't, so I couldn't see the.
আমি ফার্স্টে ভয় পেয়ে
তুমি এত কথা বলে গেছো
4 and 5 and 6 5 only.
Mr. Thakkar, I believe,
senior advocate appearing for the respondent number 5 has argued the matter at then, but due to paucity of time, hearing could not be completed.
এত কিছু বললে, why did you tell me?
দুটাই লক্ষ্য করিনি। না, fix नहीं है ना। हाँ, बेहतरी बन। 2 दे दो। अगस्त में चले कब 3 पर
नोट कर अरे छोड़ देना यार
27 28 of July at 3:45 p.m. interim order is extended till the next date of the hearing.
A few more days, only few more days beyond, just in case.
till 4th of August 2020.
Obliged, your
Or
Lord.
until further order, whichever is being sent. Okay.
In the meantime, the interim order is vacated.